I'd like to call to order this regular meeting of the Lincoln-Lancaster County Planning Commission of June 10th, 2020. A printed agenda is available outside the hearing room, and a copy of the full agenda, including the staff reports, is available at the front of the chambers with the clerk. The Open Meetings Act is posted just inside the doors at the back of the room. In order to meet the required social distancing protocols, we must limit the number of people inside the chambers. Staff is assisting individuals who are present and wish to testify on items on today's agenda by ensuring that each person has signed in. Staff will direct you into the chambers based on what items you are testifying on and your position on that item. Please note we will only bring those attendees into the chambers for the agenda item they are interested in when that hearing begins. We are requiring attendees in the chambers to sit in a socially distanced manner 6 feet apart from other people not in your immediate group. If there are more than 25 people attending for a particular agenda item, staff will bring additional attendees into the chamber as people testify and then leave the chambers. Once you have testified, you should exit the chambers using the doors to the right, and then the next testifier can come to the microphone and begin testifying. In addition, for the added protection of all those involved, the Planning Commission will be allowing testimony on agenda items by video conference for individuals who pre-registered with the Planning Department prior to today's hearing. This testimony will be taken following the completion of the live testimony for each item based on position. Based on estimations, we are staggering the times of various hearings over several hours. These times are identified in parentheses on the agenda. We are encouraging attendees to arrive no more than 15 minutes before their scheduled hearing. Please note that an agenda item will not begin before the time posted. In the event that the allocated hearing times go quicker than estimated, there will be breaks in the hearing. If you parked in the parking garage across the street to the north, the gate is open and no parking coupons are needed. Out of courtesy for those attending this meeting, commissioners, and the staff, cellular phone usage is not permitted in these chambers during any portion of this meeting. We appreciate your cooperation. Please note the Planning Commission action today is final on the following agenda items. 1.3C, Preliminary Plat 20003, 4.1, County Special Permit 20015, 4.2, Special Permit 20013, 4.4, Special Permit 20016, and 4.5, Special Permit 20005. Any aggrieved person may appeal final action of the Planning Commission to the City Council or the County Board by filing a notice of appeal with the clerk within 14 days following the action of the Planning Commission. The Planning Commission action on all other items is a recommendation to the City Council or County Board. The first item of business is approval of the minutes of the regular meeting held May 27th, 2020. Is there a motion?
So moved. Campbell.
Second, Shear.
Jerry?
Okay, Albadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Shear?
Yes.
Core?
Yes.
Motion carried 6-0.
The next item of business is the consent agenda. Items on the consent agenda will be called at the same time and will not be scheduled for a separate public hearing unless there is a request from someone wishing to speak or at the request of a commission member. I will ask Jerry to read all of the consent agenda items into the record. Once those items are read, she will ask if there is anyone wishing to speak. If you wish to speak on an item on the consent agenda, we would ask that you stand and state that item. That item will then be removed from the consent agenda and scheduled as a separate public hearing under Section 3 of today's agenda. All items remaining on the consent agenda will be voted upon in total with a motion for approval. Jerry, will you please call the items on the consent agenda?
Thank you. Item 1.1 is Comprehensive Plan Conformance 20007 to review as to conformance with the 2040 Lincoln-Lancaster County Comprehensive Plan, a proposed amendment to the Antelope Valley redevelopment plan that adds the Gorilla Flats redevelopment project. I will note that the applicant has submitted a project name change to this proposal to 2236 R Street project. This project is generally located at 2226 R Street. There is an associated change of zone 08066B to change from R6 residential district to R6 planned unit development to add additional residential area with waivers as part of the expansion of the Antelope Village PUD. again located at North 23rd and R Streets. Item 1.2 is comprehensive plan conformance 20008 to review as to conformance with the 2040 Lincoln Lancaster County Comprehensive Plan. A proposed amendment to the Lincoln Center redevelopment plan to add the Block 65 redevelopment project as a new project area to include a approximately 15-story mixed-use residential building, the rehabilitation of the existing Sharp building, and a new public parking garage with ground floor active space on property generally located at 200 and 206 South 13th Street and 1318 and 1340 M Street between 13th and 14th Streets and M Streets. Item 1.3A is annexation 20010 to annex approximately 161 acres. The associated change of zone is 20018 from AG Agricultural District to P Public District. And the associated preliminary plat 20003 to add one lot for a public high school, all generally located at South 70th Street and Saltillo Road. Again, this is final action on preliminary plat 20003 unless appealed within 14 days to the City Council. Item 1.4 is change of zone 20016 from AG Agricultural to R3 Residential on property generally located at South 27th to South 40th Street and Rokeby Road to Yankee Hill Road. Are there any ex parte communications to be disclosed on these items?
I don't see any.
Are there any ex parte communications that took place or additional information you learned while visiting any of these sites?
It doesn't look like it.
Is there anyone here wishing to speak on any of these consent agenda items? If so, please stand and state that item or inform staff.
Okay, doesn't look like there is anybody here, so I would entertain a motion.
I would move approval of the consent agenda.
Second.
Jerry?
I'm sorry, was that Edgerton?
Either one of us.
Okay, I'll just say Edgerton. Okay. Elvadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Shear?
Yes.
Core?
Yes.
Motion carried 6-0.
Oh, sorry, I was waiting for Jerry to read this. I don't know why. There are no requests for deferral, so we will now proceed to public hearings. The staff will make a brief presentation. The applicant will then be requested to present his or her testimony, followed by those who wish to testify in support, followed by those who wish to testify in opposition. The staff will then be given an opportunity to respond to the testimony, and then the applicant shall have an opportunity for rebuttal. If, during your testimony, you have copies of documents or materials you would like distributed to the Planning Commission members and/or included as part of the record, please provide that information to the clerk for distribution. Each person testifying should state their name and address and shall have 5 minutes to speak unless additional time is requested and granted. The timer will go off after 4 minutes, then you will have 1 minute to wrap up your testimony. The Planning Commission will vote immediately at the close of the public hearing unless the Commission votes to defer action or continue the public hearing. Jerry, will you please call the first public hearing item?
Yes, thank you. 4.1 is special permit 20015 to allow for an accessory dwelling unit with associated waivers on property generally located at 1950 Southwest 112th Street. Staff recommendation is for denial. This is final action on this item unless appealed to the city or the county clerk within 14 days. Are there any ex parte communications to be disclosed?
Doesn't look like it.
Are there any ex parte communications that took place or additional information you learned while visiting this site?
No.
Okay.
All right, Mr. Chaka.
Good afternoon, Tom Chaka, planning staff. So this application is for a special permit for an accessory dwelling unit. The property is located on Southwest 112th Street between A and Van Dorn. That comes up here. So the lot in question is this one. The lot is about approximately 22 acres and was created in 1997 by survey. The parent tract at the time was about 33 acres. At the time before the survey, this lot and this lot here were one large lot, and then this was surveyed off with an existing house on it. The existing house was built, according to the assessor's website, the principal house was built in 1998, and the accessory dwelling, or the second house, was built shortly after, either later 1998 or 1999. Research with Building and Safety Department, we could not find any building permits for either house. However, at the time the principal house was built, building permits were not required on houses if they were over 20 acres. The zoning code allows one house per 20 acres, so the lot is, would have been allowed for only one dwelling. This situation arose a couple of years ago, first came to light. There was a question about the use of the, I'm just gonna call it accessory dwelling, of the accessory dwelling. At the time, in November of 2017, the owner, the Ashoffs, entered into an agreement with the county saying that they would not use the ADU as a dwelling. And then they renewed that agreement in May of 2018, again saying it would not be used as a dwelling, while they looked for a solution to the problem. So accessory dwelling units were then added to the county zoning regulations in December of 2018. So they have now came forward to request this application for the ADU. The applicant is requesting 3 waivers with this special permit. 2 of them are minor. One of the rules is that you have to meet the setbacks of the district. Because this lot doesn't front on a street, the street is over here. So all of these lot lines are considered side yard setbacks. The side yard setback is 60 feet in AG district, and the ADU is built at 53 feet off the lot line. Another waiver, or another regulation of the ADU is that the ADU shall not be closer to the street than the principal dwelling or be more than 200 feet from the principal dwelling. This one is 251 feet from the principal dwelling, and like I said, it doesn't front on a street, so the other one really, I don't think is applicable. The main waiver is the size of the ADU. The regulations state that the ADU may be the smaller of 1,000 square feet or 40% of the principal dwelling. Also, when we're figuring the square footage of an ADU, if you have a basement, the basement is included within the floor area, except for a mechanical room. This ADU, when you include the basement finished area, is 1,640 square feet, which is roughly about a 60% increase over the 1,000 square feet. However, it is only about 25% of the principal dwelling, but it's not a either or, it's the lesser of the two. An alternative proposed to an ADU would be to do a community unit plan, which would require both the lot in question and the lot to the north. My understanding is that both lots are owned by the same person. With a community unit plan, it would allow each house to be on its own separate lot and enable them to be sold off in the future if need be. this ADU, we don't feel is in conformance with the intent of the regulations and of what is the principle of an ADU. Okay. The size is quite larger than what was developed and approved by the task force and eventually by the county board. With that, I'll take any questions.
Tom, I was a little confused when I was reviewing this at the map with regard to the buildings that were being discussed.
I'm sorry, the buildings that were what?
With regard to the existing accessory, the existing main residence, and then there's another existing building on the site, and I really need some clarification as to
Sure.
what's in play here.
Zoom in on this. So the existing principal dwelling is here. The accessory dwelling is here, and this is a large accessory building that was, I believe, built fairly recently, maybe within the last year.
But it's not a dwelling unit?
No,
Okay.
we're
Okay.
here.
We're
to
talking
talk
about this,
one.
the one to the south?
Yes.
Okay. Thank you.
Tracy?
Yeah, go ahead.
Can I interrupt for a second? They're working on the fire alarm system downstairs, so there may intermittently be little beeps and alarms. There's no reason to get alarmed. If it is a serious fire alarm, we'll come get you out.
Thank you.
Thanks. What is that accessory dwelling unit being used for now? Anything? Or is it just sitting empty?
I believe you'll have to ask the owner applicant on that. I'm not sure. It may just be being used for storage right now.
So can you remind me if as you propose, a possible solution would be to do a CUP, how that works in terms of both. Can you just walk through that a little bit, that process with me, please?
Well, the CUP or community unit plan would of course require a different application. Minimum area of 75 acres. Basically 75 acres would get you probably 5 lots, single-family lots. They would have to show, a site plan, a layout of where those lots would be and where a road. It would take probably, it would be a street coming off of West A Street because the lot to the north goes all the way to West A Street.
Got it. But for clarification in the record, it's okay, it's appropriate for a CUP if the residences or the dwellings are on one part of the property, even though that in itself is just 20 acres versus the entire 75.
No. If this was included in a community unit plan, it would be broken down into probably smaller lots. It wouldn't be both houses on 20 acres. They would put the principal house and the ADU on their own separate lot. There's not really a limit to how large they can be, but they would have to be a minimum of 3 acres in size.
Got it. Thank you.
Tom, if they went for a CUP, would they be able to still maintain the ag zoning classification?
It would still be ag zoning
Okay,
district.
so tax-wise, it should not make any difference.
I'm not aware of what the tax implications would be. I am going to walk back my statement on the maximum size. Under a CUP, 70% of the total area has to remain in an outlot, unbuildable, so there would be a limit to the size of the lots.
Other questions for
And so on the current building that they're wanting to be an ADU, that footprint on the main level is 824? Is that what I read?
Yeah, I think it's pretty much split between the basement and the main level.
Okay.
I think it's 864.
And what?
I think it's 864.
64. Okay.
I'm looking at this aerial, and it looks right now that they're taking access from the corner lot that's not part of this application. Is that?
Right, and yes, they take access off of this driveway.
And they don't own that section anymore, that?
No, but
Parcel.
there's an easement over it.
Okay. All right. Any other questions for Tom right now? Okay. Applicant.
Afternoon. My name's Timothy Ashoff, A-S-C-H-O-F-F. My wife, Linda, and I are owners of the property as well as residents there. Couple things. We purchased this property in 2013, so the existing house and the ADU were there at the time. We were told it is legal at the time, and it is actually, I think there's a dispute with staff as to whether or not it is legal at the time or not. At the time it was built, the prior owners had built it. They had represented that they had it properly built legally at the time. Mark Hunziker represented them, and he's here as well and will testify to that in a moment. And I also spoke to the neighbor. The neighbor that adjoins the property is the same neighbor. He was there at the time. And speaking with him, he told me that when it was being built, he asked his attorney, hey, is that legal? And he was informed, yes, it was legal at the time as well. So what brought rise to this is my wife and I did build the other accessory dwelling unit that you referred to before, and we came in to get a building permit for that because it's an ag building, but part of it I have a rec room, a restroom, and some other things. So to be safe, I came in for a building permit to do that. At that time, staff had indicated they felt the accessory dwelling unit was not legal. I worked with Mr. Hunziker, we worked with the county, and there was just it was unknown, some dispute as to that at the time as whether it was legal or not. So what we agreed to at the time, as the first agreement referenced was, is that while in order to get the building permit for that building, we would agree that while that building was being built, we would not use the accessory dwelling unit as a residence for a period of 1 year. And in that agreement, it also states that essentially after that 1 year, we go back to status quo. We can assert that it's legal, and the county can say we don't know whether it is or not. And during that, it was also anticipated that this ordinance would be passed and that we'd have the ability then to come in, as we are today, in order to get a special permit to do this, rather than fight about whether it was legal back in 1999 when it was built or not. So that's why we're here today. A second agreement was referenced about that we permanently agreed to not use that as a residence. That's incorrect. Staff mistakenly is looking at an agreement that was entered into for the other building that was built, because when I went in to get the building permit, because I had a bathroom, a rec room, and some counter space, they wanted to ensure we wouldn't use that as a dwelling. And I think that's the point you were making is that which building is referenced by which agreement. That second agreement where I agreed to permanently not use it for a residence is for the barn, the accessory dwelling unit, and does not apply to this accessory dwelling unit. So those are separate agreements for separate buildings. And that initial agreement not to use it for 1 year expired at the end of that 1 year. And so here we are today, I do respectfully request the waiver. There are 3 waivers. They are all allowed by the ordinance, as mentioned. The 2 are minor. Staff doesn't have any opposition to that. Again, they were built. It was built in 1999, so without knowledge of certainly what these restrictions would be in the ordinance with respect to setback from the property line, as well as distance from the main house. There is a slough between the 2 houses, so to get it closer to the main house would be difficult as well. So the waiver, I think, at issue really remains to be the size. And I guess I would contend that the size does fall within the intent of the ordinance as well as the comprehensive plan. The comprehensive plan talks about size as being secondary to the main dwelling. Staff acknowledges that this house is secondary to the main dwelling. It's 25% or less of the main dwelling. And really the issue here is that it's a very small structure. It is only 824 square feet on the main level. It has a full basement underneath it. That gets you to the 1648, 1650. Part of the basement is unfinished. Part of it is a mechanical room, so we are technically under the 1650. But you can see the dwelling itself is essentially the size of a 3-car garage. The main footprint of that is very small. It's within the 824 feet. It's clearly visually secondary to the main dwelling. The way it lays out, there's no street frontage, so other people wouldn't view it as an independent dwelling. And certainly my neighbors, one of which is here today, had no concern with the size or the use or the understanding of it as a secondary dwelling. And the other neighbor that is adjoining to the property, that was the one who informed me that it was legal at the time, I spoke with him, and he's also was actually surprised I had to be here for this today, so had no opposition. So I think staff has acknowledged that it meets the intent. And certainly if the intent was for only buildings to be up to 1,000 feet be allowed, then there wouldn't be the ability for a waiver, because the ordinance does restrict other waivers. So if they didn't want to allow you to give a waiver over 1,000 feet, they would have restricted that as well. So I think the clear intent of the statute is if it's a secondary dwelling, it is allowed to be given a waiver. There was some discussion here about the ability to do a community unit development plan. I was fortunate to be able to buy that property next to the current property that my wife and I have. And the reason I was fortunate is because the prior owner was going to sell it to a developer. And he did give me an opportunity to buy it before that. We don't want to develop the property. We want to live out in an agricultural area. My neighbors don't want us to develop the property. When the sign went up saying there's a zoning action, they were concerned that I was going out there to be able to build more lots, to divide the property in a community unit development plan. And so that is not the intent. There's a lot of expense to that. You heard them indicate that I'm going to have to go through another permitting process. I would have to divide the properties. The property does comport with the ordinance in that it has common utilities. So I have common sewer, common water, common power, and even share a common propane tank out there. I would have to divide that under the community unit plan or come up with some exceptions, because my understanding is they have to have separate utilities for a community unit development plan. I'd also have to build or allow access for a road over to A Street through my pasture. I don't want a road over to A Street. I want that as a pasture. I want that to be able to continue that. I'm not concerned about a future buyer. That seems to be what staff is concerned about, is if someone wanted to buy those houses as two separate houses or develop the property in the future. That's not my intent. And I think as the landowner, I have the right to say I can end up selling the property as one property in the future and not be concerned about if a buyer wants to buy it as two separate properties. I would take that hit on market value in that case. You know, it's been costly to get to this point. I had to get survey drawings to provide this permit, this application certification of the house size, pay almost $1,000 for this special permit to be here today. To go through that community unit development plan process would be, my estimations, over $10,000, and then I would have some time requirements to do some things to complete, may have to separate utilities, and really do feel that that is not an alternative when we have right before us clearly an ordinance that contemplates this. It's in compliance with the comprehensive plan, and the waivers I am asking for, I believe, are reasonable. They don't create a health issue, they don't create a safety issue, and so I would respectfully request that you grant the waivers and the special permit.
Can you tell me, since you've bought the property, what have you been using the accessory dwelling unit for?
Essentially, we bought the property contemplating that our parents would live there someday. I have a parent, we both have parents in our late 70s and early 80s, and when they got to the point where they were not independent, they would come and live there, which if you look at the comprehensive plan, that's exactly what accessory dwelling units are designed for. So we've been holding it for that. We use it as a guest house. Sometimes when my parents or my wife's parents have come, they've stayed there. But other than that, it's just been an unoccupied guest house, accessory dwelling unit. We've had some friends stay there for a couple weeks when they were having repairs done in their homes and those types of things, but not permanent residents.
The new barn that you
Yes.
constructed,
Mhm.
is that finished
It's
now?
completely finished, yes.
Okay.
Yep.
And that has it has a recreational function.
I have cattle, I have chickens, and I have kids, so I have a multi-purpose barn. So yeah, I have a multiple use barn, so, yes.
And if I understand then, based on your explanation, which was really helpful to kind of clarify the two different buildings, this came to light because of that building permit. Is that
Yes,
correct?
so the county has known about this because it's been on the tax rolls as a resident since 1999. And even when I purchased the property, I took note of that and understood it because I was, again, represented that it was legal at the time. And so I was very surprised when I came to get a building permit and they denied it because they said there was this non-conforming use on the property. Again, that's when I went back to the prior owner, who was represented by Mr. Hunziker. He had worked with staff and I believe the county attorney at that time, going, yeah, this is kind of a unknown situation, and so let's just go ahead and come up with a way to issue the building permit, which was us agreeing to not use the house as a dwelling for that time period, which essentially the building permit would be issued. And then we'd go back to the status quo because at the time the discussion was, and Mr. Hunziker can speak better to it than I was, that the city and county were going to do this very ordinance. And rather than go back and try to figure out what happened in 1999, let's get the ordinance done, and then let's come file for this permit as I'm here today and move forward. And so, that's where we're at. I could have come in probably a little earlier. I know the ordinance was completed back in 2018, just got to where we are today. I know staff did indicate they were a little bit concerned in their report that if you granted this exception, that this would open a door to many other exempt requests for waivers. But I think the staff also said that since December 2018, this is the only second request for this. So I think the time period shows that that isn't the case. And I also would think it's unique that you're probably not going to see too many cases where you have a building that was there since 1999 and somebody coming in for a request. I think it'd be more for new construction, and certainly I would hope you'd see the circumstances differently in that case.
Does it say that the basement is unfinished currently?
The basement is partially finished.
Partially
Yes,
finished?
yeah, it does
Is it a
have-
walkout or just a?
It has a walkout.
It has a
yeah.
walkout,
Yeah, it's
okay.
the single door walkout.
Okay.
One side is open, yep. But again, the footprint is 820 square feet, and I think, again, in comparison to the size of the main dwelling, it's not only secondary from a size standpoint, but also from a visual standpoint. It's essentially, as I showed before, almost, if it didn't have a basement, I think you'd call them a patio house. It's essentially, a nice little dwelling.
I know that you kind of explained why you didn't go the CUP route or why you don't want to go the CUP route, but what made you go the ADU route instead of the CUP route from the beginning?
Well, first of all, from the beginning, I wasn't really looking to do anything. I was thought it to be legal, and there is even Mr. Hunziker can maybe explain this better, but there is a notion that I wouldn't have to do anything because it still is legal, because it was legal in 1999 and would be grandfathered in prior to the ordinance. I'm just here to just clarify this. I've been upfront with everything throughout this process. Again, as I mentioned, when I went in to do the barn, it's ag. I maybe not even needed a building permit as I understood, but let's go in and do it. Once I found out about this, I said, okay, I just want to clear this up. I don't want to be here or my children be here or whatever when I pass away and we're no longer on that and there still be an issue. So I just would like to get that cleared up. I think for this purposes, this is a straightforward way to do it. It is allowed under the ordinance. So to do a development plan when I'm not planning on developing it, obviously I think I would get some opposition from those in the neighboring area, and there'd be a lot of requirements that just don't apply to what I'm intending to do here.
Any other questions for the applicant right now? Okay.
All right. Thank you very much.
Thank you.
Testimony and support.
Madam Chair, members of the Planning Commission, I'm Mark Hunziker, appearing on behalf of Tim Ashoff. This is really unique. This is the only time in 43 years of practicing land use law in this city that I have ever seen an application and the record of its hearings and disposition just disappear. We had hearings on that particular house. We had a neighbor who came and still is there, who remembers coming and opposing that application. I don't know what happened to it. Nobody in planning claims to remember it. But they seem, and they can't find anything on it. But there are at least 3 of us who distinctly remember being in this chamber, not once but twice, Planning Commission and County Board, dealing with the issue of whether or not that house could be constructed. Now, at the time, I think the terminology that would have applied to it would have been a caretaker residence. But we seem unable to find any record of that application. So we're here, at least in my opinion, in part because of a failure of our record-keeping system. But secondly, when the issue arose when Tim went in for the building permit for the barn, we ended up in front of the county board with a clear we had a disagreement with the county attorney, although the county attorney wasn't adamant that he was certain that this was an illegal building. I was adamant that I was pretty sure it was legal. And so when we did the agreement that was referred to between the Ashoffs and the county with respect to that building, we used language which was very clearly designed not to admit that there would be that there was any illegality about this building. The paragraph 5 of that agreement says both parties acknowledge that during the term of this agreement, owners intend to pursue a text amendment to the county zoning resolution, which would expressly permit the accessory building to be used as a dwelling unit, but that if such text amendment is not approved by the County Board of Commissioners, such use could be construed by the county to be a violation of the zoning resolution, and the county may take remedial action to enforce compliance. Owners reserve the right to contest such an interpretation and alleged violation of the zoning resolution. So it was clearly out there that we neither admitted that it was illegal, and the county didn't insist on language that said it was in that agreement. So we went to this task force to come up with an accessory dwelling unit process. And I have to say the planning department wasn't really wild about it in the AG districts. They liked the idea in the city because that increases density where presumably we want to increase density. They didn't like it at all in the county because it increased density in areas where they don't want to increase density. Understandable, but it also resulted in some fairly restrictive terminology in the ordinance that was ultimately adopted. And through that process, some of you were on the commission when it came through. We argued at that time, number one, the size is too small. We ought to be able to have bigger accessory dwelling units. Number two, the spacing issue shouldn't be rigid. Number three, the setback issue should not be rigid. All these things are somewhat site dependent. I mean, the location of the accessory dwelling on the site depends a lot on where you have your septic system and those kinds of things. And the spacing is also very much determined by those things. And so the response to each and every one of those concerns by the staff was, don't worry, we have a waiver provision. And we said, well, okay. But during that entire time, of course, they knew about this house. They knew that one of the reasons I was at the hearing was we had this little house out here, and it wasn't going to fit all of the regulations that were being adopted at the time. And again, it was, don't worry, we have waiver provisions. So we're here asking for the waivers, and it seems to me that it's clear that the language of the comprehensive plan is very consistent with this application. If you look at the second page of your staff report, where it has key quotes from the 2040 comprehensive plan, you can read through every single one of those and not find a single word that is inconsistent with approval of this project, with this little house. it fits perfectly. So, again, we're only the second application under this ordinance. I mean, there was some concern, again, by making these regulations too easy to adhere to, that there would be just too many of them coming in. And in almost 2 years, this is the second one, and it's a pre-existing building. This little house is not causing any harm to the health, safety, and welfare of the county. It fits quite well within the intent of the regulations and the comprehensive plan, and it's clearly secondary to the main house. I mean, it's an 824 square foot footprint compared with a 6,600 square foot house. We have shared utilities, shared access, and we will have to agree to a deed restriction that makes sure that those two stay together unless we go through a process of a community unit plan. And the community unit plan is no small task. It would require another survey. It would require an application fee of about $1,200. It would require engineering work for a grading and drainage plan. It would require street design work and street construction to gain access to the main house from A Street. And it would require separation of the utilities at a minimum. That's an expensive project for something that changes absolutely nothing in terms of what's on the ground. Again, this little house isn't hurting anything. It hasn't for 20 years. And I would just suggest to you that in the words of those great philosophers, Lennon and McCartney, let it be.
Any questions for Mr. Hunziker? I do have one. Were you on the ADU committee?
No, I was not.
Thank you.
We tried to comment, but we were not on the committee. Thank you.
Testimony in support of this application.
Madam Chair, my name is Dan Klein. I've been a builder developer in this community for 29 years. And I live next to Tim and his family at 1960 Southwest 112th. I'm a farm kid at heart. I spent a lot of years growing and learning and becoming everything from a welder to a stock raiser to harvesting to rebuilding engines. The opportunity to be able to be next door to Tim and Linda has been a delight for my wife and I. We have been out there since before this accessory building was built or the main house was built out there. I built that for my mother, who was wanting to be back in the country again. She lived in town here in Lincoln here. We moved her from Michigan. And so we built that little place for her, so it's right next door, so we could care for her, which increasingly became more and more time to do that. We had some other caregivers come in because at the time my wife and I both worked. It's been a delight to be able to have it there. And I appreciate Tim and Linda as neighbors and understand the process that they have been through. The one question that was asked regarding the driveway, that's part on our property that we have an easement for Tim and his family and friends to be able to use, and that is not a problem. I know how to grade the driveway, and so does Tim. And we've taken that real well, both summer and winter. I can understand Tim's not wanting to develop a community unit plan out there. My wife was adamant when we bought the property from the Stewarts initially that we would not. She says, I want to see deer and turkeys and fox and the rest of the natural community of wildlife. And so that was our original plan when we moved out there. And by the way, my wife and I have lived out there for 25 years. So I'm in full compliant appreciation for what Tim and Linda want to do, and would encourage you to vote these waivers, which are small in nature and certainly accommodating within the ordinance as it was developed here just a couple of years ago. Any questions?
I don't see any. Thank you.
Thank you.
Other testimony and support. Okay, testimony in opposition. Any testimony in opposition? Okay, staff questions.
Yes.
Too many accessories?
Yes.
As the accessory dwelling unit was set up for the county, you're counting the basement as square footage. If I were to own that house and sell it, the basement would not be counted for square footage. It would only be the upper floors, first or second, or, both. And the basic square footage doesn't count in the square footage of that house. So how did it come about that the basement's considered to count when it's proportionately just directly below that 840 or 860 some square feet?
It was discussed quite a bit. I think finally it was determined that somebody could finish off a basement, and that would be additional floor area.
That still
You could
wouldn't
go
count in
from
a real
two-
estate sale.
Well, we were looking at what the usable floor area, the livable area could be. And if you finish off a basement, that is considered, I know building and safety considers it, it's finished floor area, it's livable area. And so the task force, the working group, concluded that that should be included within the allowable floor area. Like I said before, minus any, furnace, water heater, mechanical equipment area.
I just find that strange that there's that kind of a difference between a real estate sale and the counting for an accessory dwelling unit.
Yeah, I don't know how the realtors do it, but.
I noticed that you included conditions of approval, although you're recommending denial.
Yeah, that's kind of standard on
Okay.
any application we recommend denial to, and that's just in case the planning commissioner, county board would approve it.
And is there anything in particular to bring to light in those conditions of approval?
No,
Yeah, okay. So there are less than 2 bedrooms in the facility, so, yeah.
I think in the letter it said 2 bedrooms, but on the site plan there was some confusion. One place it said 2 bedrooms, another place it said 1 bedroom. So that one condition was just put on there for clarity.
Understood.
When I did sit on the task force as our representative, I didn't go back and do all the research. Can you remind me, because it took a lot of discussion between the 40% and having a cap on it, because we were in the county and there were a lot more bigger houses out in the county because of the 20 acres and that. What was it? I mean, we had to obviously stop somewhere. And so, from my recollection, and that's where I need your help, is that I was thinking that the less than 40% gave still the ability to waiver more than 1,000 square feet because of the concept that the existing house may be bigger. So, if you did footprint to footprint, I think that math works out to 30%. If you do all finished space, it works out to 25% on this application. So it just seems to me that we were talking about having the ability to waive the 1,000 square feet based on the percentages if we saw fit based on the area.
Yeah.
But maybe I'm remembering incorrectly.
Well, my recollection is, I think first you gotta go to the intent of what an ADU is. And looking at other cities across the country, and actually our starting point, if you recall, was what City of Lincoln did, and our starting point was 800 square feet and 40%. We went from 800 up to 1,000 square feet, and I think, and one of the reasons we left this in as a waiver was because if you had a smaller principal house, let's say it was only, 1,500 square feet, well, your ADU would be so small at 40% that, it would barely be, wouldn't be very large. So we wanted to have a waiver process where, in those kind of cases, you could, increase it slightly from a 40%, which we did, as I noted in the staff report, the previous ADU went from 40% to 46%, but it was still under 1,000 square feet. We put the cap at 1,000 square feet because we thought that was, plenty large and met the intent of an ADU. We didn't want to have it, and I think there was discussion of whether it was 40% or, you could do either one. But we didn't, and when I say we, I'm speaking the group, didn't want to allow something where somebody had a 4,000 square foot house and then could do 40% of that. And so the cap, so it was left the smaller of the two, 40% or 1,000 square feet. Because if you do look at a lot of other cities, a lot of them are less than 1,000 square feet. We thought 1,000 square feet and 2 bedrooms was, a very good compromise for what is supposed to be a accessory unit and secondary to the principal dwelling.
I'm debating on if I need to say this now or if I need to save it for our discussion, but I was on the ADU committee as well. And for the city portion, maybe there was a separate one for the county portion.
There was.
Yeah, I did the county one.
And I concur with a lot of what Tom's saying. Like, our main goals were affordable housing, and it should be an accessory use. And it also, we were going with the assumption that a lot of people that are going to make applications for this are wanting to have, older residents, stay in their home instead of going to a nursing home. So these would probably have to be accessible. And so with the basement square footage, I feel that we need to count that. Because when I first looked at this and saw, I feel like I don't know if I should save this for discussion, but when I saw, the 1,600 square feet, I was like, that's bigger than the house I live in now. And so I agree with Tom, like, when we were looking at this, our intent was not, I struggle how to say this without, I don't mean to sound rude, but we're looking at a 4,000 square foot house here. That's a large size of a house, so almost anything is going to be accessory to that. So I think we talked about the and or the 1,000 or the percentage, and from what I remember, that was very important. And that, we put specific waivers in there. Only certain things could be waived for specific reasons, and that's why we did that. And so, I have some issues with this, but I do have some questions for Tom. Grandfathering was mentioned. Is there any way, because of the murkiness around the records and all this stuff, can we grandfather this in without calling it an ADU?
Well, there has been some disagreement, I guess, over whether this was legal or not. Research, I personally did research of planning's records, and county board agendas and could not find anything, any previous special permit. Not to say that there wasn't one, but I haven't been able to find one. And for something to be grandfathered in, it would have to have been legal at the time it was created. So I think we would have to, find for sure, have something to show that it was there legally when it was created. Now, I'm not, without going back and looking at the county regulations back then, but I know for, if it was a special permit for a caretaker, I know one of the conditions is that it has to be occupied by a employee, a caretaker, somebody working on the ground. So I'm not sure how that would, even if it did have that special permit, I'm not sure how that would apply in this case. And if you have questions for the county attorney, I believe she is listening in.
I don't think so. I don't. Does anyone else? Okay. Other questions for Tom right now? Okay. Applicant rebuttal.
If I may just speak quickly, and then I'll let Mr. Hunziger. I think to Mr. Campbell's point here, and to the space, the house and the confusion is the assessor, as does look at the space, does assess this as an 824 square foot house with one bedroom, because that's what the main level is. And you can see it is built, to your point too, to be accessible for like my parents. It's got the ramp into the front, and the main living space is the main level. There is, again, the basement space. It's an exact mirror of that. It does have the water heater and the furnace and that, so it's not the entire space that's, in fact, there's just a small portion of it's finished that is a second bedroom, but obviously if it's used by occupants such as my parents, the main living space is at 824 square foot, so I think it is subordinate. And then just the one other response to that is with respect to the intent on the 1,000 versus the 40%. If it was the board's and the city council's intent that the 1,000 couldn't be waived, they could have put that in the ordinance like they did the other things. There are specific things that can't be waived. The 1,000 square feet is not one of those specific things. So if that was the intent, then that should have been put in there. And I'll reserve the rest of my time for Mr. Hunt.
I have a question. Is Mr. Hunziker your attorney?
He is now, because I got to him through this being an issue, and he was the attorney at that time. So I asked him to come today.
The reason why I'm asking is this is applicant rebuttal, and so he's not really the applicant, you are.
I am paying him to be here to represent me
Okay.
today. If that, yes. So.
I really don't have a lot to add, except that I wanted to just point out the logic of saying it's okay to exceed 40% of the main dwelling for an ADU, where essentially in the case that the only other one that's been approved, you've approved a 970 square foot secondary house, which is supposedly secondary to a 2,100 square foot house. Here we have a house that's an 824 square foot footprint. Call it 1,650 if you like, but whatever. It's very secondary to a 6,600 square foot house. It clearly, in this case, fits the description of a secondary accessory building much better than the case of a 970 square foot house trying to pretend to be secondary to a 2,100 square foot house. And so I think you need to have some flexibility in this, and I certainly haven't any objection to the 40% waiver on the previous one, but this one falls much better within the intent of both the comp plan language and the regulations than the previous one that you've approved. And finally, I don't see this as being any sort of precedent for anybody else. I mean, there isn't going to be anybody else. Well, it is very, very unlikely that there will be anybody else who will come in with a pre-existing house and say, please give me a special permit. This one, I would venture to guess, is probably the only one like this you'll ever see. And it certainly is the most unique circumstance I've ever come across. I have never encountered this kind of confusion over the legal status of a building ever. And I think it has to do somewhat with the fact that prior to, back in 1999, when this building was built, neither the house nor the accessory building needed to have a building permit because it was on a farm. And the statutory language in those days was if you were on a farm, you didn't have to have a building permit. That's since changed. But the fact that there was no permit issued for this second house or secondary dwelling, it really shouldn't be a big surprise in those days. So again, we think this is something that is best cleaned up by approval of this special permit rather than trying to go through the exercise of having to ask for waivers of street frontage and construction of streets and all the things that go with a community unit plan, not to mention all the expense. I'd try to answer any questions.
Any questions for Mr. Hunsaker?
Okay.
I apologize to my fellow commissioners, but I have a couple more questions for staff. Can we go, would you guys be okay if, because I know if I ask staff, then we have to allow the applicant another rebuttal. Are you guys okay with that?
Yeah.
Yes.
I'm sorry, Tom. I forgot I had questions about the CUP issue.
Okay.
So can you tell us, like if they were to go the CUP route, and so my understanding is that they would have, well, first of all, would they have to take access off of, hold on, let me find the right map,
A Street.
A Street.
A Street, or could they take it off 112th Street?
They would have to show a street off of A Street. Well, I mean, the problem with coming off of 112th is they would have to go through Mr. Klein's property.
But what about putting something up here?
I believe those are other lots.
Because I thought he owned that property as well.
Oh, I see what you're saying. Yes, yeah. Let me just put that back up here. Right, the north property does have, yeah, it does have frontage on 112, so it could come off of you could have it off 112th or A.
Just because someone does a CUP, does that mean that they have to develop that land?
No,
What all is required when they have to do a CUP?
pretty much what Mr. Hunsaker said, a site plan, a grading drainage plan, street profile plan. You have to construct the street can be gravel, doesn't have to be paved.
So when they do the site plan, they could indicate however they wanted to separate out the lots. Doesn't mean that they're gonna be developed.
Right, you would do the CUP would be the first step, get approval, and then you'd come back and do a final plat, and you could plat however many lots you wanted to out of the CUP.
And then the grading plan would just be for their new access road that they would need.
Usually in the county CUPs, yeah, the grading plan is not too intensive.
Would you have any idea how much those items would cost? I mean,
No.
What's the cost of a CUP application versus a ADU application?
CUP would be, I think it's $988. This application, I believe, was $412.
Other questions for Tom about CUPs or anything?
On the, just one quick question, on the ADU for the city zoning, what waivers are allowed with that? Is it the same? 4 and 5 are the only must-do?
I believe that's correct. I think we pretty much did what the city did in the county.
Okay.
Can you remind me which two things can't be waived?
What was it? The
The deed restriction?
separating, the deed restriction has to be one, you can't separate it off onto another lot. And the owner has to live on the property.
Okay, thank you. I could not remember that part for sure. Okay, thank you, Tom. Applicant.
I guess I should let my attorney speak. A couple things with respect to that. This application was $988. I was told the application for the community unit plan would be more than that. And talking with the engineers, and in addition to the application fee, I've also had to pay, as I mentioned, surveyors to come out and do what I needed to get this application. If I wanted to do a community unit plan, those surveys gave me an estimate of $10,000 to do that, along with some of the engineering that would go along with that before I even started any construction. And again, for my intended use of this property, and we can worry 30 years from now about them. You'll have different requirements then. The access here, if you look at 112th Street, what you can't really see, but you can see by the waterways, is the grade of the property. And there's some downhill grade there, and it's the backside of a dam that was built in 1933 as a WPA project. So to come in and around here, I have this building here now. It's a great downward slope. The construction of that would take at least a few different culverts, as well as a significant amount of grading to get that up to the grade level of the house driveway as it exists today. And then would be narrow between the property line, because between the existing buildings and the property line, there's a slope down. So you'd either have to put in retaining walls at a great expense to do that, or build a much larger road all the way around the other side of the pond. So this would not be an insignificant expense in creating this alternative access either.
Any questions for the applicant? Okay.
I would move that we close the public hearing.
Second.
Jerry?
Okay. Albadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Shear?
Yes.
Core?
Yes.
Motion carried, 6-0.
I would then make a motion to approve the special permit 20015 with the waivers.
Second, Albadri. Oh, sorry.
No, you got it.
This is an unusual situation. We built in 1979 and had absolutely no building permits whatsoever. So that was not unusual in those times. And the only inspections that had to be done were on, I believe, electrical had to be inspected, and there may have been one other. But it was pretty much build what you want when you want. And so this happened, and the intent that they have for this property is exactly what an ADU is. And so I think that this is one that we should grant a special permit and support the applicant in creating a legal status for what's already there.
Dennis?
I'm going to support the motion. I think that the applicant has come before us and made this application with good faith. I believe that what he's trying to do, the applicant is trying to do here is, or I should say, it does meet the spirit of the ordinance, the regulations that we approved a couple years ago. I wasn't on any of the task forces, but I remember, as I said 2 weeks ago, I remember the discussion we had as planning commissioners very, very clearly from a couple years ago. And we talked about the waivers a lot. And we specifically removed two of the conditions from having waivers, and this was not one of them. And we talked a lot about fit and kind of the overall intent of what we were trying to do. So I think that this, as Dick said, I think this fits with what we were trying to accomplish a couple years ago. When I was reading through the staff report, I was intrigued by the CUP process. I thought that might be an out, but as I've learned more about the topography and the desire of not only the applicant, but an additional adjacent property owner, a CUP is a worse fix to this than just going ahead and granting this waiver and approving this motion. So I don't think that's the right way to go. In fact, I think it'd really be terrible for us to actually say a CUP is the right approach here. I think that'd be a bad thing, but bad from a planning standpoint. So I'm gonna support it.
I will be supporting the motion also, as my fellow commissioners have mentioned. I do really appreciate the due diligence of the staff and to keep us focused. I do think from a county standpoint, there was a lot of discussion on size and all of those types of things, and I think this ADU does meet the intent of what we were looking for. And because of how the pictures of its design, it gives us even a little more flavor because we see that it's accessible and it is less than that 1,000 square feet and, 25% of the dwelling unit on the property. So I will be supporting this motion.
I will be supporting it as well as my fellow commissioners have stated. I think the applicant as well as staff gave us the information we needed. I understand staff's concerns about possible other waivers that might come through. But again, seeing that this was some pre-existing in a sense, I will go ahead and support.
I do have some concerns still. I understand with the grading and I don't know if I want to say it grading, the topography, that does make it challenging to create a drive and that kind of stuff to make it accessible going the CUP route. And but I am concerned about the ADU because I know being on that committee, the different viewpoints and why what we came up with was a compromise between different perspectives. And I am very nervous because we just had someone else the last time we were here asking for an ADU, and they all, I shouldn't say all, they're great reasons to have an ADU. They wanted to have, their children live on the same property so they could age in place, and that's very admirable. But as planning commissioners, we do have to look at who the next property owner is and the long term and what will happen. And part of the problem that I foresee with ADUs is that not so much in the county as in, the city of Lincoln limits, but separating it out and being able to sell it on its own, and we have to protect some of those things. And I think that if I remember correctly, we did talk about having larger sizes of the houses in the county as opposed to the city because it's more wide open spaces there. And so maybe we need to go back and look at that. When we first recommended this, these rules to be proposed, we did so with the thought that if applications came in and we needed to adjust it, we could definitely do that down the road. And so maybe, we need to look at in the county, maybe we do need to have larger square footages available to that. But because, and I understand this is a pre-existing condition, I'm still gonna vote for denial just because I want to protect those ADU rules that we put in place because I understand why they were put there for that reason. So I will be not voting for approval.
Tracy, I think the first argument that you were making, giving a special permit does not split that into lots where a
Right.
PUD would,
Right,
which would allow somebody who bought it in the future to sell the property separately.
right.
I believe doing the special permit keeps that all together.
Right, and that's why
doesn't
I'm
allow
saying
that
we
to
want
happen.
to keep that
Yeah.
together. And so that's why I would prefer they do a CUP, because then they can do whatever they want with that, and then we're protecting the ADU so that this doesn't become an issue for the ADU. Okay? Because in the city, which is a little bit different than the county, we don't want things like, in core neighborhoods, it's very hard because I'm not stating this very well. We want to protect the owner occupied. We don't want someone renting out and having problem properties, which is not so much of a problem in the county, perhaps, but we wanted to protect that. And so I would much rather this be separate and then they can do their own thing on this particular property than to have them tied together. I don't know if that clarifies anything. No? Okay. Jerry?
Okay, this is for the conditional approval of special permit 20015. Albadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Share?
Yes.
Core?
No.
Motion carried 5-1. Okay, staff has requested a 2-minute break to allow for the transition to the next agenda item. We have a number of people that want to testify,
Okay, so we'll be on break for
like a 2-minute break.
2 minutes.
Yeah. Okay, moving on to the next agenda item, which is item 4.2, special permit 20013 to allow for a community unit plan with associated waivers to setbacks, lot area, block length, and the sanitary sewer design standards on property generally located at South 46th and Hillside Streets. This is final action on this item unless appealed to the City Council within 14 days. Staff recommendation is for conditional approval. Are there any ex parte communications to be disclosed?
Yes. Jerry, I was I was present during the Zoom meeting of the College View Neighborhood Association on May 13th, where Mr. Euler presented his plans to the neighborhood.
Noted. Thank you. Are there any ex parte communications that took place or additional information you learned while visiting the site?
Rachel.
Rachel Jones, planning staff. This is an application for a new community unit plan. And the development would be located within an existing block in the College View area. The block is bounded by South 46th Street on the west, 48th Street on the east, High Street on the north, and Hillside on the south. And this is an infill project that would redevelop portions of several existing properties that the developer owns. The plan shows a total of 16 dwelling units. 8 are existing dwelling units that will remain and continue to take access via either 48th Street or 46th Street. And then the backs of these lots would be redeveloped into 8 new units. A new street would be provided for access to the new dwellings coming off of 46th Street. This is the Peanut Hill Road. And you will see that to the south, they're showing a conceptual continuation of the street and lot layout with a potential connection shown down to Hillside Street, just off the end here, right down here. And the street would be shown with a temporary dead end. We did receive some comments about this. We allow streets to dead end as long as there is intent to extend the street in the future. This concept plan on the south is not being approved at this time, other than it would show how the street could be extended in a way that meets city standards. And to be clear, if the developer went forward with phase 2, it would require the approval of any property owners involved. And with that, I will take any questions you have for me.
I'm going to hop on that last comment that you just made. If they go through with phase 2, will it come back through planning commission, or would it just be an administrative amendment?
It would come back through planning commission because it is not in the proposed boundary today.
Thank you. Anyone else have questions for Rachel right now?
Okay.
Okay, thank you. Applicant.
Good afternoon, Commissioners. My name is Philip Euler. I am the applicant when using Riga Engineering to process everything. I just wanted to give you just a little bit of background for me. I've not been to you before, and I'm not likely to come back again. I came to Lincoln in 1968. I grew up in Kearney. I came here to attend UNL. I got my engineering degree, and I worked for Lincoln Electric System for 30 years, and then over 10 years for Nebraska NMPP Energy. I've been a resident since that time. I'm retired now, and I want to tell you how I first came involved with this particular piece of property. It was through Sheridan Lutheran Church. In the 1980s, Bud Christensen, who I think has wrote you a letter, asked me and others to consider forming a housing corporation with the primary purpose to assist particularly single-parent families are having a difficult time finding clean and affordable housing. At that time, we bought 3327 South 48th, which is about at 48th and Sherman. We rehabbed that home. We placed a family in there with 3 girls and a mom, and she was there over 5 or 6 years. As the corporation continued to look at what to do, Habitat for Humanity in Lincoln opened up, and we felt that we could better financially support them because of their wide region of covering the city. And so we gradually evolved out, and since I already had one property and a rental property in East Campus, I agreed to buy at 3327. And I established for my Euler rentals a similar type of an objective, is to try and find good, clean, affordable housing in what I think is a wonderful neighborhood for families. So that's how I came to this property. As you may know, when the city of Lincoln annexed it, there were a number of horses that resided behind these homes. That's why the lots were big. They were all grandfathered, and when they went away, the land sometimes kind of just went into disrepair or a dump, what have you. So I'm going to turn it back over to just one other thing. You may or may not know the significance of why the streets are named what they are, but it is a historic labeling for College View area, because peanuts were grown in the area and people would go on Sunday on the trolley to go get peanuts on Sunday afternoon as an outing. I'm going to turn it over to Dan unless you have any questions for me.
Any questions for Mr. Euler right now?
Thank you very much.
Thank you.
Dan Rosenthal at the Re-Engineering Group, the engineer for the project. I guess we had the neighborhood meeting last week, so I just want to hit some of the highlights.
That one, yeah.
I just want to hit some of the highlights. Went through all the, there's 5 support letters and 4 opposition letters. So I just kind of went through the letters a little bit and just kind of highlight some of the things. One thing that is a resounding comment all the time is traffic. And so we looked at the Institute of Traffic Engineering calculations for trip generation. And for the number of lots, for an AM movement, it's a 2-hour window, it creates 5.92 vehicles per hour. That's for peak AM, so that's a pretty low number. So that's less than 3 vehicles per hour. So that's in a 2-hour window. The PM, that'd be rush hour traffic in the afternoon. That's from 4 to 6 PM, and that generates 1 movement per unit. So that's 8 total vehicles estimated in that 2-hour window. So you can see the traffic generation is really pretty low. But if you spread that out for the entire day, it's about 75 vehicles for the entire day. And then another thing that came up was some of the residents have possibly sanitary sewer lines that cross different properties. And talking to Phil during construction, he would certainly fix anything that went across the property, and we would work with whoever, the city, maybe Brian Kramer and Breon, to make sure we have non-abutting agreements in place so that it would make those sanitary sewer lines actually compliant with the city standards. So we're hoping that's not the case, but that may come up. Another question that kept coming up too is how close the street's going to be within my yard or next to my house. So we had been working on this project for over a year with the planning department and city departments to make sure that we have everything laid out correctly, the right-of-way, the setbacks, the sidewalk locations and everything. So everything we have does meet all the criteria for new design standards. There's a lot of questions about the storm sewer system. We've been working with watershed management. We have everything worked out as far as the calculations for the storm water. If you look at the grading plan, I'm not sure if you have that or not, but it shows a bigger detention cell, and the first phase would be a lot lower. It wouldn't be as high water level as what we'd have to do if we moved into phase 2 to create everything. So those are some of the things I think were in those opposition letters. regarding the site, so I kind of wanted to address those. Anybody have any questions for me?
Do you have access to a map right in front of you? There was some discussion about the pedestrian easement, and I was wondering if you could point that out to me.
Oh, sure. That's right here, right, Rachel?
Yes, that's
Right here?
the one.
Because of the block length. they-
Okay.
They want to have access from 48th over to this street.
Sure. Okay, thank you.
You're welcome.
I do have a question for Mr. Euling. If he can come back up.
You can come back up.
Yes, sir.
Leaving that, looking at this map that's up there now, besides the property that you mentioned, which I assume is lot 7 on the plan.
Yes,
Okay, have you purchased 6 through 10 and 1 through 3? Do you own those properties?
do.
You own all of those?
I own 10, 9, 8, 7, 6, and 1, 2, and 3, and the home that's gonna be moved across the street.
Okay, thank you.
That was one of my questions, is I noticed that one house was going to be moved. So is it the one that's on Outlot A right now?
That is correct, yes.
Okay. And so then, I know someone wrote in, I was thinking that that was where they were.
It was one along outlet B up here.
Oh, okay, okay. So is Outlot A big enough for a dwelling unit on there?
No, there won't be any house there. The house that's existing right now is going to get moved across the street, and then that will just remain an outlot. It's not big enough for a house.
Okay,
So I think the question is that that house is now going to have a street, a side yard, and so what we do is we create, the city wants an outlot created there, so nobody will ever build there. So that'll always be a green space.
so it will just be green space, nothing's
Green
planned to
space,
go
I'm
in there?
thinking possibly Outlot B may become a community garden, but until we actually see how things lay out, it might be Outlot A that becomes, at least part of it a community garden. So, that would be determined by the neighborhood association.
Right, great.
There was also discussion of a new culvert in this area. Can you point to where that is?
Yes, a couple of years ago, maybe it was last spring, the city of Lincoln had, we did some work. I'm sorry, back up in here on, High Street.
Okay.
They built a new storm sewer pipe right through this area right here.
Okay.
I guess I do want to comment on the outlot. So this person here who talked about they're going to be next to the street, they will actually be next to a lot. They won't be next to the street.
Okay, thank you for
If I
clarifying
could
that.
comment on that, there was a 15-inch tube there originally, and it ran alongside the west side of Ken Bro's house, and there was a lot of problems with it. With the 44th Street sewer project, I think the city said we need to make that bigger, and so they put in a new tube in there. And so it's increased its capacity to move water out.
Oh, yeah, go ahead.
Dan, I can't manipulate my computer screen well enough here. Can you point on the plan that's on the screen exactly where the street dead ends in this first phase?
Right here at the end of phase 1.
So at the property line?
Correct.
Okay.
There was some discussion as to, and it's inaccurately marked on this as Van Dorn Street, but it's actually High Street, correct?
Yes.
Okay, so on High Street, there was some discussion about how close Peanut Hill Road is to High Street. I assume that that's an appropriate distance for a cross street in terms of,
Correct, yes.
Okay.
Like I said, it meets all the design standards, all the curves, all the radius of points, everything meets all the slope of the street, everything meets design standards. And that's, I can't speak for planning or city, but that's why they do have conditional approval for the project, so.
Can you tell me a little bit about the June 2nd neighborhood meeting? Like, how many participants did you have?
I believe we had about 10 in our office, and then probably another 7 or 8 via Zoom, our go-to meeting. And it lasted about an hour and a half.
And what were the primary concerns? Were they kind of the same that we've heard today, or?
Oh, well, we haven't heard it yet today.
Well, the letters, I guess.
But I think mostly not my backyard. You know, that seemed like that was resounding. You know, greed, not my backyard. Don't want the project. And it meets all the criteria. It meets I think the city comp plan. It meets everything the city planning department wants to see in a project. Yeah, mostly just not my backyard. We love it the way it is. We don't change it.
Okay.
That's what I kind of heard.
Can you tell me, there was mention of one lot had to be removed because that you needed it for water detention. Is
Yes.
that in the Outlot C area?
Yes, right over here.
Okay.
Well, yeah, it'd be right in here.
Oh, okay.
And so there is some discussion going on that probably be down the road if
Phase 2.
phase 2 happens, will we be able to replat that as a lot? There's some discussion that perhaps the city may not want to do that because of the soil being saturated. And our thought process is we just remove all that saturated soil, bring in some clean, dry soil, and just remedy the situation, so.
Okay. Any other questions for the applicant right now?
I guess I do have one other comment.
Oh, sure.
Is we will not be doing any grading on anybody else's property. Everything is within the limits of the property. So we won't need any easements or anything for grading.
Okay, thank you. Testimony and support for this application. Come on up.
There apparently is nobody here in support, or, I'm sorry.
No.
Support.
Yep, oh, sorry. Testimony and support. Okay, and there's no one in the back room for this? Okay. Testimony and opposition.
Okay, I have a sign-in sheet, so I'm going
Okay.
to read the names so that they know in what order. Okay, it's Tammy Lingle would be first, Deborah Clover, and followed by Roberta Clover. So I'll just call out 3 names at a time, and so you can just be prepared to go in that order.
You mean Cleaver, K-L-E-V-E-R?
That would be what I mean.
I wasn't planning to testify, but he will. Can he take my time?
And what is his name?
Del?
Del. Okay, Del Cleaver.
I was wondering if those 3 wouldn't mind if I went first, because I wanted to lay a foundation down for everything, but if they want to go first, fine. That's fine with me. I don't care.
Go ahead, and your name, ma'am, or you'll announce it.
Okay.
Can you tell us your name and address
Over
first?
at the microphone, over here.
This one here?
Yeah.
Okay, my name is Nancy Seltzer, and I've lived on this block for 41 years, and I live on the 48th Street. And I just wanted to let you know that,
Can you give us your specific street address?
oh, sure, 3229 South 48th Street.
Thank you.
I'm number 13 on the map.
Okay.
This proposal that is up today has been proposed for 18 years. I'm not sure if you're aware of that. For 18 years, and I have a file I've kept from the year 2002 of everything that's gone on, all the people that have lived on my block, have died, have felt they were harassed, all kinds of things, but I've never come across anybody on our block that's wanted this land developed, okay? So, outside of maybe his 2 daughters that he bought a house for on the block. So, there's been all this opposition all these years. So, Phil's answer to that has pretty much been to buy up the block. And if you, See, Euler Rentals owns, I don't know what, 50%, 70% of the houses, okay? That's what's been going on. So that's why I wanted to lay this foundation. So the last time this came up was about 2 years ago in 2018. And, about 2016, we started up an Eden Park Neighborhood Association. And I sat on the board. And in one of our meetings, one of the people in our community came up and was concerned because there was talk of this again. And so then there was a big hoopla in the meeting. So our president, Ray Crisp, said he was going to come down and talk and find out about it. Well, he came down and I don't know, raised hell or what he did. But anyway, everything got dropped. So anyway, let's see. Where do I want to go from here? Okay, well, I have some concerns about this meeting today because I've talked to a few people on the block, and not everybody, just a few here and there, and 2 people never received notices about either one of this meeting or last week's meeting. That concerns me. I have concerns because people are losing heart because we fought this project for so many years, and so many people have died since then or moved. I also have concerns that this is happening over the COVID-19 thing where people are afraid to come out of their house and testify. And I have a biggest concern about, I contacted the Ombudsman, and their job is to make sure that people, our group, gets fair representation. And she told me she's in lockdown, so she won't come. So that concerns me too. Okay. Now we'll move on to the next thing. Last night, laying in bed, I decided to write down the pros that I've heard from people in our community versus the cons. Well, needless to say, I couldn't come up with any pros that anybody wanted, but I came up with a list of 14 cons. And anybody here that wants to testify that or say that's their beef is more welcome to extrapolate on it, okay? So I'm going to go through those 14 quick. One of them is loss of privacy. Last week or 2 weeks ago, the first drone go over my house. I like to lay out in my backyard, and I don't want somebody spying on me, or I don't want a house close by watching, you know? Then my concern, and this is going to seem probably petty to you, but it isn't petty to me, and none of these issues these people are going to bring up is petty to them, okay? Is I'm going to lose the ambiance. For 41 years, I've fenced in my backyard. I've landscaped it. I put in a Japanese garden where I carried my own bags of cement and made my own concrete stones. And you're all welcome to come on my property anytime you want to and look the situation over. I don't know if you have to make a decision today or not. And then another one is people are concerned we're losing the trees. You lose trees. You lose oxygen that's recycled. Another beef is that people are going to now be looking down on rooftops, cold cars, and cold concrete. Another thing, barking dogs. You get 20 new houses back there, you might have 20 new barking dogs. Traffic and noise. Even the other night, and I don't know if it was one of my neighbors here, but they were having a little pool party down there, and I was outside, and I could hear every word they said 300 feet away, because this thing is built like a funnel, and the sound waves have nowhere to go, so any little sound down there stays down there. And so I got to watch my cussing a little more, I guess. So anyway, then we've got your traffic pollution. Then people are concerned about sewerage backup, water backup, basement walls, the vibrations the road's going to cause where their old house walls are crumbling in the basement. More crowding is going to lead to more crime. But the biggest thing is the flooding. And, well, how do I want to put this? Years ago, there weren't all these regulations like you guys were talking about before, needing permits for this and that. And all the old timers knew enough not to build a cabin or a house next to the river. But things got more liberal, and there's more people in the world, so they started building all these houses along the rivers. And so what did we have a couple years ago? Flooded rivers. So what did we have? We had a lot of homeowners that were devastated, lost everything. And so volunteers went in and helped them clean up, and FEMA went in and helped them clean up. And you know how disastrous, you saw the news. Well, then we got it all cleaned up, and what hit last year? Well, another doggone flood, all by the rivers. So our federal government, if you recollect, they stepped in and they said, well, we can't be having this. We can't afford to clean these guys up every year, so we're going to buy out their properties so they don't build any more things here. Nobody needs to be building here. So that's what I think we're going to run into here. Right now, we're concerned with the neighborhood and the developer Phil and you, the planning commission. But you know who's not here? Are those that are going to pay $50,000, $60,000 for these new lots, basically at the bottom of a funnel. Because all our houses sit up here and it all drains down into this area. And I don't know, they say they got a pond that's going to dry up every 48 hours, but I'm not sure you guys really realize how much water comes down there. I've got pictures of my backyard here, and a few years back we had such a gully wrencher that it put foot-deep trenches in my backyard, because my backyard goes down 400 feet, and then my neighbor's yard that butts against it is another 400 feet. Imagine if your roof was 400 foot long and water coming down it. That's the size of a football field and a third down at the university. That's a lot of water. And I go down.
We put the pictures on the device there and we can see them.
Right here?
Mm-hmm.
Okay, right there is where it started washing out. And you can't really tell from the photo too much, but that's my black tar paper. That was a foot deep. So the only way I could get it to keep from eroding further was I had to haul in some boulders, and then I put different sizes of rock on top of the boulders, and then I put pea gravel on top of that. I had quite a problem. And then at the bottom of my lot, you see this fence down here? Water went down there so fast one time that that's probably a 100-foot across fence, 80 foot, something like that. And every 6 foot is a 4x4 post, and they're all concreted in. Well, so much water went down that deal that it lifted those posts out, and the fence laid down about this high, and the water went over it. So there's a hell of a lot of water that goes there. Let's see. Got that. Also, years ago, I had a friend who was worked for the geology department, and he was telling me facts about the block. And he says that we had one of the I thought he said 3, but I might be wrong, virgin woodlands still in the city limits. And he acted like we had a treasure there. Well, I gotta say, there was trash in there, and Phil has cleaned that up, and he's a hard-working son of a gun. But he gets carried away and a little ambitious with his ideas and projects that nobody else wants. But I will say this, also in his favor, all these rentals, I mean, at first everybody in the neighborhood didn't want him turning all these family homes into rentals. I mean, we didn't want to be surrounded with who knows what. But I will give it to him that he screens his tenants well, and we haven't had any problems with them. But I do have a problem with this little sidewalk he's proposing on Lot D, where it goes from 48th Street to the road.
If you could have one more minute to wrap up your testimony.
Okay, well, then I'll wrap it up. Okay.
So tell us about your problem with the sidewalk.
Well, I just don't think anybody needs to be going from 48th Street sidewalk between a couple of houses down to this road. There's nothing there. There's no business there. It's going to bring crime. Okay? So I guess to wrap it up, my question to you guys is this. Why would anyone vote for this proposal if, for one man, that the whole neighborhood, outside of his 2 kids and son-in-law that live there, don't want? To me, the only reason you would do that is because you want more taxpayer money for property taxes. And to me, that's what you call a quid pro quo. And we know what a quid pro quo is after this year. That's it.
Ma'am,
Oh, we got a question for you.
Oh, you do?
Rachel, can you put your map back up there of the,
This one here?
yeah. It'll come up in just a second.
There we go.
Okay, can you point out lot 13 to me?
You mean where I live?
Yes.
Yeah, it's right up here.
Which,
Bill initially talked me into selling my bottom 2 lots, and I thought it was gonna come across 2 like this, but then when I saw when he diagonaled on his map here and took 2/3 of my backyard, I said, no way, I'm not selling.
so you live in that, where it says POB above,
You got it, that whole,
10.
whole checkered thing.
okay, that goes clear back.
Yeah, 400 feet.
Okay, thank you.
Yep.
Any other questions? Okay, thank you. All right, Jerry, who's next?
Okay, Tammy Lingle, Dell Cleaver, and Roberta Cleaver.
I don't have a lot to say. My name is Tammy Lingle, and I live at 4730 Hillside Street. So, if you know where that is on the map, here, I think it's about right here.
Just a second.
Oh, hold on.
Sorry?
It's just not up on the screen yet. There we go.
Okay. So it's this one right here.
Which one?
You gotta slide it
Move it
up
up.
a little.
There you go.
Okay, so it's this long one right here.
Okay, thank you.
Okay. So I don't have a whole lot to say. We cared enough that we went around the neighborhood and got signatures of people who are
Okay.
opposed to this. And we wanted you to have a copy of that. There's also a copy of, my sister owns half of my house. And so she lives in Arizona. And so she included a letter that's notarized and the deed to our house to prove she is
You
a
can
house
place
owner.
those right in that envelope
All right.
on the, that would be great.
Okay.
Thank you.
Thank you.
Can you kind of just tell me a little bit, did you just go around the block? Is that where you got your signatures?
Yeah, around the block.
Okay, great, thank
Okay.
you.
Anybody else?
You're free to go.
Thank you.
Thank you.
Yeah.
Dell Cleaver. Okay, and then following Dell would be, Roberta, did you say you were not speaking?
She didn't.
Okay. Okay, Rebecca Cast, and then followed by Barbara Sullivan.
Go
Hey, my
ahead.
name's Del Cleaver. I live here at 3328 South 46th. 1983, my wife and I got married. A little brief history. I wanted to buy an acreage. She wasn't real big on the idea. She wanted to live in town because of her work schedule. She was working as a nurse, so we found this gem. It was a diamond in the rough. I had the property because I'm an outdoor person. She was able to live in the city. We've been there ever since. Yes, the area was rough, needed a lot of work. The previous owners had let it go. Those people, a lot of them have aged out. Younger generations have moved in, and we've been cleaning it up. Some of the concerns I have, even though it says that it works on paper, it meets all the criteria for the access in and out of this, you're actually bringing this development in and out on the two of the narrowest streets in the neighborhood. It would be a lot better if you could bring this over here onto onto High Street, where it lines up closer to 46, because at that point, High Street is 3 lanes wide, 46th Street is 2 lanes and a motorcycle. Hillside is barely 2 lanes. Okay. Another thing I have concern about is the access point there. Because there are no cross streets, traffic goes down the street quite fast. There are a number of people that do not meet the 25-mile-an-hour speed limit. They actually exceed that. The quick shop on 48th and Calvert, to try and get out of there and go north on 48th is next to impossible. People use 46th Street to get to Van Dorn, yet northbound. Even the delivery trucks use that. In the wintertime, that stretch of 46th Street becomes very, very icy because of the trees in front of 3240 plus the angle of the street. We don't see any sun down there. I am surprised the house at the bottom of the hill has not been hit. There's a reason that person keeps their driveway clear of ice all winter long. There has been black marks up to their garage door. I wonder about the sewer capacity, the sanitary sewer capacity. The reason I question, is that going to cause a problem further down line from this development area? With the stormwater runoff, what I saw when Union Bank removed 11 properties and turned them into a parking lot, that's when we started having problems with the storm sewer behind Kenny Bro's house. Prior to that, it was able to meet the demand. When they did that, the amount of water that goes down through there exceeded that. So the city had the expense of having to increase the capacity of that stormwater. Is the sanitary sewer, are we going to see problems maybe half mile down the road, a mile down the road? People start seeing backup into their basements because of the added sewer runoff that's put in there. Another question is, when you start bringing in the heavy equipment to build these streets, are we going to crush that sewer line? This sewer line, 1920, approximately when it was built. The city, when they annexed College View, the records were just virtually non-existent. I tried to locate my sewer line back in '92, and the city said they had no information at all on that. So the records for that is not very good. That's another thing I'm concerned about, the way they're going to dead end that street, thinking that we're going to continue on in future development. Not too long ago, we had a 2-alarm fire on Hillside. The fire department brings a lot of equipment when they fight a fire. Are they going to be able to get their equipment into that development area and get it back out? If a truck would have a problem, could they get another truck in to replace that? That's just a few of my concerns there. One thing we didn't talk about with the additional delivery trucks that'll be going in and out during the day, garbage trucks, that's at least 2 trucks. We used to have just 1 truck a week in our neighborhood. Now they're running every day. So we have the additional load there. I think that's everything that I have to say at this point in time. Do you have any questions for me? Do you have a question?
Is your lot the one that is the second down from the future pedestrian sidewalk?
Mine is showing a pedestrian sidewalk running along the south property line.
Okay, so the south property line.
Yeah, going up to 46th Street.
So are you you're the second one in the grayed out area?
I have a color copy. Could I bring that up?
Sure, yeah.
It shows that a little better.
It's the first one.
Okay.
He's north of that pedestrian.
Sherman Street goes
Yes.
right into Dale's property.
So you're the orangish color?
Yes. This is my lot here. I have 440 feet, the west 440 feet of lot 3, north half.
Who owns that house that's 2 lots below you?
Going which direction?
No, going down.
That's
Yeah, that one.
Tom and Becky Cast.
I'm sorry?
Tom and Becky Cast, or Becky Cast. Tom has passed away.
Is it actually true that their garage is not all on their lot by the drawing?
Pardon? I didn't catch it. I have a little problem with the mass.
It appears that garage is not totally on their lot, that it's overextending onto a neighbor's lot.
You can come up later.
Yeah. The property owner is here. She owns 3 lots together.
Got it. Thank you.
Any other questions for Dal right now?
I don't know if you can see that or not.
Oh, wow.
That was the night we had 5 inches of rain, or 3 3¾ inches of rain. Memorial Day weekend. That's the north property line.
Just this year?
Yeah. May that we had the 8 inches of rain, water was 12 foot wide, 3 foot deep going across property. Another issue I see is this area here will weep water for a week after a heavy rain. This area stays wet for 1 to 2 weeks after a heavy rain. So anybody that has a house down, these houses here, I would be concerned about having water in the basements.
Any other questions for Dell? Okay, thank you.
Okay.
Okay, we have Rebecca Cast, Barbara Sullivan, and Ray Royal.
Afternoon. I am Rebecca Cast. My address is 4831 Mandarin Circle. My phone number, do you need that?
Nope.
Excuse me. Have old lady voice here. I own the 3 properties that you just, that Delbert pointed out. These 3 here. I've owned the property for 57 years. We bought the property because of what it was. It was a block deep. It was peaceful. It was serene. It was a wonderful place to raise our children. I had a horse back there for nearly 30 years. I had chickens and a rooster, unfortunately. It was peaceful and quiet. We lived there about 35 years, and then we moved on out to a little bigger acreage. It was peaceful and quiet in there until Phil began buying up properties and came in with his chainsaw and cut down everything that stood in front of him. He said the other evening he probably cut down 100 trees back in there. I have 2 issues that I want to talk about today. The first one, again, is the water that goes down there. As you figured out, both 48 and 46 come down to a valley. Last year, the city came in and replaced the storm sewer off of Hillside. We had a culvert on the first property there that my husband had put in, and at that time they were not joined together. When the city redid it, they attached to my culvert. When the water comes down there, and you've already heard how much water comes and where it comes from, we have a literal lake down there. The engineering company has assured me that their computer has done all the work and it should be able to handle a 100-year storm. But in the 80s, we had a 10-inch rain that lasted the whole day long. You could have floated Noah's Ark down in the back. So I'm not concerned. My concern is that this holding pond, if we get a rain like that, is going to back up. I have a barn or a little shed down in the bottom there that could possibly be damaged. If that were the case, then I guess I would have to sue the city or Phil or somebody. My second issue is phase 2, and I know we're here today to talk about phase 1. But I own those 3 properties, and if you will look at the map again, you will see that the road is crossing my property down here, and also where the cul-de-sac goes up. Phil has also decided that he should put some lots on the back of my property. I'm here to tell you today that my property is not for sale. It will not be for sale to Phil. It will never be for sale to Phil. So as phase 2 stands right now, it is null and void. And I will tell you why my property is not for sale. It's probably been 7 years that I've been bullied by Phil and his son-in-law, who lives in the next property to me. They had a tree fall on my fence. I asked if they were going to fix that. The son-in-law said to me, if you think I'm going to fix your fence when you've got all that crappy rental property and crappy renters that you have there, you're crazy. I'm going to have your land. And I said, I don't think so. And he said, when you die, I'll get it from your kids. I said, I don't think that's going to happen. So by the end of the week, I had a letter from the city that the son-in-law, had turned in all of our crappy rentals to the city. We had to take down a shed that we were thinking about anyway. We'd had to do a little painting on one house. By the end of the week, I was having a garage sale. I was turned in for having a garage sale. It wasn't too much time after that I came back to the house, and there were trusses laying on my front lawn that his son-in-law was building a room over the garage. I went over and told the workmen to get it off. They wouldn't listen to me, so I called the police. The policeman came. I told him my story. He said he was going to file a neighborhood feud against my neighbor. I don't know if that happened, but after that, he pretty much left me alone. The end of January, Phil showed up at my house, wanted to know if I wanted him to name one of his streets after my horse. I again said, I'm not selling you my land. After a heated discussion, I said, this conversation is over. He said, no, it isn't, wouldn't let me shut my door, and I had to threaten to call the police. Therefore, my land, and I hope you understand, is never for sale. So if Phil's going to do phase 2, there are going to have to be some changes there. About 30-some years ago, someone came in behind my property and they wanted to develop. At that time, the city denied it because they said the emergency vehicles wouldn't be able to get in and out of there. So I guess, that was kind of a concern with phase 1, too, but they told me there would be a T there for people to turn around. It would have to be a mighty big T for a fire truck to turn around in there, I think. But unless you have any questions for me, I thank you for listening to me today.
Any questions for Mrs. Cast?
Thank you.
Okay, we have Rebecca Sullivan, Ray Royal, and Larry Zogas. Thank you. Zogas.
Go ahead.
Hi, my name's Barbara Sullivan, and I live at 2962 South Street, and I'm Becky's daughter. They actually bought that house when she was pregnant with me. So 57 years, that house and that property has been a part of our family. As she was speaking, we love the outdoor space. We had horses, chickens, cows. We had a baseball diamond. It was great. It was the greatest childhood ever. We went down and played where the water came running off of Hillside. There was a stream that always ran through and flooded our horse pen, and that's where we played. That's where we grew up. And seeing what Phil wants to do back there just breaks my heart. I mean, I can go on about, the emotional factor of what this change would be to me, but, looking at what his proposal is and the staff report, he's just pulling from the comprehensive plan. So I did that as well. The comprehensive plan for the city talks about the results of such development are ultimately felt by individuals and their families. And I hope that you all consider the number of people that have come here to testify of how this is going to have a negative effect on them as well. He talks about redeveloping, the comprehensive plan talks about redeveloping, where buildings have been cleared from sites or where the properties are derelict. There's nothing here. There are no properties that are derelict. Every single property on that block is on the tax rolls. So there's already income being generated from every property. My mom has 6 rental units for low-income housing. If Phil puts in $250,000 houses, property taxes are going to go up. She's already having trouble making all the tax payments on all the properties that she has. So there we go. We're going to get 8 more houses in, but then 6 families are going to lose their low-income housing. And on the comprehensive plan, one of their goals is to provide low-income housing to people in the city of Lincoln. I have a letter from Phil's former attorney where he wanted to buy the properties of my mom, and he had offered between $108,000 to $138,000. Well, if the new properties are $250,000, what is that going to do to our property taxes in that area? I also should mention that I am one of the heirs to that property, and my brothers and I will not be selling that property to Phil or another developer. So phase 2 is not going to happen. Also continuing on, The comprehensive plan discusses downzoning, where they want to reuse sites and buildings in commercial areas in order to create new mixed-use centers that are compatible and complementary to adjacent neighborhoods. Again, this is not a blighted area. This is a fully functioning neighborhood. He's not coming in and saving the day. I mean, there's already houses there. There's already income being generated from property taxes. The comprehensive plan also discusses environmental impacts, and one of their goals is to preserve, protect, and promote the character and unique features of urban neighborhoods, including historical and architectural elements. The comprehensive plan continues with neighborhoods remain one of Lincoln's great strengths, and their conservation is fundamental to this plan. In existing neighborhoods, preservation, maintenance, and rehabilitation of existing housing should continue to be the focus. Infill and redevelopment needs to respect the street pattern, block sizes, and development standards of the area. And is he taking that into consideration? I feel like he's just presented all the ways that their plan meets the criteria to be built, but he's not taking into account any of these other things that the comprehensive plan addresses. I mean, I can go on. Lancaster County boasts a diverse set of environmental resources and landscape types that should be respected and maintained. 3.4, prevent the creation of wall-to-wall city through the use of green space. And there's a lot of considerations that haven't been looked at in these plans that take what was once a beautiful area, and granted, yeah, it did get to be messy in some areas, but it's still a natural area, so all the wildlife, all the birds, everything that's lived down there for my entire 57 years is going to be completely displaced by concrete and lights and noise. I mean, I really feel like this point in the comprehensive plan, 7.5 says, a neighborhood is more than housing. Great neighborhoods combine all the elements of parks, education, commercial areas, environmental resources, and housing together in one place. There's much more to be considered in his plan than the money on the tax rolls for 4, 5, 6, 7, 8 more houses. You really need to consider the impact this has on the people that live there and on the history of this area and how, I encourage you to drive by. You won't even realize from the street what this is back there. If you'd ever want to come over, walk in the backyard and see how beautiful it is and how serene it is and how peaceful it is, which is why my parents bought that property 57 years ago.
Any questions? Thank you for sharing.
Okay, we have Ray Royal, Larry Zolgas, and Elizabeth Terry.
Can you turn this back on?
Yeah, it'll do magically, but we'll have you speaking to the microphone.
My name's
so we
Ray
can hear you.
Royal. We've lived at that, I've lived there for a while, but my folks bought that house in 1952.
And what's the address of it?
4706 Hillside.
Okay.
See where your monitor shows. It's this house right here that Future Street seems to have not completed their drawing, because I don't know what happens here with this required easement on both sides of the road. I don't know what the city requires for easement. This house has got an old foundation, got buried concrete anchors. If you put in the road there, I'm gonna have to fix a basement, a significant expense. If phase 2 is not gonna happen, I don't have a dog in this fight. It's that simple. But yeah, it's a nice, quiet neighborhood, and Phil owns boom, 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 and over here. So he's got pretty good rental income off the property, and I don't disagree with him wanting to develop land in the heart of the city. It's 48th and Calvert, it's a busy intersection, it's right in the heart of town. But I've been misled more than twice on engineering design stuff. I'd like to see, where's the settling pond? Where's the settling pond? Where does the water flow to the settling pond come from? Because this doesn't show the quick shop and the bank and the concrete and all that stuff.
I have had water running curb deep a week ago in that vicinity. And over here, they had to redo the storm sewer. The lady that lives across the street right here, the city paved the alleyway. They put a big concrete alley. They put a big cast iron grate. Grate got plugged. She had water 10 inches high on her back fence. Didn't go away. Basement flooded. Finished basement. She put in new carpet. Insurance company probably paid for it. She lived there another year and sold the house. So the next person gets to deal with the problem. I can't imagine there was 3 foot deep water, 12 foot wide, but that's what somebody said. That's a lot of water. But, you know, it basically, it doesn't affect me. When you get heavy equipment in there shaking the ground, that wall's gonna collapse. It's got concrete anchors with, excuse me. Sorry about that.
Okay.
My dad had that done 40 years ago by some contractor, and it's stable. It's not going anywhere, but it'll move. If the ground plane gets moved around and stuff, it'll fail, and I'll put a new basement under the house.
Any questions for? No? Okay, thank you.
Okay, thank you.
Okay, Larry Zolgis, Elizabeth Terry, and Dave Sabatka.
So my concern is much the same as Royal's
Tell
concern.
us your address too.
4648 Hillside Street.
Thank you.
There's a proposed road that may happen in phase 2. And so I feel a little out of phase right now because I don't even know if phase 2 is going to happen. But the paperwork that I received had said this was concerned with 46th Street and Hillside, and I live on Hillside, so here I am. I'm objecting to putting a road into that area because it'd be right next to my house. I've disputed the fact that I did not think there was enough room to put a road in there without bending some rules or having modifications to codes or whatever. I've been assured there is, but like Royal, also I'm concerned with what kind of disturbance they'll do to my foundation in the process of putting that road in, because there's not a whole lot of room between those houses. Currently, I have had no water, but one particular time, just a little bit of water in the basement. Other than that, in 30 years, no water in my basement. So we've been lucky. We got about that much topsoil, and the rest of it underneath it is clay, and so I think that's why we haven't had any water. But we can go in our backyard, and like one of the gentlemen said, in our case, 2 days later, you can see water running down, because our property has got a slope to it, running down that slope. 2 days later, you can still see it running on the ground. And so my wife showed that to me. I couldn't believe it. But so Phil has the right to put these houses in, I think, to develop them. But I really think it's a mistake. They can put their pond down there to hold the water and help divert the flow into the storm sewers and make that work. But I just don't think the ground is right for that kind of development back in there. In 30 years, I've seen a lot of carpets laid out into the streets or on the curbs because people have had leaky basements. And so I think that's what's going to happen. I think they're going to put sump pumps in, and that's going to work for a while. When first power outage and big rain they have, next thing you know, they're going to have water in the basement. It's just a problem that's going to just waiting to happen. So basically beyond that, 30 years ago, we bought this house. We liked the scenery and everything in the back, and back then there was a horse. But that's long gone now, but we still enjoy the view back there. There has been times where it hasn't been the prettiest view, and they've needed maintenance done back in that area too. But generally, people have worked at it a little bit at a time. But I bought that house. It was not a corner lot, And, you know, I don't expect anybody to raise a hand if I ask the question, but which one of you would want to have a corner lot after 30 years of living without one? You want to be a corner lot is my question. So I don't want to be a corner lot either.
Can you point out, so I make sure I'm thinking of the right property, where you're at on there?
We come out on Hillside, just the other side
Okay,
of where
good.
Royal is. There's a little house that's in the street right here. Hopefully you can see where I pointed. And Phil owns that. And I don't know, I mean, he's came over to our house before and offered to buy our house, and I'm assuming, in which we weren't going to do it, but I'm assuming that he's going to remove this house in phase 2, and that puts Royal's house on one side and mine on the other. And I agree with Royal. I don't see how they can get in there and do what they need to do to that area to build that road and pull that basement out with disturbing our basements also. And then it's going to be, can you prove it? And then it's going to be, who's responsible? So, and we'll be left holding the bag. That's the way I feel it is. So,
Any questions? Okay, thank you.
all right, thank you.
Here we have Elizabeth Terry and Dave Sabaka.
Good afternoon. My name is Elizabeth Terry. I live at 3427 South 48th Street, which is right there. And my husband, my oldest son, and my daughter spent last Saturday walking around the neighborhood getting the petition signed. And of everybody that signed it, or everybody that answered the door, only 2 did not sign it, including Phil's tenants. They also were more than willing to sign it, that they did not want this back there either. I also attached a letter on with that, on our dealings with Phil, that he says one thing to get his way, and then he turns around and does whatever he wants to begin with, whatever he wanted anyway. So, I mean, I don't have much to say other than all of the scientific studies that he says he's getting done and everything. I'm not sure where they're doing it because there's more traffic on Hillside than what they said. I watch it, I see it from my kitchen window every day. So my biggest concern is that there will be more traffic. I have kids that are outside playing all the time. And we do not live on a double wide lot, so they are out on Hillside biking and everything, and I don't want more traffic on there. I don't want more construction back there. I don't want it damaging more water flowing past ours, or, you know, more noise, because, you know, we have a quiet neighborhood. That's one reason why we bought the house. It's got the whole charm of the arts and crafts, and we like it there. We like it quiet. We don't want to move. And we took the time because we wanted you guys to see where us as a neighborhood stood in regards to this project. So, thank you.
Thank you.
Here we have Dave Sabaka.
Good afternoon. My name is Dave Sabatka. My address is 4635 High Street, which is, I don't know, it's not on the map, but it's right up in, right here. Oh, excuse me, over here.
Can you pull it down a little bit?
Oh, I'm sorry.
That's okay. There we go.
I'm nervous. It's right over here, and our backyard, and the Ken and Linda Bro, who lives right next to us, we're the victims of this flooding issue. We, before Phil moved in or took over the property, we had water, and then we had a small culvert that ran into the sewer. Well, ever since Phil moved in, there's a forest back there. You know, myself and our neighbors, we played back there. You know, there's deer, there's foxes, and thank goodness no coyotes, but that was, I mean, you walk there during the day, it was almost black time. Phil decided to cut down trees and made a pile right where the water would flow. Every time it would rain, that storm drainage would get clogged up by the floating sticks and debris. We have a trampoline in our backyard where the flooding was happening. The water got so high that our trampoline was covered by water. And Ken Bro, our next door neighbor, would be to our left. And if you would like to come out and I'll show you, he has a greenhouse. And we measured it 6 inches of water. And the line is still there from where the water. His basement flooded. I had to help him remove water from that basement. And by the way, before I forget, had it not been for Nancy, I wouldn't be here today because I never received a letter. So Nancy came to my door, said, "You're going to show up tomorrow." I had no idea. Of course. That's why I'm here. A couple concerns is that storm drain that they just put in, we fought many years to get that fixed. City came out, they did a great job. They removed that small culvert and they put a square culvert there. Well, wouldn't you know, it rained the other day really hard. Guess what was sitting in that culvert? Those sticks that are sitting back there. And I don't see how this is going to work if he wants to build a street behind our house after they just redone that storage sewer. And I like my privacy. I don't know about anybody else. And my mom had a daycare for 40 some years. We had to put a fence up, a chain link fence. But if we're gonna have a street behind our house, I want a privacy fence. I want a privacy fence in my whole backyard. Because I don't think it's fair that I'm losing my privacy because someone wants to build a road behind our houses. And I made the newspaper several years ago due to traffic on High Street and Hill Street. What I did was I put my truck in the street, I put a tricycle on it with a big baby, with a baby doll. And what I did was I put that tricycle behind my truck and it looks like a kid was coming out. And boy, that slowed down traffic like you would not believe. I made the newspaper. You know, the traffic is horrible. And another thing, I'm going down my notes here, that forest, he claimed that it was bad. It's not bad. It wasn't bad. And ever since when Phil took over, it's a mess back there, ladies and gentlemen. It's a mess. There's cut down trees, like I said, and then there's branches that float down that waterway. So it's just frustrating. Even though we got that new culvert fixed, we still have that debris from those little trees, that sticks and twigs and what have you. If they're going to put a road behind my house or my Ken and Linda's house, are they going to tear up that new culvert they put in? I don't understand how they're going to build a street over a culvert. It just doesn't make sense to me. I mean, you're going to have to redo it over and over. And our water problem, so does that mean our water's going to flood, or it's just frustrating. I do have pictures, but I deleted them because I didn't think it would come this far. I had a minivan back there, full of stuff, like a storage. That water went in my van all the way up to the passenger side, flooded my whole van, and pictures of my kids, just everything, destroyed it. I lost memories, I lost prized possessions I had for many years, gone. And with this new street, like I indicated before, I want my privacy. Everybody in our neighborhood likes that privacy. Who's to say that, there's going to be, they said, they estimated car movement. You can't estimate car movement down the street. You build these houses, who's to say, they're not going to have parties, or they're not going to have gatherings or friends over, which is fine. But on an average day, there's going to be cars coming and going. If you stand by my street on High Street, you see cars coming and going all the time. Delivery trucks, food trucks like Swans and what have you. It's just infallible to make an estimate on how many vehicles are going to be on that road. And with my pictures, we had this big, huge truck come out, and they could unclog it, the back culvert. So I don't want a road behind my house where there's going to be trash. Those houses are going to have parties, and I'm just making a scenario. I'm not going to say there is going to be parties or what have you. Yes, Phil did come to my parents' house, my house as well. He wanted to buy my house. He went to Ken and Linda Bros next door to buy their house. Having said that, with the access to our houses, he has a bigger opportunity to build that road and build anything that he wishes to. And at this point, nobody wants to. You heard everybody make a testimony. It's a water issue. It's this issue. It's so many issues that are playing a part in this. And it's like falling on deaf ears. I mean, we as neighbors, we've been in this house for 43 years, since I was in 3rd grade. We had fun. Yes, there was a horse back there. Yes, there was a rooster. We woke up every morning from that rooster. And Mr. Kess, who he passed away. Every day, he's making popcorn. He made popcorn like every day, made a whole neighborhood smell like popcorn. But now we're going to have exhaust smoke. We're going to have, trash laying around. I'm just speculating. People do litter, and that makes our neighborhood less in value, makes it look bad. It's a never ever going process if this road and houses get built. So, basically, that's all I have.
Okay, thank you.
Okay.
Okay, I believe we have one individual, Linda Bro, will be testifying in opposition via Zoom.
Hello? No.
Jerry, she's up.
Okay. Hello?
Go ahead, Linda.
Oh, I'm sorry. My husband and I, Kenny and Linda Bro, are doing this together, and we both have comments that we want to make. I have pointed out some, and I wrote a letter to whoever this planning commission.
I think they can hear it in there, but I'm not sure that we.
Oh,
yeah.
I wrote letter.
Hello?
Yes?
I'm sorry, we just got audio, so I hate to have you start over, but if you could do so, that would be most helpful. Thank you.
Yes, this is Linda Bro and Kenny Bro. We own 4625 High Street. And we had sent a letter, I don't know who we sent it to, but on what we felt was the basic things that we.
Are you still there?
Yes, we have that letter.
Okay, I'd like to reiterate, my husband would too. First of all, the safety with that street going through the back of our house. And I think Rachel did say that we would hear some of the noise with my emails with her, the traffic noise. We have heard that. We'll be hearing that. Lighting, the light is going to destroy our sleep habits and everything. Most of our bedrooms in the back where he wants to build his road is behind our house, all the houses. And I'm kind of just going in my lane here. We've lived in an established neighborhood for 45 years. And I think most people that own these houses have lived there for probably 30, 40, 50 years. And I don't understand why he wants to come in and destroy a neighborhood that is established, that has been established for all these years. And also my big concern is he's going to put in $200,000 homes. What's our property taxes are going to go up, but our house values will go down because of that street. Nobody will want to buy a house with the property values with a street behind your house. And also the road that he wants to build between 46th and 48th Street, who's to say they're not going to, from 48th to 46th, they're not going to go through there just for a shortcut. And as far as the traffic, you cannot tell people how many cars are going to go through there. And the flooding, we've had floods so bad that we had that one rain a couple years ago. We had rivers running through our house, 10 inches of water came into our basement, and the sewer line wouldn't even hold it. It was coming out the sewer line at the house on the street. And that's my concerns, and I think my husband wants to talk to you too. Hello?
Hello, hi, Mr. Bro.
My concern is water.
He said just a second.
On the line of the shed was 9 inches of water in my backyard. I can't grow a garden. In fact, when I grow a garden, it gets drowned out. And sometimes I get tomatoes, sometimes I don't, because it's gone. And it's just horrible. Water just keeps coming. And in this new rain after the culvert, you could see a 4-foot stream of water running to that culvert from up the hill. And that's not going to change. It's never going to change. All them houses that are built up there are going to have water damage. They can't in any way unless you put them on stilts. I don't think you want to do that. But that is my main concern. It's water, and I don't see how they're ever going to handle it. It's impossible to handle. It's just Mother Nature. So that's my concerns, and the traffic and the lighting. It's going to be a shortcut from Hillside. They'll miss the corner. They can get a shortcut back to Van Doren Street, on the way to Van Doren Street anyway. And like Mr. Zabaka said, the traffic on that street, I stand out there and people come roaring down there about 40, 50 miles an hour. Them kids from high school, that's a traffic rate. That's a racetrack for them. And it's not going to improve any. It's going to get worse. So that's my concern.
Okay.
Thank you very much.
Thank you.
Thank you.
I believe that's all we have for opposition.
Any other testimony in opposition? Okay, we're good back there. All right, staff questions. Anyone want to go first?
There's been a lot of concerns raised with regard to water issues in the area, and I think we need to go into a lot more detail on the work that you've done to clarify that.
Well, what I can say on that is we have watershed management staff who've looked at this, and there is a condition of approval in the staff report, and so they will require a number of changes to be made. They felt like it was in good enough shape to go ahead, but there will be some final changes they need to make for that.
To meet the requirements of watershed management.
Correct.
Okay.
In general, they're not allowed to put additional water onto neighboring properties. That's the standard they would be held to here.
Right, but how are they gonna mitigate, you know, I'm pretty familiar with this site, so, you know, it is a basin. And how are they gonna mitigate all that runoff? Oh, Steve's telling me to wait a minute.
Steve Henderson with the Planning Department. Tim Zock with Watershed Management. We hope, he's here right now.
Great.
So I'd
Awesome.
like him to address those kind of questions.
That'd be
I think he
awesome.
could give you the bigger picture.
Thanks, Steve.
Yes, Tim Zock with Watershed.
Hi. So we have a lot of concerns about the water and the drainage into this property because it kind of acts like a basin there. Can you tell us what needs to happen in order for us to alleviate some of that flooding issue?
So in our review, we're requiring that, as one of the conditions, is they show that the water leaving their site, entering that pipe that we recently constructed, that they don't, the amount of water they let off their site doesn't exceed that pipe's capacity. So that road they're proposing is kind of built up, and behind that road is the detention to the south. And so we'll be requiring that detention holds back enough water so that it doesn't cause any issues leaving the site to the north.
But what about the drainage that's already coming from the south from the Union Bank parking lot down into this
That'll all
valley?
go directly into the detention cell.
And it will be large enough to hold all that runoff?
That's what, they have to make some corrections to their detention cell. And that's one of our conditions, that they show that it will be large enough.
And I'm not sure if you're gonna know the answer to this, but in that paved alley, there is a grate. Who is responsible for maintaining that grate from debris or making sure that it doesn't get clogged?
Is that south of Hillside? I'm not familiar specifically with that.
Sure, let me, so the Union Bank parking lot is paved, and then there's an alley that runs east-west, and it's about, I'd say, halfway paved between 46th and 48th.
Okay.
There is, it kind of funnels down like
Yeah.
this, and then there's a grate in the middle there. And so this would be to the south of this site.
Yeah.
So kind of, there's Hillside, and then there's the alley that goes
Okay, yeah.
through there.
I believe our street maintenance will be responsible for maintaining the alleyway.
Okay,
That
I wasn't
area.
sure, because I know that property owners are responsible, you know, like half and half, but I didn't know with this drainage grate in there, if that is something the city maintains, or if that's something that the property owner would be responsible for on either
I
side.
guess if it's a public, is it public alleyway, or is it a private property? That's kind of, if it's public, then the street maintenance would be the ones responsible for maintaining that. But if it's private, then it would be whoever owns that
Okay,
system,
which would
that lot.
okay. So watershed management isn't concerned with the amount of runoff that's happening and flowing into that basin from the south?
So like they have to revise their drainage report and their detention and their grading to address our concerns. And we're looking at it really closely, making sure that they're not increasing any runoff more than what there is. And so we still have to see a revised drainage report showing that they're going to meet those concerns and not back up water onto the property to the south, and also not increase runoff to the north.
Now you mentioned about the new pipe that you put in there. Is that the same, you know, the neighbors have been talking about a culvert. Is that in the same location, or is that something different?
So we had two parts to the project, one at High Street, putting in a larger culvert so water enters that pipe and then goes into the storm drain system to the north. And then we extended a pipe on the south end at Hillside. And so that kind of, the water in the pipe is extended farther, so it comes out of the pipe a little bit farther north than what it did.
Can you talk too about, several of the neighbors mentioned, it'll be several days after a rain event that they're still seeing, you know, water flowing through this area. Can you maybe explain how that happens?
I guess I can a little bit. I'll try to explain that, but I'm not familiar with the specifics of the area. But it could just be from groundwater that's like the ground gets saturated and then water is just kind of trickling out. Or it could be that there are areas that we're ponding and they're just kind of slowly draining out. And then we see, like, from irrigation, people watering their lawns, that there's some areas that are just constantly trickling with water.
Does it matter what kind of soil type that is in there? I mean, like, so if it's more clay, is that why it's bubbling up more? I don't know if that makes any sense.
That I'm not quite familiar with. So.
Dick, did you have a question?
Nope.
No, I thought you were
Sorry.
flagging me down. Okay.
Nope.
Any other questions for watershed management while he's here? No? Okay, thank you for coming down.
Thank you.
More questions for Rachel? You can catch them on the way out. More questions for Rachel?
I have a question, Rachel.
Yes.
So the drawing, the engineering drawing that we were provided doesn't show the hammerhead at the end of the first phase street. My question is related more to emergency vehicle access and the ability to, you know, if a fire truck has to come down that street, the hammerhead, do they have to back out, or are you the right person? Can you talk to that?
I couldn't speak to what they would actually do with their trucks. At the time of the final plat, they will be required to build that hammerhead he talked about. So just, you know, it may not be shown, but that's the standard requirement at the end of a dead-end street.
And then the hammerhead would be designed to allow an emergency vehicle to be able to make that maneuver to get back out. Is that?
It could assist with that, certainly. You know, the fire department has standards and dimensions that they apply for how big of a truck they can get in and out of places.
Okay. Okay.
So I'm not sure about that, but they didn't express any concerns on this application.
Okay.
So the only waivers that are in place with regard to this special permit are the setbacks, the block length, and then the lot area with regard to a couple of the lots. Is that correct?
Correct, as well as the sanitary sewer.
The sanitary sewer.
Design standard.
Can you tell me a little bit more about that sanitary sewer situation? So they were saying that the lots are, so they're gonna divert, you know, like lots or 1, 2, and 3, instead of taking it from 46th Street, they're gonna now take it from Peanut Hill Road, is that?
Yes, the lots that border along 46th and 48th Street will ultimately have their sewer connections redone to take access to the new sewer line that will go through the new street. So their connections will run through the new lots in the middle to connect to that sewer line, and so they'll have non-abutting easements for that. And the reason for that is, you know, currently the sewer line runs up through the middle of this block. So with the changes, they would need to redo the sewer design.
Okay, so now I think that's, when you said that last sentence, that kind of made more sense. So the sewer right now is going through, say, where
Yes.
47th Street would be if it was there.
That's correct.
Okay, and so they're just moving it to Peanut Hill Road or Trolley Lane. Okay, thank you. Sorry, we can't take questions from you guys. Other questions for Rachel right now? I have a question. And I know this is more for phase 2, but some of the neighbors brought it up. The trolley lane is showing connecting through Hillside there. Is that residential lot wide enough to accommodate that whole street there, or would they have to take, would they have to have easements, or would they have to have property from those two sides?
I think we would look at that at the time it came in. The standard right away, for a public street, which this presumably would be if it continued, is I think 60 feet right away. So, they'd have to show how they met that, as well as the pavement width. Perhaps LTU would consider waivers to that if they didn't meet it. But the details of that, as we've talked about, aren't being presented or discussed at this time.
Can you talk about, are there any screening requirements, like along the Outlot B or Outlot A or anything like that?
Along the north side of the roadway there.
Mm-hmm.
Not that I'm aware of. We've had cases where when a road ends, we've required screening because of the headlights from a car turning around there could be an issue, but here I don't believe there'd be any required screening.
And I'm not sure if you'll know the answer to this, but maybe Bob, I'm not sure. This new culvert that they put in, is that going to be, will they have to reconstruct that or anything when they're doing this new street? Will that be affected at all?
That is probably a better question for LTU, if they could.
He's
answer that
hovering
one.
back there, I think, waiting. Or did he go back upstairs? No?
While Bob's coming up, a quick question about trees in the area. Will there be significant tree removal required in order for this road to go in? It looks like there will be. Is that correct?
Yeah, I'm sure they'll have to remove trees in this area. The applicant might be able to speak to in detail if there's any they'll be able to keep.
Okay, thanks.
Bob Simmering, LTU.
So I understand that the city, not you yourself, I guess, put in a new culvert along High Street, maybe about 46th Street. With this new project, will that disturb this culvert? Will it have to be rebuilt or anything like that?
They'll have to include that in all of their calculations that Watershed considers. So if it needs rebuilt, that would be their responsibility. If it does not, then it can be used as is. But all those calculations need to be submitted to our Watershed Management Group.
And so that would be the developer's responsibility if it needs to be in their cost then?
Correct.
I don't know if you're the appropriate person to ask for this one. Some neighbors were concerned about when they bring in the heavy construction traffic, if that would affect, like the existing sewer lines, stuff like that. Can you address that concern?
Well, obviously, they're going to have to rebuild the sewer line through the subdivision. And after that's built, we do a video inspection of all the sewers. So we would find out if damage had been done to that. And if damage is done during their construction project, they're responsible to repair that.
Okay. Thank you. Any other questions for?
I have a question for Rachel. Sorry.
Okay. I think you're off the hot seat, Bob,
You're
unless,
done.
okay.
Sorry, Rachel. I'm going to try to word this eloquently. But my question is, I do see that there's conditional approval, but in response to the comprehensive plan of the city, is there any fear of the low-income housing or affordable housing being taken away, and the changes with the new developments and the socioeconomic backgrounds of the community that might be coming in?
Sure. In general, we don't look at property values or try to estimate what might happen with those. For these types of applications, we really just look at land use.
Okay.
In general, infill projects increase the supply of housing and a lot of times take advantage of existing infrastructure. So in those ways, they could potentially add to that and increase the overall supply. Otherwise, I don't know that I can speak to that any more specifically.
Rachel, did you attend the June 2nd meeting?
Yes.
You know, I asked the developer some questions about, you know, neighborhood concerns. Do you think that his responses were accurate?
Yes. The main concerns that came up at the meeting, a lot of questions about drainage, some questions about phase 2 for those people who are shown within phase 2. Were the main concerns, and, you know, generally effects on property for those who are adjacent to the project.
Thank you. Any other staff questions right now? Make sure I got all mine this time. I think I'm good. Okay, applicant rebuttal.
I took a few notes while we were sitting there, and one thing I did want to reiterate is the justification for recommendation that this is an infill project, and it does use up underutilized property and is within the comprehensive plan. Couple things, the lighting would be designed by Lincoln Electric System, and there are city standards for light pollution to go across the property line. So that would, once you get past the property line, the light levels drop way off. So that's one thing I just want to address. Again, going back to the traffic, we had sent the plans and everything. You're only seeing one drawing. There's multiple plans that go to the city for review, and traffic, and everybody else looks at the plan, looks at where the location for the street ties into 46th Street. So all those things were taken care of. The sanitary sewer was reviewed by Brian Kramer, and we talked with Bob and everybody about the non-abutting agreements. We have a plan worked out to make that work. The storm sewer, there's a question about flooding the adjacent houses, and maybe Tim can maybe address this also, or if you need to ask him, is that the detention cell will be 5 feet or so below the adjacent house. And the criteria is that we have to be 1 foot above with any opening into the dwelling for the 100-year storm. And so we meet that criteria. So, and then I guess I just want to weigh in a little bit about the water that we tried to talk about, metering out. You know, this watershed goes north into other parking lots and stuff. So, you know, if there's water standing in some parking lot, it takes time to drain out. You're going to see over a period of a few days water that's coming off a different property that's coming through your property. So it doesn't necessarily mean the water is physically from your neighborhood. It could be coming from the south. Again, the layout was approved by the city, conditional approval, and we are working through the stormwater regulations. One thing that we did do, and I don't know if this was brought up, is we did give up a lot just because we were looking at maybe doing some drainage detention on one of Phil's properties to the south, and through discussions, that was abandoned. We gave up a lot to increase the size of the detention cell. So.
Do you want to talk a little bit about the trees that will need to be removed? Do you have a kind of a general sense
Yeah,
of what
I mean,
that looks like?
Phil's, he spoke the other night at the meeting that his intention is not to tear out the trees, just to remove the ones that are necessary to build foundations or parking or streets, but to keep the majority of the trees there.
Could I address that?
Sure.
I did we have a aerial view that the CUP plot is laid over the top. I counted 20 trees that are going to come out because that's where the road is. Most of those trees are volunteer. There's one old mulberry tree that was a volunteer, and it's going to come out, but it's about ready to fall down anyway. It's at the end of its life. The rest of them are Chinese elms or whatever, Asian elms. And they're anywhere from 4 or 5 inches to maybe 8 inches big. And they're in a cluster. I can show you where they're at, but it's right at where Trolley Road begins, where you turn and go south. They're all, from my estimation, and I don't know what's going to happen because of moving earth. Some trees may have to go because if you cover up the bottom of a trunk of a tree with dirt, it'll die. And so those trees will have to be removed. And I counted 7 that I know that the house on the lot, if it's built, going to have to take the tree out because that's where the house is going to go. My draft covenants require 1 deciduous or conifer tree of at least 3 inches on every 2,500 square foot of lot. And so there will be some trees that are moved, that are capable of being moved. They're not old enough yet that they wouldn't survive a move. So my vision is to have many of the trees are in the outlot where the detention pond is, and they will be left unless they have to be taken out just to get the hole bigger. But all the trees on the upper level of that, I will leave those. It's not my intention to cut down any tree I don't have to.
Thank you.
Will you guys have to bring in fill dirt to bring up?
Right now, with the excavation for the detention cell, the basements, grading, I think we're just about balanced, that we won't have to bring any material in, but, you know, depending on the trees, if they come out and you got the tree ball, you have to remove, we have to account for that.
So just basically kind of redistributing.
Right.
Okay. Other questions for the applicant? Okay, thank you.
I would move that we close the public hearing.
Second, Albadri.
Jerry?
Okay, Albadre,
Yes.
Campbell,
Yes.
Edgerton,
Yes.
Joy,
Yes.
Shear,
Yes.
Core.
Yes.
Motion carried 6-0.
I'd entertain a motion.
Move approval.
I'll second. Sure.
Discussion.
Yeah, one of our overriding things is infill and getting proper infill. And I can empathize with the people that have lived there 30 to 50 years. And you don't like to see change to what's been there for almost half your life at least. And, but I think there has been good planning by the developer. I would encourage that they do some screening on Outlot B and Outlot A, just to create a little separation and we'll recreate some of the privacy if there aren't trees there already. But will be supporting the motion.
Our certainly the waivers that are in front of us with regard to this special permit do provide some flexibility with the space. All of this space has been brought together, and the waivers are relatively minimal. You know, we've tried to address the issues, and we've talked a lot about the flooding concerns, and there is a new culvert and the sanitary sewer design standards, and all of that seems to be in order. I will be supporting this as well.
I'll make a few comments. I think everyone should remember that we're voting on a special permit, and this special permit has a lot of conditions attached to it. So there are a lot of things that need to get worked out. We've talked about some of those in our discussion, but there's a lot to cook here yet. But I agree with my fellow commissioners in terms of the comments about infill and how that really is responsive to our existing comprehensive plan. And I agree with that concept in our plan, and with the comments that have been made. A couple things I do want to point out. We're voting on phase one. There's been a lot of testimony about phase two. Phase two is not relevant right now. And all of you who are worried about phase two going ahead, like someone can do something with your property that you own, that ain't gonna happen unless that property gets purchased somehow. So my vote is conditioned on the fact that we're only dealing with phase one at this point, and that's all we're dealing with. Anything beyond that comes back through the process, and there'll be plenty of comment, and a lot of things have to happen for phase two to even start. One thing about phase one that I think is good is that from my count, and somebody else can check me on this, but from my count, I believe that there are only 2 existing properties that will be affected by an additional lot. I think there's only 2, and the way I'm looking at the drawing right now, one of those properties, the additional lot, comes to the existing property line of the existing property owner at a point. So there's I'm not saying that there's no impact, but the impacts actually, because of the outlots, are diminished to a certain degree. And either Tracy or Dick talked about outlaw A and outlaw B and how it would be helpful to have some landscaping on that. I think that's a good comment. So I'm going to go ahead and support the motion, but I'm supporting phase one, and we'll see what happens in the future on phase two, if anything.
Go ahead.
I really appreciate everyone taking the time today to come and talk about your neighborhood. It's really important to us to hear all of that. And as my fellow commissioners have mentioned, we're focusing on phase one, and we're really focused on the land use and showing and making comments so that you as a neighbor are protected. We reduce the impact to your properties. And we do appreciate, though, the time that you've spent. I will be supporting the motion, and as my fellow Commissioner Scheer mentioned, this is a phase one option, and we will be watching that also from the conditions that are put on this project. But as good faith, we do recognize our engineer is a very good engineer in our city, and our city does really take care in protecting those neighbors as things go. We're not as familiar with the developer, but we're hoping that as a good neighbor that he reaches out to all of you and continues to pursue that.
This is a tough one for me. I have I'm familiar with this area. Some of the things that go through my mind is that they could put 31 dwelling units in this area. That's a lot. And so they're only asking for 17, and 8 of those are existing. I think that this property will develop at some point, and this is probably a lower use than what it could be, so it could be much worse. But I do completely understand your concerns about water. I'm very familiar with how this topography in this area, and I share your concerns. But I think we have to look at it this is just phase one, and this we're just looking at land use. But I would, and I'm not really sure how to do this, so I'm sure you guys will correct me however I do it. I would like to offer a friendly amendment that we do put in a condition that they put in some screening along outlet A and outlet B. I don't know, do I amend this now? Sorry, Tim.
Tim C., City Law Department. You have a motion on the floor at this time with a second. In order to make an amendment to that, you need to offer the amendment. If you get a second, then you would discuss the motion, vote on the motion to amend. Once the motion to amend has been resolved, either it's approved or not approved, then you would move on to the main motion at that time.
So I can make a motion to add a site-specific condition to add screening along outlots A and B.
You could make that motion.
I would second it.
So now we can discuss that.
It's awfully vague.
I know. I'm sorry. I'm bad
Well,
at
there
making
are
motions.
there are city standards for screening.
Okay.
And it would require the evergreens to be at a minimum of 4 foot tall going in, and on shade trees or any deciduous tree, it's 1.5 inch caliper. So that's the very bottom level of screening, and so consequently, generally it's a combination of deciduous and evergreen. And once you know what's existing there already, then it could be determined what should be added to.
And I'm not sure it would have to be living trees. It could be maybe a fence.
Yeah, it could be a fence.
Yeah, Tim C.
Sorry.
against city law. I just want to caution you against referring to design standards because there are no applicable design standards for a screening like this. And so for us to say applicable design standards, the applicable design standards don't exist. So we shouldn't be referring to that. If we're going to make a motion for screening, it should be specific enough that it's clear to everybody to understand.
Thank you.
Do you want to amend your motion?
Yeah, that's what I'm
to-
debating here.
Why don't you amend it to that it must follow the screening design standards that exist for screening along streets and parking lots and things like that.
If we're discussing, I think you should include parking lots, because I think the way the concern about this street next to those existing residential lots would be similar to the concern we would have as a commission for a residential lot backing up to a parking lot. I mean, it's the same kind of condition, so that'd be as close as we have to something that is already on the books for a design standard, I would think.
So you're suggesting that we amend the motion to put, to design the screening requirements similar to a parking lot screening?
To what the city has in place for design standards for parking lots. That gives at least some specificity to, providing screening.
And if you make that, that's what you add to yours, I would second it.
Any discussion from this side?
A little less vague.
The only thing I was thinking is that if you're going to protect on outlot A and B, do you do the same on the other two properties?
Can you tell me which properties you're looking at?
Well, if you look at outlot C and outlot E, I don't know if we need to do it concurrent to the other properties in the drive.
Well, Outlet C is going to be where the detention basin is.
Right, so that should be,
What does the motion say?
right, it should be
Oh, I
landscape and be nice there.
And
Yeah.
I'm not sure Outlet E is really in
Design
this
standards used
phase.
for parking lots. Following the screening design standards used for parking lots.
Off of lot 5.
Yeah, it's not in this.
But it would go with the parking standards at the end of the hammerhead. That's up to you, though, on your motion, we can talk more about it, but that would be my only other comment if you're going to amend your amendment. But it's up to you.
I would like to amend my amendment, holy smokes, so that we put in, to make it a little more detailed and say, as required by parking lot standards.
And I would second that.
More discussion.
Nothing for me. I mean, that seems reasonable from what Commissioner Shear.
So do we want to
Vote on the amendment.
vote on the amendment to the amendment?
Mhm.
Okay. Jerry, I think we're ready for that one.
Okay, so just so that I'm clear.
Yep.
So this is an amendment to add a screening along outlot A and B to meet the designs that are followed by parking lot design standards. Something to that
Yes.
effect, okay.
But we'd have to vote on the amendment to the amendment, and then the amendment to the, don't you have to double vote there?
I think we pulled the first one.
Oh, you pulled it, never mind. Okay, thank you.
Tim says yes. Okay.
Yes, we're good?
Yes, I think so.
Okay, this is on the amendment. Albadre,
Yes.
Edgerton,
No.
Joy,
Yes.
Shear,
Yes?
Core,
Yes.
and Campbell. I'm sorry, I missed you.
Yes,
Okay, motion carried 5-1.
So now we're back to the original approval of the special
Motion,
permit.
conditional approval as amended.
Any more discussion on that part? Okay, I think we're ready, Jerry.
Okay. Albadre,
Yes.
Campbell,
yes,
Edgerton,
Yes.
Joy,
Yes.
Shear,
Yes.
and Core.
Yes.
Motion carried 6-0.
Do we need a break? Okay, let's take a 7-minute break. So we'll come back at 25 after.
place here, is item 4.3A, annexation 20009 to annex approximately 61 acres, more or less, and adjacent right-of-way, and the associated change of zone 20017 from AG Agricultural District to R3 PUD for up to 506 dwelling units and 120,000 square feet of commercial floor area with associated adjustments to the zoning and design ordinance or subdivision ordinance. Both property generally located at the northwest corner of South 40th Street and Rokeby Road. Staff recommendation for the annexation is conditional approval. Staff recommendation for the change of zone is approval. Are there any ex parte communications to be disclosed on these items?
No.
Are there any ex parte communications that took place or additional information you learned while visiting the site to be disclosed?
I don't see any. Okay, Brian.
Good afternoon, Brian Will, Planning Department. So I've thrown the exhibit up here on the viewer. So I can show everybody where we're talking about. This is northwest of the intersection of South 40th Street and Rokeby Road. Approximately 60 acres laying in here. It's just south of the drainage that extends through this area here. The development that you're going to hear about shortly is the community unit plan on the west side. Separate application that'll be dealt with separately in a minute. So this one, two associated applications, the annexation and then the change of zone, which is to R3 for a PUD, planned unit development overlay. As we look at this map here, and sorry, but the resolution isn't that good, but what it shows is that this property is contiguous to the city limit. All utilities and city services would be available to serve this property. And it is adjacent to B2 commercial zoning to the north, but R3 to the east, and then R3 to the sort of to the north and to the west. So as we look at this land where it falls in the future land use map and the growth tiers in the city, we find that it meets the comprehensive plans policy for annexation. And so in that respect, we're recommending approval of the annexation. The change of zone which is essentially to allow the development that's shown here. As was noted, it would allow up to 120,000 square feet of commercial floor area and just a little over 500 dwelling units. So the way that it's laid out here is there's some commercial here that looks like your sort of typical neighborhood commercial near an intersection here, and then over on the west side there is one commercial lot here and then this portion. And so as it was originally understood anyway, that there was going to be essentially B2 commercial uses here and then mini storage. I think when the applicant gets up, the applicant has a motion to amend that essentially allows B2 uses over all of these areas, including mini storage over all those areas as well. Planning staff, we've reviewed that recommendation and are fine with it, don't have any issue with it. There are a couple of adjustments that go along with the PUD. The first one is adjusting setbacks internal to the development to 0, which is actually pretty typical, actually already allowed by right in many of the zoning districts. What we want to be careful though is to make sure that we maintain a perimeter setback. And so the note as we're suggesting it be written, have the site plan show 20-foot perimeter setback. And then to the north where it's adjacent to the drainage way, which is under a conservation easement, maintain at least a 6-foot setback in that area. A 6-foot setback would be consistent with what we find adjacent to parking lots and have it screened accordingly. Second adjustment is to height, and that is for the multifamily or the apartments that are shown here. And that adjustment is from 35 feet, that would be the typical height limit in R3, but can be adjusted with a PUD to 55 feet. And given the separation from other uses in the area and adjacency to what will be commercial uses, the planning department is supporting that height waiver as well. I think as you've seen recently over the last couple of years with a lot of apartment complexes, it's getting pretty typical to go to 55 plus or 50 plus feet for apartments. The report talked about a land exchange that this plan assumes happening, and the applicant can speak to that. All I would note is, my understanding at this point is it looks like that may not be happening, and so this site plan may wind up being modified in the end. But what it's talking about is a little parcel here that was to be exchanged for a little strip here. And so what it did, it made a more logical development here for the PUD, and then what is otherwise a developable lot here would be set aside as part of the conservation easement. Like I said, it doesn't look like that's probably going to occur, so I think ultimately there is going to be some amendment to this plan. I don't know that any suggestion is going to be made today to do that, but because I talked about it, I just want to explain what that related to. Probably maybe the most significant departure from the original preliminary plat was the extension here, or the connection of South 34th Street, which is not shown. What is shown instead is a pedestrian connection through this development, connecting the sidewalk system in Rokeby Road to the sidewalk system in Wilderness Hills, as well as the trail system along the drainage. It was by mutual agreement on the part of the developer, the city of Lincoln, that street connection not be made. And so this plan has deleted that street connection. So with that, there are conditions of approval, and subject to those conditions of approval, the planning department is supporting this change of zone for an R3 PUD. So with that, I'd be happy to answer any questions that you might have. Maybe before we do that, I just want to mention one other thing. We did get by email comments from Mr. Dale Doenhauer. I'm sorry if I got the last name wrong. Home address is 9300 South 32nd Street, and had objections to the plan that was being presented. His objections primarily were to deleting the street connection and allowing a pedestrian connection instead, and also to the height waiver for the apartments to be allowed to go to 55 feet. So with that, I'd be happy to answer any questions.
Go ahead, Christy.
On the street access, is that a recommendation of you or a request from the?
That to not make the street connection.
Right.
That was a decision reached collectively prior to this application being submitted. There had been discussions among the developer, the owner, and the city about that.
Mm-hmm.
I mean, it's been it's been an issue, that street, whether it's going to be connected or not. It's been an issue for a while. But yes, there have been there've been meetings among the city and the owner, and it was by mutual agreement not to require that connection.
So it is an entry into the development and then it kind of stops.
Yes, it just, so it's on here, on the exhibit here, it essentially comes into this point here, and then you go left or right.
Okay.
It stops at the edge. From there, it's only a pedestrian connection.
And is it on this, is 34th Street on the, come from the south of Rokeby? Then is it a street on the south side of Rokeby?
At this time, no.
It is not,
No,
okay.
At this time, no.
Thank you.
But they've made the road in the development across, right? That you're having the sidewalk connect to? That road
On the south side?
on the north side, where 46th, or wait, what number is
Here,
that?
you mean up in here?
Yeah, that road exists now,
Yes,
doesn't it?
this exists up here.
And it comes down to the
this
edge of
point
their
here.
property.
Yeah, so there's a little stub that's been constructed there. I think, actually, I don't know the disposition of that. I'd understood potentially that what paved surfaces there would be removed and it'd be opened up as green space, but
Oh, okay.
perhaps maybe the owner's, Brad Marshall is here for the owner, maybe he can speak to that.
Can you point out for me, there was some discussion of the neighborhood park, and if you can, on the other map perhaps, point out to me, remind me where the school is going with regard to this property? Thank you.
Yeah, well, so the neighborhood park was gonna be in this area
Okay.
here. And without the street connection, it seemed that at that point, you know, accessibility to the larger neighborhood would be, well, you couldn't drive there, it'd be cut off, you'd only have pedestrian access. So I think for multiple reasons, it was agreed that moving that park to what is gonna be the school site up here,
Okay.
which is actually gonna be on kind of the southern, south edge of it here, that made better sense. It's more centrally located. Without this street connection, it will be more accessible. The developer is making a contribution to help to get that park built and created. Now, that park's not gonna be built today or tomorrow. I can tell you the funding for that park is in the one of the 6 capital improvements program, but the timing of it is not certain.
Thank you.
Brian, I have maybe kind of a weird question. Why are we calling this an R3 PUD when none of the underlying uses are gonna be an R3 use?
Yeah.
A good question.
Well,
I'm like,
yeah.
I was a little confused, but I was like, maybe there's some reason I don't.
We try to have the underlying zoning match what we're, I guess, the primary component of the PUD, or at least match what is in the area. Here's the thing, when it comes down to it, the underlying zoning in the PUD, I gotta be honest with you, it really doesn't matter a whole lot, because what we wind up doing is writing a whole new set of zoning regulations for that development, which is exactly what we've done here. We're allowing R5 uses in one part and B2 uses in another part. And so the reality of it is, whether it's R3 or B5, the fact is it's going to be multifamily and the commercial. So, like I said, we try to maintain consistency. In this case, the vast majority of Wilderness Hills, the residential part, is R3. And so I think extending that down through here was the start point for this discussion. No real compelling reason to say R5, B2, or anything else. So that's it.
I know that there was a letter, and I can't remember if it's for this particular development or the one right next door, but they were talking about connectivity to the east and to the school, and so by not adding in that South 34th Street in there, they were concerned that there wasn't good connection to that future elementary school.
Well, yeah, I mean, yeah, as you look where this connection would have gone, South 34th Street down to Rokeby Road, I mean, obviously, that's another connection to an arterial street out of the neighborhood. I mean, I mean, that part of it makes sense to me, that if I live in this area, getting out of there, it's maybe going to be a little more inconvenient. I'm not sure that coming in this way to get to that school, at least at this point, makes as much sense. There's just not as much traffic, I don't think, that's going to be coming from the south for quite some time. I think it's predominantly from the east and the west. But there's no denying that doing without another connection to the adjacent arterial street, and there's no way I'm going to stand here and argue that that's some advantage. I mean, it does inhibit access, no doubt. It's just, I think in this case, there were just larger concerns, and when it came to crossing this drainage, the constraints that were involved, the long-term maintenance responsibility on the part of the city are really what went into making that decision not to require it.
This was contingent on NRD approval, is that correct?
Well, yes, because what there is, that's what I was talking about earlier, it's a little land swap between this and this little sliver here. If that and I think the NRD has spoken, so if that doesn't occur, this plan ultimately, when it gets done, City Council is going to have to be revised to kind of go back.
Got it.
Other questions for Mr. Will right now? Okay, applicant.
I do have a motion to amend. Should I pass this around? I can at least get this in their hands. Thank you.
Brian, can I get a copy of that as well?
Yes.
Thank you.
Well, good afternoon. Brad Marshall with Olson. I am here to talk about the Wilderness Hills development. It originally was approved in 2006, and Olson helped amend it in 2018. And I bring up 2006, that's important because at the same time there was a settlement agreement that dedicated conservation easement and set some of the guidelines for the development that we're going to talk about here. Specifically with the parkland and this land exchange that we had a concept proposal to the NRD about.
Thank you, Brian.
I'm going to just show the plan from 2006, 2018. So this is generally the plan that was included. It was a preliminary plat. Zoning was R3. And it did include the particular area that we have in the PUD before you now. It was designated as townhomes and multifamily, but no details were provided at the time that it was submitted, and the amendment didn't provide any additional details at the time either. And so we are bringing forward the changes, particularly because of a lot of the development in that area, and this particular developer participating in future improvements to Rokeby Road and entering agreement with the city for those. And so this development will help pay for some of the improvements that Lincoln Federal Bancorp would be agreeing to. well, that does not show up very well. I don't know if I can, the color is not showing up very well.
Finger in there and it should auto.
Okay, well, yeah.
Little trick I
Little
learned.
tricks, no. So there really are two different colors here, and when Brian outlined, as part of my motion to amend, Brian and I talked about the darker kind of orange color, if you will, are these B2 areas that we propose. The original was to bring in a portion of A4 for the mini warehousing, but making this a little bit more simplistic moving forward and changes and being a little more flexible, which is one of the reasons we've chosen the PUD, is to add the warehousing to that as an allowable use in the B2 area. And so those areas are highlighted in this darker orange. The R5 is the remaining lighter yellow. Tracy, you had a very good question on why we had a R3 PUD when it's not the dominant zoning. I guess you could blame me for that. But I did think that there would be some anxiety with this originally being an R3 zone, and a lot of the conservation easement is extended beyond this and abutting residential, and so maintaining that underlying R3 adjacent to what is actually built and out there for the development was my thinking of keeping the R3 adjacent to them and then allowing that R3 buffer between the two developments and where development actually take place. And so, right or wrong, that was the thinking behind it, was that we could provide some comfort, I guess, to the people that are living there that would be maintained as R3. The waivers Brian went over, Wilderness Heights, Wilderness Creek have very similar height waivers for the multifamily, again, to provide some flexibility for 3- and 4-story buildings, and then the internal setbacks, which we talked about on the perimeter, maintaining the underlying zoning, and then the internal setbacks being changed. The parkland was part of this settle agreement from 2006, and included, I believe, 3.06 acres. There was a purchase for parks when they were to acquire that property. I believe it was roughly about $172,000, and that was shown in just west of where the 34th Street connection would be located. Upon preparing for this, we actually went to the HOA about a year ago. We talked about some of the major changes, that South 34th Street, the park, and one of the benefits that was proposed from the park side of things is that we could actually get a park built sooner. The developer, without extending 34th Street, would actually donate the land to Parks. Parks would have otherwise paid for that property $172,000 with impact fees. The $172,000 probably would be of this entire development. And once they own the land, then they have the expenditures to actually the equipment and so forth, $20,000, $30,000 on top of that they would not have, which would delay the actual park construction. With the donating of the land, they can actually utilize the impact fees to build the equipment. As Brian had said, in talking with Sarah Hartzell, the Parks and Rec Department, that would expedite that park actually being built. So one of the things we heard last year at this meeting was we don't really understand why we're going to have a park on Rokeby Road when it's going to serve our development. A lot of history goes back to 2006 of why the location was settled upon. But Parks came back recently, and as part of this proposal, they talked to LPS about co-locating their parkland up at their property, and we have come to an agreement to that. The developer would donate 3 residential lots up there adjacent to that would otherwise been platted with the property, and in return the developer would get that property along Rokeby Road. So 34th Street is part of this overall deal. One of these things that has changed in the way we look at development and development drainage over the years, again, another 15 years has changed. We're seeing bigger storms. We're seeing a trend to accommodate larger rainfall events. Though that data being actually increased, so that and that really was happened since 2006 to when we went through a major amendment in 2018. And so, as Brian alluded to, the developer, Olson, and the city and city staff have been talking about the elimination of 34th Street. And in lieu, provide a pedestrian trail to connect the development and this development along Rokeby Road, which would then have the ability to connect Iron Ridge, which is on the south side, and so forth. The developer would incur all the costs still for that pedestrian connection from the north to the future location of the Cabot Trail, and then a connector down to the PUD area. And that's all kind of shown here in red, which would include also still a sizable, I guess, culvert. It would be a box culvert for that crossing to meet the park standards for maintaining some level of trail in this particular area. So the drainage study was a pretty major overhaul in 2018. The drainage study would be manipulated and modified to show the culvert instead of a major roadway. And there are some benefits from a floodplain perspective. It does bring that back down a little bit. I'm not saying it's a big major change, drastic, but there are some small benefits there. That's I guess what would be proposed from the development side of things, is still providing some type of connectivity. The Cabot Trail, which would extend from Yankee Hill, we'd have to ask parts exactly, but I think the last time I talked to Sarah, there's probably 4 or 5 different developments are in front of this one, but that's not too bad considering where funding could come and get that trail built as well. So one of the last things I want to talk about is the NRD exchange. It was a proposal. There is this unique little parcel of land that's divided by, there's the drainageway on the north, there's drainageway on the south, and it has access to 40th Street. The 2006 settlement agreement says that it can be developed, but there is very limited uses, particularly like cell towers, very low generation of trips, which the settlement agreement puts at 10. And so our concept, a concept that came out of this was that maybe the NRD would like an exchange for that parcel to be dedicated. The developer would do some enhancements, excavate it, get some flood storage volume, plant prairie grass for water quality, and in return, we actually offered a 2-to-1 ratio. We would give twice the amount of land as we would get in return. Adjacent to this, there was a sliver here that kind of just make it more symmetrical and in line for the development here. However, at subcommittee last night for the NRD board, the idea was pitched around, it was actually rejected, the concept was, and so talking to the developer today, we'll probably pull that proposal from the NRD, and from here, we do need to modify our settlement agreement There are things with the 34th Street crossing, with the trail, with the parkland exchange and so forth, that talking to planning, I feel like we can include that parcel as part of this overall PUD and come to that. I don't think it's a major change in here. We could probably include that in the settlement agreement and final details before City Council. So with that, I have one more little diagram. I mentioned Rokeby Road improvements. The Iron Ridge has taken care of the improvements down to the west end of what is highlighted in red here. And there's an agreement being hopefully in its last stages of drafting and comments between the different adjacent property owners with Big Butch Cassidy on the south, Lincoln Federal, and Iron Ridge. That agreement and those improvements can be scheduled in the near future. With that, I'd be happy to answer any questions that you may have.
How did the neighborhood meeting go on May 19th?
We utilized that meeting to introduce both projects. It's basically, I mean, there's a lot of property, it's a mile long, to introduce to everybody. I thought from a virtual perspective that we've entered this new realm of getting information out. It's a useful tool that you can utilize from a presentation perspective. We did get a lot of good comments. I'll talk a lot of the comments that we heard was more specific to the CUP, which is next. But I thought it went very well. And we had a pretty good attendance, if I recall, and people in and out, it was about 30 people.
Were they, we've received letters on, like the 34th Street and the parkland. Was that the basic things that you heard, or were there any other?
There wasn't a ton of discussion, to be completely honest with you, about the uses, about there was a little bit more about the parkland. I see in the comments there's still some confusion about that. The intent is actually to expedite it, to move it up in schedule and deliver a park to these residents sooner than they would otherwise, per the standing agreement. The intent is not to delay it at all. It would go on a piece of property that would be adjacent to the LPS property. That property is not on this. The bond issue was passed in February. I could speculate that it might be in the next one, which would be 10 years from now. So, but I do believe that Parks has got that, has talked to LPS about that location, and they can co-benefit from having that. And it is more centralized to the development, which would be nice, I think, from what I heard.
On the change that you made with the amendment, you're adding mini storage to the corner area also?
So the mini storage, per the amendment, would be an allowed use in any of the B2 area. So it would not have to be confined to the west side of 34th Street. It could be any of the commercial areas.
Okay.
Great. Okay, thank you.
Thank you.
Do we have any testimony in support? Testimony in support. Okay. Testimony in opposition. Come on up.
It looks like I'm the only one. Hi, my name is Joe Armstrong. I live at 3001 South Creek Road, which is just to the north of this development. So I can kind of show you that location. So I live right here. So just to the north, again, of where we're talking about the development. I guess I'm not opposed to the development of this area and what's being done. And actually, the meeting that we did have was very informative. It was the first time that we knew about this, but it was had a lot of information. We've had a lot of discussion since that time. I know Dale has sent in the letter of opposition to the increase in the height from 35 to 55. I would second that. I guess some of the issues that we have is basically our property value. As we look at where that development is, it is directly, if I look out my deck, I'm going to be looking directly at the back of a storage unit or the back of a apartment complex. And when we bought this property 5 years ago, we were told that there wasn't going to be any additional development in that area other than possibly some residential development. So along this line right here are $500,000 homes of people that kind of bought those lots specifically for the view and the look and the area itself. So I guess to kind of summarize my concerns is the view itself, the property value and what it could do, the height at which we talked about increasing. There's still some water issues that NRD is working on, and I can show you just a couple of the pictures just from May 22nd. That's directly behind my house and just to the north of Rokeby Road. So they're still working on some of those issues. And then I guess the request would be that if this does go through, that there would be consideration, whether it be natural or man-made barriers of some kind, to be able to hide, I guess, the commercial development. That's all I have.
This land right behind you then is obviously going to stay open, it looks like. I mean, that. Right.
I believe so.
So
I'm
to
right.
the south, right?
To the south. I believe this area they talked about could be commercial and could be storage units.
But up above the dotted line where,
This is a natural waterway that NRD is managing, yes,
Okay.
the conservation.
Thank you.
Drainage, yep. Any questions?
I don't see any. All right, thank
Okay,
you.
thank you.
Other testimony in opposition.
I believe we do have one individual who wants to testify, Lori McCarthy via Zoom.
Lori, are you there?
She's coming.
Okay.
Hello, everyone. Thanks for allowing us to join via Zoom. That's really helpful. I do have some concerns to express. I think one way to give you a little context for where I live, I can share this screen since I don't have a fancy projector. Let's see if that's going to work.
Yes, we see the map.
Okay, great. So this is my husband. This is where we live. So we're not directly adjacent to the things that are happening, right? But we live in the neighborhood. And what I would say is, I became aware of these changes via our Facebook group just a few days ago. I don't think I was on the list of people to be contacted for the meeting that happened on May 19th, maybe because I live far enough away, but I feel like it does impact all of us. One quick question. I know that Dale submitted a letter, so have the council members read that letter?
Yes, we do have it.
Okay, and he asked that it be read, and so I just wanted to make sure that it had been acknowledged or.
Yes, it was.
Okay, great. So I basically share a lot of the same concerns. I'm a little bit more concerned about the change to the roadway, and especially as it relates to the park location. I think it's been stated that the moving of the park is going to expedite the park existing. I guess I'm pretty skeptical of that. I don't claim to know all of the details around that. I have tried to reach out I spoke to JJ Yost in the Parks Department. He was really informative, but I don't get the impression that really that's a way to expedite it, especially since, as you've said, the school isn't even on the plan officially. But I feel like we, not as like a homeowners association, but just as the people living in this neighborhood, like we keep having the sand shifted under us as far as what's going to happen. I have seen comments on, again, the Facebook group, because that's how people communicate these days, about people who have lived in the neighborhood for 13 years and keep being promised this and that about the park. And now we're here and it looks like that area is about ready to be developed, and now there's a change. I understand that it looks like when they reevaluated the situation that there would need to be a bridge, and no one's really, I think, said how much that would cost. I've heard, millions of dollars thrown around, so that is a lot of money, I understand. But it kind of, it's a little crummy for the folks who have lived there or bought houses with certain assumptions in mind, for that to suddenly change. They're donating 3 lots, but it kind of feels like, okay, but what about where the park was going to be or the plan that was going to be there? So we're removing a road, and I don't know what to expect for congestion of traffic. We're putting in a school, and I don't think I've ever lived in a neighborhood with a school. Maybe that'll be a problem. Maybe Lincoln will expand, south of Rokeby Road, and suddenly we'll have more people coming up from the south. By the time that school is built, you can't really know what traffic you might need. I think Dale mentioned in some of his comments, and it was news to me, that it's sort of been evaluated and that there really should be another entry point to the development. So I think that's a concern. Anyways, so I think that's about what I have to share. Moving from 35 feet to 55 feet, I feel for the folks that are down there. Maybe that will change their view. I don't think it'll change my personal view, but I think it's something to consider, more along the lines of, expectations were one thing and now they're changing. So with some of these changes, I would love to see some better plan for a park, or, a sooner plan. You've said that this is a way to expedite it. I don't know. And I'm just uncertain, I guess, about what the lack of this road will mean. So I think that's all I have to share.
Thank you for participating and sharing your thoughts. Okay, do we have anyone else that needs to testify in opposition? Okay, staff questions. No?
I can answer one.
Okay.
Bran, with the changes that are going to have to happen yet before this goes to city council, is it proper for us to go ahead and approve the layout that's in front of us, and then it gets amended, or what?
So I'm assuming you're talking about this land swap with the NRD.
Well, it's gonna change the layout of the apartments, because they won't be able to do that little point out there with the NRD of the land they were gonna trade for.
Yeah, I don't think you have to do anything with it today. The condition is, the plan's fine as it is, or if you don't get approval from the NRD, then you gotta revise it. So, maybe tomorrow the owner or Brad, they change their mind and go back to the NRD perhaps, and some agreement. I don't think you want to preclude that at this point without really having a need to. So I'm suggesting it's fine going forward as it is. And if they want to address the issue going to council, they can do it at that time.
Okay, thanks.
Okay.
Brian, do you know, and I might have to ask the applicant, I'm not sure, how many feet space is in between, like that buffer in between the current development and then
Oh, you mean
what's,
from the edge of the development to?
yeah,
the
more on
neighborhood to
the
north?
west side though, yeah. It's okay, I can ask.
I don't have an estimate, a
Okay.
guesstimate. I'm sure Brad probably would.
Thank you. Any other questions for Brian? Okay, Brad.
Getting my measuring stick out.
I was just wondering in relation to that, to the height and,
Sure.
you know, how it's gonna,
Absolutely. So a couple of things to remember, and I don't know, Tracy, I don't have an exact number, but you know, I think it's where we actually had a gentleman testify where he lives over here, and what's a little deceiving thing I think is I actually saw him point over here where our PUD actually comes all the way down there, but the commercial land that's being proposed kind of stops. Well, it stops here.
I'm assuming
it's
that
not
maybe you
behind it.
have some floodplain issues in there and that's why you can't develop all the way over to that.
Yeah, the limits of what you see for development cannot be expanded. There was this conservation easement that I've alluded to a couple of times. This goes to that brink. There's no more. We can't go an inch further to the
Orange colored point, it can't,
go farther west. It can't go. And I can testify. I mean, I was there that night that he took the pictures. I probably was in the background. Seriously, and it does fill with water back there. It rained a lot, and we've been working on this development a long time, so I ran down there and looked at it. You could see the standing water behind his home. But that's why that conservation is there. It was flood prone in 2006. It's been designated as floodplain today. We've analyzed this again in 2018. We're, changing those, and certain procedures will continue to follow the city to get those finalized over the couple of years as development continues. There's, if I had to throw a number out, there's a football field between
okay.
the two. I think it's probably 300 feet or so. What I was going to mention about the conservation easement, why that's so important, there are a few trees here today. As volunteers continue to come, there's the conservation easement has language in it about maintaining those trees and so forth, and it's been a learning. Staff can probably attest to that. It's been a learning curve for us, but what all is included. But you can see there's a good stand of trees and through here, and I would imagine that they're going to continue. I mean, maybe not for this owner, but maybe the next owner or the next owner after that, where there may be some more visual. And Brian did allude that there is, from the setback reductions that we asked for, even on the north side, that we still have to meet like parking. If there was a house right next door, we'd have to do the same screening standards on the back side here as if the house was 20 feet away. But those residents are a little bit further. Lastly, on just the connectivity, this is a map I think we shared at the neighborhood meeting. Just there are red dots. It's showing the access points around the development. We did openly talk to LPS about any concerns that they may have, because they're going to have kids going to school on the south side of Rokeby. They're going to want to get here. And there are future roadway improvements that are in the works, that come up 40th and have a direct access, or come directly in on Ohohensi and over to the school. And we did not hear any major concerns or objections from LPS about the connections. I understand South Creek Road is there and it's going to increase traffic. I'll talk about that CP. There will be increased, probably. But this development has basically developed from west to east. The east half is missing. There's not roads that connect this going back to 40th Street and so forth. And will add population down here as the development continues, but the last piece that we actually added was the 8th edition down here, And they do. They travel like 31st up to the north and get to Wilderness Boulevard or whatever. And but that will be alleviated as there's actually more connections made through the development. And I don't. Well, what I haven't really heard, I didn't hear in our public meeting, and I've heard actually opposite from one or two people that live down in that area. A little selfish, but they were pretty happy about not having the connection because they won't have the traffic generated to them. You know, I try to think about this outside a little bit. I did a quick calculation of the way I like to go home through my development. I travel 0.8 miles to get to my house through and just, and I think, you know, if you're in the far corner here, it will be very similar. You have to take some side roads, and it's not a quick pop out to the arterial roadway and to go to the grocery store. It's a little bit of driving, but if we get this done now, they'll know buying homes and building homes down there what they're doing.
And what are your access points out of the property we're talking about right now?
The access that are constructed
To Rokeby?
to Rokeby, there is no connections built today.
In the yellow, I'm sorry, what we're talking about
In the
today.
yellow, there will be one here at 34th Street, 37th, and 38th.
Okay.
So there'll be 3 going into the development, and there will be one additional one at 29th Street that we'll talk about next.
Perfect.
Any other questions for Brad? Okay.
Oh, may I? You asked about the NRD and questions about Dick, if you thought that if we could move forward with this. I think that our position is that we probably won't pursue it. I think the position was pretty clear from the subcommittee as to some still questions they're wrestling about their how they deal with exchange for conservation easements and them doing that even into the future. There are guidelines for that piece of property in that settlement agreement. I think we'd just like to expand as we negotiate those final pieces. But I don't see major changes to the plan that we have today. For instance, we may lose. I'm not asking for a reduction based off the land and the developable amount of property. But you know, a little rotation of a building, and you may take off the end units and combine them, you know, and turn them in. What we'll probably end up losing is a little internal green space, which would have been really nice, personally, with this particular layout. But I don't think it's going to impact what's shown in the residential, the multifamily, and the commercial at all.
Okay, thanks.
I'm gonna ask one more question since you're still up here, Brad. On that corner, the biggest conversations that people bring at me in the public are mini storage and having it in a very public view area.
Mm-hmm.
How make or break is it to have the mini storage on the corner for your client?
On the flip side of things, we've shown this plan to people. They actually like the location that it's at. That's primarily why we located where it was.
Mm-hmm.
I think corner uses, I think a little bit more retail and commercial, particularly when we do layouts for those. What I had heard talking to planning also, or I don't want to speak for them at all, but I think mini warehouse are pretty quiet neighbors, if you will, and you know, light and light trespass and so forth are will be controlled through the design standards and so forth, and I just see them being more less intensive use. If you were going to pick anything across this drainage way to be there, I think we like where it's at. If I need to be as direct to say that warehousing, I think we want the flexibility to be able to move it around, just given how we would want to maybe see how the development gains interest from buyers.
Okay.
Yeah.
All right. Okay. Thank you, Brad.
Thank you.
I'll move to close the public hearing.
Second.
Jerry?
Okay, Albadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Shear?
Yes.
Core?
Yes.
Motion carried 6-0.
I assume we need separate motions, so I will
That is correct.
move to approve the annexation 20009.
Second, Albadre.
Discussion, and feel free to discuss both at the same time.
I'll go ahead and start. I'm certainly, with regard to the annexation, this is completely makes sense. It's contiguous to the city limits. It's certainly no reason not to annex it given what's available at the site. And I don't have any concerns with regard to the change of zone either from AG. I thought it was an interesting discussion with regard to the R3 PUD versus PUD in any other residential district or any other district, but it makes sense given what's around it. Certainly have a lot of things that needs to take place for this to move forward, but I think everything makes sense, including the moving of the park location next to the school. I think that's great for the neighborhood long term, especially if that park can get built more quickly.
I agree. I don't have any issues at all with the two things we'll be voting on, both the annexation and the change of zone. I think those are both appropriate. As it would move forward into development, I actually think Brad's math is off a little bit. I think from the closest house to the closest proposed structure is more like 500 feet. It's a long ways. I did some just mental measurement here, and I think that open space, that buffer is great. I agree that I think there will be volunteers growing in that wetland, lowland, whatever it is. I don't know if it's an official wetland or not. It probably is. But I think that'll continue to establish as a great buffer. So I'm not worried about that at all either.
Else? I agree. I think the annexation is appropriate. I think the change of zone is appropriate. I'm not worried about the 34th Street connection. I can see kind of both sides of that. And I hope that the park does get built sooner rather than later, and I think this will speed that up. So it sounds like a good idea. Jerry?
Okay, this is for the conditional approval of annexation 20009. Albadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Shear?
Yes.
Core?
Yes.
Motion carried 6-0.
I would move to approve the change of zone 20017
As amended.
as amended. Thank you.
Do I have a second?
Second. Sure.
Thank you. Any other discussion? Great. Jerry?
Okay, this is for the approval of change of zone 20017 as amended. Albadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Shear?
Yes.
Core?
Yes.
Motion carried 6-0. Okay, next item is item 4.4, special permit 20016 to allow for a new community unit plan on property generally located at the northeast corner of South 27th Street and Rokeby Road. Staff recommendation is conditional approval. This is final action on this item unless appealed to the City Council within 14 days. Are there any ex parte communications to be disclosed?
I don't see any.
Are there any ex parte communications that took place or additional information you learned while visiting this site?
No.
Okay.
All right.
Hello, Tom Chaka, planning staff. This is a request for a special permit for a community unit plan for a site that is just west of what you were just discussing, on the northeast corner of South 27th and Rokeby Road. The application is for 132 dwelling units on 20.75 acres. The dwelling, so this area in here, that's got the hatch kind of area. As you can see here, it says AG. This is being rezoned to R3, and that was on the consent agenda earlier today. The proposed development is for row houses, either 3 or 4 attached. Zoom in here a little bit. There we go. And so this entire area will be rezoned to R3. The applicant is requesting waivers to the average lot width and lot area. The lot width in the R3 district for attached single family is 40, average lot width is 40 feet, and the lot area is 5,000 square feet. They're requesting a reduction of the average lot width to 20 feet and lot area to 2,500 square feet, which is fairly typical for a townhouse, row house type development. There's also a reduction. They're also asking for a reduction in a setback, side yard setback for certain lots. This area right here, coming through here, is for a pedestrian easement. Originally, it was shown as 5 feet with some no-build easements on it. Planning had recommended that the outlot be 10 feet wide instead of 5 feet wide, and have a reduction in the side yard setback so they didn't lose any buildable space on the adjacent lots. This way, I don't know how many of you were here years and years ago when we had the whole discussion of pedestrian easements being only 5 feet wide and looking like as we described, a cattle chute running through there. So this would allow it to be 10 feet wide in case people want to build fences, because even if you put a no-build easement, we know those things get lost and lots get sold and resold and people are going to build stuff there. So our preference would be the 10-foot wide outlot and the reduction on the side yard setback to 2.5 feet from 5 feet. Other thing I want to actually probably be better on this one. I know there's been some discussion about townhomes next to single family. If you look at the boundary of the CUP, you'll see there's open space right here between these existing single-family lots. This isn't an approved preliminary plat, and this area is shown for single-family lots. As of today, that's what's approved, and that's what I believe is still planning to be there. There is also going to be a buffer, an outlot along this northern strip of these townhomes that will be for landscaping, parallel to the street extension there of South Creek Road. This development proposes one access point to Rokeby at 29th Street. Then other internal access will come from the existing roads to the north of Keystone Drive and Del Rio and also South Creek to the east. All the streets will be public streets, built to city standards, curb, gutter, and sidewalks. I think maybe that's all I have. Take any questions?
Any questions for Tom right now?
On the streets that they'll be accessing out of to the north, let's see, you said that was Hoy Street. Is there any improvements on 27th there, like a stoplight or a roundabout coming up?
I'm not aware of any.
Okay.
There was something in the conditions of approval about, where was it? My notes. The water quality comment. Oh, submit the water quality request for alternative form?
Yeah, I think Brad has some motions to amend, and I believe everything has been worked out with watershed management. And Tim Zock is here from Watershed to answer any questions.
Okay.
For that.
Any other questions right now? Okay, applicant, we're ready.
Wow. Here we go again. Same area.
It's the Rokeby Road Day.
Yeah. So again, this is part of the preliminary plat we were just talking about. There was detail in this particular area, though. Brad Marshall. Sorry. There was detail shown in this particular area on previous preliminary plats. The original plan actually showed attached duplexes, or attached single family, I should say more appropriately. I call them duplexes, so they would be, this is the corner in the southwest corner. In 2018, we actually changed it to single family. The mark was a little bit heavier on the single family at the time, and so that changed. But from 2006 to 2018 is actually shown as attached single family. There was always this little 6-7 acre parcel. There was an acreage home that was in there. It's exchanged hands. Lincoln Federal has now purchased that, and that is part of this overall CUP application and change zone. So they do have a particular buyer for these row houses or townhomes, and we developed the plan particularly for Smetter Homes. Smetter Homes is a builder, a local builder in Lincoln, and has been doing a very similar type of townhomes in this area. They're doing attached single family in Wilderness Creek, which is just behind the Toyota Lexus dealerships, and then also I'm going to probably refer to this next one probably a couple times. There's a townhome development north of 40th and Yankee Hill Target. So the area had been developing up there. We've got about 40 or 50% all the way through, and Smetter Townhomes came through and built out the rest over the last couple of years, I should say. So the similarities between that development and this one are probably going to be very similar. I've got some images I like to show you as to the style and product that they're going to bring to the table. So the plan that I have shown on the screen here is kind of the general layout of what these would look like. They are 3 and 4 plexes, with the occasional maybe 2, just depending on how the land works out. Well, what's really important, I think, is important. What we tried to accomplish is to create a buffer between the adjacent landowners, the people that live there in Wilderness Hills today, and Lincoln Federal would retain, and what these single-family are in the preliminary plat and not part of the CUP discussion, but there is a row, there's 13 lots, I think, here. These have already been developed and sold. So there's a number of single-family homes, lots that would be proposed along South Creek Road to create a buffer, if you will, between those residents, have like uses to the south of them to be their neighbors. And then the people buying those lots would know that there's a townhome development literally across the street from them. So that is, these lots are slightly bigger than what are existing out there. We think they'll be comparable or higher in value to those properties. Tom talked about green space areas in the development. The darker green kind of overtakes the edges, but that's right of way. But there are lighter green outlots along the perimeter that the buyer wanted to include into the plan so that they had the ability to do their own landscaping, control that within themselves. They do plan on having their own HOA for these 132 units. And that HOA would maintain the perimeter control of the landscaping and so forth. The product for the townhomes, because I know that will be a discussional item, is shown here. This is right off their website. This is this is an end unit and center unit of a townhome piece. They do change from like an exterior being a ranch, the interior being a two-story and so forth. So they are somewhat customized in the development. This is just an interior shot that was shared with the neighbors at the virtual meeting. The market, the price market, I guess that Smetter Homes will be going for was between $240,000 and $320,000. So these are, by reference, not cheap townhomes, I guess. Occasionally, quite often I hear, are they going to be rentals? Townhomes. These Smetter townhomes are developing these and building these to sell them. They are not building them to maintain and then rent out themselves. They're sell to the general public for their own homes. I did hear occasionally too about the concern of this dropping valuations of the neighborhood. I do understand that from development happening and different types of uses happening in the particular areas. I did a quick valuation, look at what's kind of around that area. The line of homes to the north that we showed here, they're around $350,000. I think actually like the average of all of these like 356. So you're talking some nice homes and good values of properties that these neighbors would certainly have and a legitimate concern. But going back to, that's why we kind of created this. This isn't the most efficient layout that we could have come up with. That we've got more roads here than we probably need. But at least it creates that buffer if we felt like to maintain between those residents and the existing neighbors and what would be built. One of the other things we occasionally hear, and I want to make sure that we address, is also parking. Townhomes have driveways and they have limited parking. If they have multiple occupants, they have vehicles in there. What they've seen in success for like the area north of Target are single parents that may live there, older, 55 plus, if you will. But there's a good mix that was communicated to me for all of those. But this would be a development that would have, like I said, the HOA would take care of a lot of those amenities and common spaces and yard work and so forth for the development. This is a diagram I just wanted to share. Because of the narrow widths of the lots, for every two, you have to show that you can have like a parking spot designated somewhere, and that can be on the street. But you have to account for the driveways, because townhomes have tighter driveways and there's less street parking. This is a diagram, and if you can see the green spots through here, there are spots and open spaces from the driveways. There are areas that along curves and so forth that you get greater parking opportunities. What's shown here is 70 parking spots. We did not take anything really outside, even though half of South Creek Road won't have homes on the south of it fronting it with driveways. It'd be a great location for overflow, if you will, if it had to happen. We think that there is adequate parking already, but one of the suggestions, and Tom talked about, was that pedestrian path kind of cutting through that neighborhood, going all the way to South Creek, just in case there was an occasional person that parked on the public streets back there. And again, we didn't show anything on 27th Street to try to maximize what we had there. I stopped by one morning just to kind of get a glimpse of what that area to the north looked like as we woke up, and see how many cars are parking on the streets. That is a shot. There was literally not a car.
Is that pre-quarantine or after quarantine?
That is during quarantine. So or pandemic, I guess, or work at home, if you will. Or they do have a couple of, I will caveat that there are a couple of designated locations within that development. There are, so off-street parking, they have a couple of parking stalls. This is a couple of other ones to show that there are people that park on the streets there. It's, I didn't pick and choose. These are different streets at the same time. And those stalls that were designated were utilized. I'd probably say about 50% that I saw.
Brad, are those two stall garages?
Yes, they
Okay.
are.
It looks
Yep.
like it on here, I just, okay.
Yep, they are. If you can see them, but they are, yes, two stall garages.
Perfect, thank you.
Kind of going back to that exterior, if you will. To the south, having townhomes are different than what's there with single family and people that are living there. We thought that this would also be an appropriate transition from single family to a little bit higher density with the townhomes just south of Rokeby, which is an R3 PUD also, has B2 approved uses for commercial and multifamily on the corner, which if I can do my shuffles here. So, like we said, majority R3 to the proposed R3 CUP with our units, excuse me. And then across an Iron Ridge, there's approved multifamily as you kind of do that increase in density, if you will. That's pretty much it. We did have the individual testify about the mailings. We did not extend that far within the development. We had asked, as part of the contact with the HOA within Willers Hills, to post on their Facebook group, and I think that did hit some, at least, that were not within that notification area. And they've been really great to work with. I should add that as part of this process. The board there have been absolutely wonderful to communicate with and get information out and have them assist in that. If there's any questions, I'd be happy to answer anything.
I had asked about water quality, or there was that comment when
Specific and alternative form.
Yes.
So, in this development, what we are proposing is two things. One, additional corridor adjacent to the property. Just use, it's probably going to be the last one. To the east is this drainage way that we've been talking about. So the conservation easement comes through here and ends at that 6 or 7 acres that was purchased as part of this. There's kind of been channel erosion here, and so we are providing corridor and following the guidelines for that. But then we are proposing to add adjacent or additional corridor beyond what's there today as part of a water quality. And then across the way, actually, if you cross the creek, there is actually portions that are still are being farmed. And so as one alternative that the city has accepted on other developments is converting that cropland to prairie land, prairie grass. And so that is part of our water quality proposal. I should mention I almost forgot, but the motion to amend before you, we have worked with Watershed on those 2 items. Tim Zock is here from the Watershed Department if you have any particular questions, but we do believe that we do have support with those 2 motions to amend that language. We have shared that with him and he has reviewed it.
Any questions for Brad? Yeah.
Just a comment, Brad, we found that on our row houses and our live-work units, that we had to go to a 24-foot lot to get a really decent 2-car garage on the property. The 20-foot can work, but it doesn't leave much room for getting in and out of cars.
Yeah, I probably agree. If you look at the site plan details where it's actually all dimensioned, the minimum is 24. Good. And what is before you in the waivers is really the standard for an R5. And so the minimum lot area and the lot width are following the R5. That would be an allowed use for townhome usage, but because we're an R3 CUP, we had to add those as waivers.
Any further questions for Brad right now? Okay.
Thank you.
Testimony and support. Testimony and support. I'm assuming that no one in the back room is for this. Okay. Testimony in opposition.
I would note that I distributed a copy of an email from a Mr. Bruce Staff, who had initially indicated he was going to be available via Zoom, and something changed, so he submitted those comments. And we do have one individual, Lori McCarthy is also wanting to speak on this via Zoom.
Okay. I think we're ready for Lori if she's, or was that the last?
Hello, Lori, you're up.
Hi, Lori, are you there?
Can you hear me now?
Yes.
Hello, hello? Okay, great. I was just going to say that I would second the concerns with the increased traffic on Hoy Street and the potential effect on property values. I don't think I have any additional flavor to add to those. So thank you for hearing us today.
Thank you.
So your concern is about traffic on Hoy Street, is that correct?
Right, with only the one entrance from the south and just what that'll look like of increased traffic on Hoy and Keystone as it comes in.
Okay, and Hoy does go all the way to South 27th, is that correct?
That would be where they would enter this development from the north, and most likely.
Got it. Okay, thank you.
Yes, thank you.
Any other testimony in opposition here? I think that was maybe it. Okay, staff questions. Anybody have any?
You're good with this motion to amend?
Yeah, and Watershed's good with it.
Okay, great. Applicant rebuttal? All right, I would entertain a motion.
I would move that we close the public hearing.
Second, Albadri.
Jerry?
Abadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Shear?
Yes.
Core?
Yes.
Motion carried, 6-0.
I would move that we approve the amended special permit 20016.
Second.
And that was Edgerton.
Yep, got it.
Discussion. Wow, okay.
Tired.
Or mid-afternoon slump here. Okay. I think this looks like a interesting project. It kind of fits all the,
Checks all the boxes.
checks all the boxes, yeah. Okay. Jerry, I think we're ready.
Okay. This is for the conditional approval of special permit 20016.
As
Sorry.
amended.
I'm sorry, as amended, that's correct. Thank you. Abadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Shear?
Yes.
Core?
Yes.
Motion carried, 6-0. And I believe we're wanting to take another 2-minute break or so unless you
Okay,
want more.
so let's take a break until 6 o'clock.
Okay.
Steve?
Geez, you just pointed out it's 6 o'clock. Holy
Each person testifying should state their name and address and shall have 5 minutes to speak unless additional time is requested and granted. The timer will go off after 4 minutes. Then you will have 1 minute to wrap up your testimony. The Planning Commission will vote immediately at the close of the public hearing unless the commission votes to defer action or continue the public hearing. So I'll have Jerry call the item now and then we'll get started.
Okay. Okay, item 4.5 is special permit 20005 to allow for an alternative to imprisonment facility with up to 6 persons in an existing residence on property generally located at 420 South 28th Street. Staff recommendation is for conditional approval. This is final action on this item unless appealed to the City Council within 14 days. Are there any ex parte communications to be disclosed?
I don't see any.
Are there any ex parte communications that took place or additional information you learned while visiting the site?
No. Hi, George.
Hi, George Wesselhoff, Planning Department. So where we're at the vicinity of L Street and South 28th Street on the east side of South 28 at 420 South 28th Street. This is a request for a special permit for an alternative to imprisonment facility. The property in question is zoned R2 residential and it's located in a residential neighborhood west of Woods Park. The definition of alternative to imprisonment facility, I'll read it here. The definition is alternative to imprisonment facility shall mean a facility in which more than 3 but less than 16 persons who are unrelated by blood, marriage, or adoption reside under a supervised program of alternatives to imprisonment, including but not limited to pre-release, work release, and probationary programs. Such facilities shall be licensed or approved by the state of Nebraska or other appropriate agency if so required. A little background or history on the zoning ordinance. In 2005, there were changes that were done to the zoning ordinance that relate to group living. And as part of those changes, new special permits were added that included one for alternative to imprisonment facilities in residential districts. This permit did not include any specific conditions, but it was noted at the time in the reports to Planning Commission and City Council that the Planning Commission can act pursuant to their authority to impose such conditions as are appropriate and necessary to ensure compliance with the comprehensive plan and protect the health, safety, and general welfare. The 2005 text amendment for group living was done due to concern about litigation with respect to the definition of group home and persons with disabilities. Children's home and alternative to imprisonment facilities were 2 specific uses established and permitted by special permit as part of the text amendment. Previously, alternative to imprisonment facilities, if you look at the zoning ordinance from the early 2000s, actually fell under group home and was actually conditional use or conditionally permitted. The applicant for this application, by the way, this is the first application since the 2005 text amendment. The applicant is proposing up to 6 women maximum within the existing residence. Previously, the applicant had proposed 8 women. There would be 1 to 2 employees that will be staffed at one time during the day or night with 1 staff person on the premises from 7 a.m. to 11 p.m. Parking, and I'll bring out the site plan here. Parking would be in the back of the property along the alley. There's not a specific requirement for this use type for parking, but given the number of proposed residents, up to 6, and the number of staff, 1 to 2, the proposal, which is 4 spaces, is appropriate. There's also stacking room for 2 additional spaces. By comparison, group homes are required 1 space per 3 client or employee residents plus 2 spaces per 3 non-resident employees on the largest shift. So in other words, group homes do not have to provide a parking on a one-to-one basis, but rather a percentage of the total persons involved. And so these parking spaces will access from the alley. So this special permit, the recommendation is conditional approval. I would just mention two of the conditions in particular. One of the conditions is that any change in layout of the floor area and exterior will require an administrative amendment and review by the Historic Preservation Commission as the property is located in a historic landmark district. This condition is so the house will retain the same look and not look as institutional. There's also a condition pertaining to outdoor lighting, and that condition is that the standards that would apply would require that all lighting shall meet a light trespass requirement such that no more than 2-foot candles measured on a vertical plane located on the property line of adjacent property, so to protect against light trespass. With that, I can answer any questions you may have.
George, I have a question about that parking. So if we were following the group home parking requirements, we'll see how I did with my math here. I think it would mean that they would need 3 parking stalls.
Yeah, I think that might be right. In this case, they have enough room for...
Extra.
They have extra. They have 6 spaces, though we only count the 4 as far as the zoning ordinance.
Okay, great. Thank you for verifying that for me.
George, I also have a question. With the number of residents, if they were to up it from 6 to 8, do they need to come back for an administrative amendment, or is that approved?
That would be an amendment that would go to the Planning Commission.
Okay. Thank you.
George, I have a question that is not directly, well, it probably is directly related to the special permit, but it has to do with context a little bit. This is the first special permit applied for this use? Not on the site, but for this?
For this special permit category, we
Yeah,
searched the
that's how I should
records,
say that.
yes.
Okay. Are there, we received a couple letters in it. Is it true, or can you verify that there are other operations in existence that are operating without a special permit?
I am not aware of specific address locations. I know the applicant, I believe, at the Woods Park neighborhood meeting, which I attended, mentioned that there may be other such facilities. Please keep in mind that there is the possibility that under the definition of family, which is no more than 3 unrelated persons, that could include a situation where there's post-release probation. It doesn't necessarily have to. So that's one possibility, but I'm not aware of any illegal locations.
Okay, and then the last thing, I think your report identifies this, but in terms of any kind of enforcement of conditions, things like that, it's the Nebraska State Probation Department or whatever they are. They would be, you know, and other things, for example, the health department, for example, gets involved for certain complaints and stuff. But is this Nebraska State Probation? Is it health department? Is it police? Can you talk about that?
Sure, and the applicant can expand further, but as I understand it, there's not a licensing requirement per se. However, there's reporting to Nebraska Probation.
Okay, thanks. That helps.
Is there a role for the historic preservation review in this, with regard to this particular property?
There is, if the structure would propose to be changed as detailed in that condition, and that was kind of a protection measure to preserve the look of the house.
Got it. But as it's been proposed, there's no need for that at this point.
At this point, I think, and the applicant can maybe clarify, I think they were considering a fence, which may necessitate historic preservation review, but not at this time.
Thank you.
George, So is it possible that there might be other facilities operating within the city that were started before this 2005 text amendment came through?
I'm not aware of any. The applicant may be able to speak to that, or her representatives that are more
Okay.
experts in that area.
So we don't really have any other examples in the city right now that would be something similar to this.
As far as this special permit type, now as a matter of public record, there was an application just submitted for a second special permit under this category for 838 F Street for a new life place.
One of the things you described is that although there's no specific conditions within this special permit type, that the planning commission can put into place conditions that they might feel are necessary to protect the health, safety, and welfare. However, it doesn't appear that, it appears that the conditions that were proposed by staff are more really related to the property. You didn't, staff didn't put forward anything that really would be suggestive of health, safety, or welfare. Is that correct? I mean, am I interpreting that correctly?
Well, so the various departments reviewed this special permit like any special permit application, and Planning and Building and Safety Department in particular had comments. Those were included as conditions. The parking would certainly be a general provision or condition that could be added. Another way of saying it is that, in absence of a highly specific criteria under the special permit section, such as a licensing requirement by the city or a spacing requirement of a certain distance, those cannot be, as I understand it, and legal counsel can correct me if I'm astray, something that specific cannot be applied. But a general criteria that we would look at potentially for any special permit, not necessarily this permit type, can be considered.
Thank you.
Any other questions for George right now? Okay.
Thank you.
Applicant.
Hi, my name is Tina Arciaga, and I am the applicant for this Connecting Links Transitional Living Program. Please. So just a little bit about myself and my background. I have my master's, and I have owned my own drug and alcohol facility since 2006 at the Heritage Square building, where I conduct intensive outpatient treatment programs. I do evaluations, co-occurring jail evaluations. I do mental health treatment. So I've been doing this for 16 years. I've been a provider through the probation administration for this amount of time. I'm in good standing with all insurance providers and the other. Just to speak on our staff, we have ample range of experience in this field that I've been a part of. We have solid training and a wealth of expertise. And I'm confident that we can provide the best possible service for this house. I have worked alongside probation officers, parole officers, navigation officers in the treatment facility, as well as evaluating clients like at D&E, diagnostics and evaluation, community corrections, the jail, et cetera. And I've been providing these services for this amount of time. So I really know what it entails to provide this type of programming in this house. My overall goal in beginning this type of programming is to be able to encompass the entire scope of treatment, which is not only to provide services therapeutically, but to provide at my Heritage Square office, but to provide a sober, safe housing unit in conjunction. And I've learned over the years that clients' opportunities increase when their success rate will go up when they have the environment to reside in, such as this sober living environment, to reintegrate back into society and work their recovery program simultaneously. I am here to apply for this permit legally. I can't say more than that. I want to inform the community about the needs of transition living in Nebraska. There is a lack of homes in the community that are going to accommodate this population of people. I have this experience to help make this transitional living in Nebraska Better program, and also to help women who need this assistance to return to their families, to return to their children and their friends after serving their time. There's been times that it's been hard seeing multiple women in an unsupportive environment, and this house will help them to succeed. Too often do I see women from the group have either nowhere to live, they live in unsupportive environments, and if I have the power to make it easier for women to succeed, then I believe it's necessary to take this action. 24/7 security. I have a total of 4 Ring cameras that constantly monitor the premises. I get motion notifications on my phone when there's movement at all times. I have security locks, so they're smart locks, so the only way someone can go in and out is through a fingerprint. At night, if there's any motion on the premises, the cameras illuminate the backyard and front yard. And I've also engaged the Ring subscription professional monitors to have security at all times for me as well. We have also lowered the floodlights to accommodate for lighting being too bright for neighbors. We were able to do that. Our program plan and purpose. We want to provide housing for women in this sober and safe environment where they can succeed. This is specific to women who are transitioning from an incarcerated state, which is a structured environment, to a sober living environment for the sole purpose of providing an environment that's sober, safe, structured, and allows women to establish themselves as part of the reintegration process to this community as they continue to work towards their continued recovery efforts. We want to ensure the stabilization in the community, which encompasses this holistic pictures of all entities, where we have our treatment providers, probation officers, housing unit, all working cooperatively to have the stabilization in this community, to have this sobriety. As part of the reintegration back to the community, we expect to find, these women need to find full-time employment, go to school, they have to regain their independence. We're gonna help them pay their bills, budget, checking accounts, house rules, child rearing, education, and so forth, that type of programming. We're gonna provide a structured, completely sober, safe environment for women and offer peer support as they continue to work towards their recovery efforts. And we wanna improve the outcomes for women who reside in this home that are referred from outside sources, whether it be criminal justice system, navigation officers, probation officers, etc. We want women to have shared household responsibilities and duties on a scheduled basis and consequences to follow and to be accountable for their role in this household. Set of rules, we have a code of conduct. There's no visitors allowed on the premises whatsoever. We have insurance for this house. It's not typical homeowners insurance. It's professional insurance for this type of endeavor, and we cannot allow anybody on the premises other than the women that reside there, period. No children, no men, nobody. There's no illicit substances allowed, alcohol allowed on the substance. We will be staffed. Right now we have 2 to 3 women, so we are not fully staffed as we're gonna have the house manager. If this goes with 6, we're staffed. We're gonna have a house manager. We're gonna have someone there. Staff will be at the residence 7 days a week to ensure the safety and protection. I have 2. Can I have more time, or?
Yeah, since
Okay.
you're the applicant, yes.
Okay, I have my master's, and I've been doing this for 16 years. Sean McClure is another master level. He actually is a therapist out at the Tecumseh prison. We're gonna enroll interns from colleges that are versed, and they wanna get their internship practicum hours and hire outside. So we have 2 LMHP for every 6 women, which is a good ratio. Attendance, they have to have attendance and successful demonstrated participation in all the programming. They have to have successful discharge, successful in probation. Their goals have to be met, our code of conduct, etc. If they weren't in 15 minutes, I would escort them out. All women call in daily for UAs, so we know that they're sober. I do UAs, probation does UAs, these women are sober. These women committed their crimes when they're under the influence of substances. These women did their time and they're sober. They're supposed to attend pro-social events, AA, NA, church, 12-step programs, and for women to remain sober in this transitional living environment, we need for them to reintegrate back in the community by showing they're saving money, staying sober, looking for housing, and making good decisions. We want women to succeed. Ultimately, I want these women to feel that they're successful on their own. They have a good understanding and footing of what it's like to live in a healthy lifestyle on their own. Service directors will maintain a healthy environment and teach women basic fundamentals, job application, resumes, how to problem solve sober, being a good roommate, and being a good neighbor. Budget, how to live a healthy lifestyle. Success means we'll have more supervision, 24/7 surveillance, which is set in place around the clock. There's more chance of success to help women who have been sober for a good amount of time, and these women are sober, hence in the right state of mind to change their lives for their future. There is a need for transitional living in Nebraska. There were 2 bills passed in 2018 across Nebraska. And those 2 bills were our prison systems are too full. And we needed the Capitol, the Senate, they passed these bills to take people out of incarcerated state and put them somewhere in transitional homes. Well, where are we going to put them? And you got to do it the right way. You got to do it the legal way and permit it the right way. Now, when I had this house, I didn't just pick any house. We've owned this house since 2000. We've been renting this house. We've been in Lincoln. We've been here the whole time. We are around the house a lot. Instead of renting it, we chose, why not do this? Why not use it for this endeavor? Well, when I started this process, I found that there was 2 group homes within 6 blocks of proximity of the parcel. And that would have been an easier route. Well, when you're in a zone of R2, you have 3 options. You have residential, you have a group home, or you have alternative to imprisonment. I didn't want to give up. It hasn't happened since 2005, so I chose to do an alternative to imprisonment because I didn't want to give up and I wanted to give this home a good opportunity. With that being said, you know, I did everything that the Planning Commissioner George told me to do. Do your due diligence, Tina. Do letters to your neighbors. I did. The first day my kids moved out of the house, my daughter gave the client handbook to our roommates, or to the neighbors, let them know exactly what we were doing. We gave letters out 200 feet of the parcel. They told me to do my due diligence, go to the Woods Park meeting. I did. It wasn't pleasant. The need for transitional living is there. And so if these women cannot live in this house, we're going to have to put them somewhere else in Lincoln. And trust me, there's more coming down the pipeline. It's not just me. This house is as good as any location is. Transitionals are filtered throughout the city. These homes are safe, they're structured. I mean, I know mine is. And they're typically crime-free to the neighbors in which they exist. Profits from this program will be directly reinvested back into the preservation and conservation of this historical home, which will help continue to restore its great historical value and structure. The next one. Oh. Do you have any questions?
I have a couple for you. So are you going to have someone there 24/7?
Yeah, I want to have a house manager. If we're approved with the 6, I'm going to have somebody be there, spend the night there. So I was thinking 7 a.m. to 3 p.m. shifts, 3 p.m. to 11, and overnight.
Okay. And so what have you been using this house for up until now?
So my family, we have 4 children, and we bought the house in 2000. We had 4 children, and we, you know, in 2004 we did a lot of work into it, and at 2006 we decided to move, and so we've just been renting it. And I've rented it one time to a housing authority, a woman. We've rented it to our children for a year. We've rented to some people that didn't work out so great, that were college students, and so, you know, it's been. My children were there living as of November of 2019. And I says, well, we're going to do this, guys. You got to go. So my children, you know, are living somewhere else, and they're going to college, but, you know, they understand that this is what we need to do for the house. So.
So there was a description of the residents or the women who would be coming in as pre-release, work release, and probation.
Right.
Can you walk me through
Sure.
what that means?
Sure.
And in terms of where would these women, I mean, would some of these women still be in prison, or where would they be if
Right.
they weren't here?
So these women have done their time. They have
Okay.
paid their debt to society.
Okay.
Okay? So they're free, independent, you know, it's transitioning. It's like throwing someone out of prison, like, oh, here's $100, go get a house and a job and a car, and they're not going to be successful that way. So we need to like taper it down. Just like if they did short-term res treatment in prison, we're going to taper them down to intensive outpatient and so forth. So we're transitioning them to be sober in the real world, get a job. We're helping them get a job, employment. We're helping them get set up with school and their referrals, and to stay sober and live life sober, get back to their children. Most of these women have children. They want to go home to their children.
Sure.
So when they first get there, I say, I'm sorry, you know, we can't have them here. And so they're pretty disappointed, but that's a goal they need to work for, you know?
I just wasn't sure what pre-release meant. I mean, in my non-professional
Sure.
mind, that meant that was before they were actually released from prison.
Right. So what they've done is the 2 bills that they can either jam their time, or they can do so much and serve their debt and then come out on a post-release, if you will. And this post-release is new since 2018. So when they're on post-release, they're being monitored by probation officers in lieu. So like I work with probation officers with them. They have to do random UAs. And so navigation officers were just put into place last year to help with this process. So they'll go into the prison system or an incarcerated state. They'll interview them, find their need. Do they need treatment? Do they need transitional living? What can we do to make this person successful? And so from that point, the navigation officer will contact me if I have a house, if I have a place, and then we kind of go from there. Does that make sense?
So all of these women would be working with someone in probation? Okay.
Yeah, they have to call in daily for UAs. I give UAs. I do the breathalyzers and UAs,
Sure.
and they do too. And there's consequences.
So how do they come to you? Like, how do they know?
Just because I've been with probation for 16 years. Like, I'm in good standing with probation administration. I've done treatment, mental health for 16 years, you know, on my own. And so when this started in 2018, and in 2019, I was just like, well, I can do this. I have a house to provide. And so that's, the referrals come from probation.
Okay, thank you.
Your current practice, so they just don't stay overnight there? You're seeing them like kind of on, I don't know, you know, they come in for an appointment and.
You mean at where I'm at Heritage Square?
Right.
Okay, so this is separate. Like, so I have malpractice insurance. Like, I have my master's, so I do mental health therapy. I'll do the group therapy, individual. I'll do co-occurring evals, psych evals, or mental health evals. And I do that down at 421 South 9th Street, Suite 107. And I've been doing that. And this is separate. So when I'm at the transitional, it's just programming. It's not the ethical master level type thing. It's more, okay, let's do a resume, help you with that. Let's help you get food. Let's help you get food stamps. Let's help you get reacquainted with your children, you know? So I'm kind of going, does that make sense?
Yeah, I just wanted to, no one's staying overnight at.
At Heritage Square, no. No, this is something that transitional is where they spend the night.
So I'm familiar with, we've had a group come through before, Hano House, and they're affiliated with Mental Health Association of Nebraska. How is what they're doing different from what you're doing, or is it similar, or how?
Yeah.
Can you explain that to me?
It's pretty much the same thing. The Hanu House, I think, is transitional too. I mean, they're taking clients as well. I do a lot of evaluations for Hanu House when they're actually living there, and then they'll refer them to me at treatment at Heritage Square. So it's like a separate business, if you will. So they're doing the same thing. They're housing people in supportive environment and making them do the treatment and the UAs, and it's just the same.
Then who decides when the women move on?
So it's 1 to 3 months. It could be an extension, and I usually kind of abide by the PO, the probation officer. I kind of look to them too. I mean, and they'll ask me my opinion because what I see, but we work together. And
okay,
like I've had one girl, she was there for a month and she's ready to go. I mean, she had a job, she was sober. Like, go, that's what it's here for. Good job. And then others might need a little bit more time.
Sure.
Other questions for Tina right now? Okay. Thank you.
Thank you.
All right, testimony and support.
Okay, I am going to go off of a list that I was handed
Sorry.
in terms of registration. So I'll just start. Is it Tom Arciaga? Okay.
Hello, Tom Arciaga, 6111 Rolling Hills Boulevard. I'm her husband. Let's see. Well, she's been wanting to do this for a lot longer than just recently. This is something that she's been talking to me about for, I don't even know, it's been a long time. And it's been no, let's just stick with your job and let me do mine. We moved out of that house and let's just keep it as a rental. And she was just really tired of seeing the same people going in and out, in and out. And so it was kind of like, so she just pretty much just said, I'm gonna do it. And that's where we're at. So I just, have to support her. And people talk about her as a person. It's not an 8 to 5 job. It's not something that you just clock in, punch out. You know, there's a lot more to this than what she's really saying. So, I mean, even on vacation, she'll take a phone call, you know, and it's somebody she cares about, somebody that she's in treatment with. I've got to take this call, Tommy. And all of us kids, we're on vacation. This is like family time. And there's my wife, you know, just off talking to somebody, trying to talk somebody down off of whatever they're going through or whatever it is. So when we hear all the opposition letters and we read them, it's hurtful. It really is hurtful, especially some of the people that are here today, you know, and even coming in, you know, hello, Dan, how you doing? Hi, Tommy. You know, I consider him a nice person. I like him. We lived across the street from each other. He's watched my kids grow up, you know. So it's I knew this was going to happen, and this is a big reason why, you know, I really wanted to avoid all this. But as George or Tina will tell you, this was part of owning that house. You have to own that property. So it wasn't something that we wanted just, oh, we're going to go do this and that's just it. It was the only place that we could do this at. And that's why we did it. It wasn't to be resentful or to be mean towards our old neighbors, you know. And that's, again, some of the things that were being said. It's hurtful. Yeah, she's doing everything, her due diligence, the right way that she's supposed to do. You know, I think it was George that was the one that told us to please go to the Woods Park, you know, go to the Woods Park Association meeting, whatever. And we were there. It was, she said it was bad. It was horrible. It was horrific. It was not fun. One of the people actually finally had to stand up and say, this seems like a witch hunt. I had to talk down the crowd twice. I did. Please, everybody, calm down, please. It wasn't fun. We left. She was upset. I don't like seeing that. But this is something that my wife is really passionate about, is helping people. I knew this was going to happen. This is where we're at today. And as she said, she's not going to stop. She's going to still continue to do her due diligence, everything she has to do to make it a better place for her. And it's not just women. She works with men too. Okay, I know she was stuck on this women thing, but no, she does help men as well. But that's really all. I'll make it short, so that's all I have to say about it.
Thank you.
Bye.
Okay, the next three are Tony Arciaga, Towan Arciaga, and Macy Clapp.
Hi, I'm Tony Arciaga. I'm her daughter. I live on 3833 Chilano Drive. I don't really have a lot to say. I just want to let people know that out of anyone that should be doing this, it's someone like her. She's had so much year of experience, you know, and I just think it's wrong that she's being not punished, but, you know, she's gone through all of this. Like, me and her have been working on this for like 6 months, more like a year, a long time. And she's punished for doing her due diligence, and that's not right, because there are several other homes running by people that have no experience. So, yeah, that's all I really have to say.
Thank you.
Okay, Towan Arciaga, Macy Clapp, and Jane Harrison.
Hi guys, Tomas Arciaga. Tina's my mom. I live at 808 South 30th Street, 30th and Randolph. And I've been there for almost a year, renting. And I've read some oppositions too, and a lot of the neighbors think that by having this house in the neighborhood, it's gonna bring more trouble than what's already there. And I've experienced, you know, I've heard gunshots, I've seen people dumpster diving, I've seen drug traffic, and I've seen all this stuff. And, you know, people think that by having 6 people that, you know, have made a mistake and are coming out of jail, live in a house in their neighborhood, they think that there's going to be, you know, bad traffic and a lot of bad things coming in the neighborhood. And it's just not, it's not fair to treat women like this who are just trying to do good, get back to their families, do what's right. They've done their time, and I just think that they're not given a fair shot, and I just think that it's not okay. And you know, I support what she's doing. She's doing it the right way. She's doing it to help, you know, these women, and yeah, I just support that. So, thank you.
Thank you.
Okay, Macy Clapp, Jane Harrison and Jordan Hasselbach.
Hi, my name is Macy and I live at 3833 Chileno Drive, and I support the transitional living run by Tina Arciaga. I believe that this housing is the best and most effective way or option for these women when coming out of prison to better themselves and reintegrate back into society. We all make mistakes in life, but not everyone gets the opportunity like what Tina is offering, and I believe that she truly wants to help these women. None of us know what they have been through, so it's not right to judge them for their past mistakes. I think we should all have an open mind and an open heart and give these women the chance that they deserve. Thanks.
Thank you.
Okay, Jane Harrison, Jordan Hasselbach, and Allison Drecke.
I'm Jane Harrison, and I live at 3735 Peace Boulevard. And I got interested in this through an OLLI class on corrections and prison and became aware of the transitional housing. And I think it's just a great way to reintroduce people from our prison systems to our communities. And we all need acceptance, encouragement, and help in order to be successful. And we should not let fear or ignorance or apathy keep us, the community, from doing our part in helping them to succeed in their journey. Thank you.
Thank you.
Jordan Hasselbach. Following that would be Allison Dredke, and then I think we have a couple Zoom testimony.
Hello.
Hi.
I'm Jordan Hasselbach. I live at 816 South 32nd Street in the Woods Park neighborhood. I grew up on 34th and F, which, being on the other side of 33rd Street, I believe is the 40th and A neighborhood, but I went to the same schools. I went to Randolph, I went to Leffler. I was in Troop 28 at St. Teresa's, where I earned my Eagle Scout award. My dad spent 2 years in a federal penitentiary at Fort Leavenworth, Kansas. And as I said, you know, he raised his family in this neighborhood. I would like to see these women be afforded the same opportunities that I was when I was a kid. It was a good place to live. We rode our bikes and we had block parties and we walked to Woods Pool. I walked to school. So I have that personal connection. I also have professional experience in this realm. I work with young people, 16 to 24-year-olds, that have had experience in the juvenile justice and child welfare systems. I want for these women what I want for my participants, which is, you know, for us to extend our empathy to them. I think that, you know, it's worth mentioning that those systems, juvenile justice and foster care, are often feeder systems into the adult criminal justice system. These young people have experienced trauma in their life that is, you know, a contributing factor in all of this. And I also am a dues-paying member of the Woods Park Neighborhood Association. I think I even volunteered to be on the board. So when you hear, I know that there's a letter of opposition that's from the Woods Park Neighborhood Association. You'll hear testimony from other people that are members or on the board, and I want the commission to know that there is at least one dissenting voice in the Woods Park Neighborhood Association. So I guess that's really my impetus for being here. I don't want them to speak on my behalf in this instance because I have the different perspective. That's really all I have.
Thank you for sharing. Thank you.
Allison Janacek or Jarabet, or I'm not exactly sure, Janecek.
Is Allison here?
I'm here, but I didn't want to speak.
Oh, okay.
Oh, okay.
Okay. Okay, I do believe we have two individuals via Zoom in support, Gil Peace and Ivy Lutz.
Do we know who we're connecting with first? We'll see.
Hello, this is Gil from P Studio Architects. Can you guys hear me?
Hi, Gil. Yes, we can.
Okay. First of all, I just wanted to say thanks for the time. Our office has been helping Tina put together the submittal plans. We've also been working with George as well as Rich and Megan at Building and Safety, putting together the submittal plans, making sure that the facility is going to be safe and that it's going to meet code. You guys already talked about some of the issues that we've reviewed, the parking. We've also gone through and done an extensive survey to make sure that we've got all the right smoke alarms, egress windows, the proper code requirements to make sure that it is a safe facility. And with that, I'm going to turn it over to you guys in case there are any questions. I'll keep it as brief as possible.
Gil, did you make any changes to the property then? Interior changes?
No, we are not proposing any changes to the interior or to the exterior. The only changes are the ones that George highlighted, which is the outdoor or the alley loaded parking to make sure that we've got enough parking to serve the facility.
And has there been a discussion about a fence?
There probably has been, but I'm not aware of it. But if it's anything that needs to be reviewed or taken up with the historic preservation, we certainly will.
Thank you.
Thanks, Gil.
I believe we have Ivy Lutz.
Hello, can you hear me?
Hi, Ivy. We can hear you.
Hi, great. My name is Ivy Lutz. My spouse and I own our home at 536 South 29th Street. We've only lived here since October of 2018, but I attend the law school at the university, and I plan to build my life here in the Woods Park neighborhood. I am in support of the special permit to allow for an alternative to imprisonment facility up to 6 women. As you well know, prisons in the state of Nebraska are overcrowded and rehab facilities have waiting lists. Therefore, individuals are not receiving the quality of care that they should. Once released into our community, these individuals not only have to battle finding employment, but also safe housing with their criminal records. It is almost, I don't want to say it's impossible, but it's really hard to get somebody to accept that you're a felon, and then I'll just move on. Also safe housing for, okay, but many struggle to remain sober. Tina has over 16 years of experience and is certified in mental health. This facility would provide clean and sober living for women who just want an opportunity to see tomorrow. There's addiction issues throughout our town. You can see it up and down O Street. And these women deserve the opportunity to change their lives. My final point is that this is honestly the safest place for these women, and in our neighborhood just down the street, I know for a fact that there are felons and people who've committed misdemeanors all around us all the time. But these women would be in safe environment where they can learn to be human again, because incarceration strips you of your dignity. So I support the special permit. Thank you.
Thanks, Ivy. Does anyone have any questions for Ivy? Okay, great. Thank you, Ivy.
Yep.
Okay, so I think, is that the last testimony in support?
I believe so.
Okay, so we're going to switch over to testimony in opposition.
Okay, I'm going to go off my list again. I have Pam Hirschman, Jane Sebi, Tom Kiefer, and Dominique Sheeny.
Hello.
Hi.
I'm Pam Hirschman. I own 423 South 28th Street. I've owned it for 31 years. When I bought it, I'd looked for about 4 or 5 years before I purchased it. Looked in a lot of neighborhoods. I grew up in Eastridge, looked throughout Eastridge, and finally decided I was looking for something larger, on a more homey atmosphere. And Eastridge was really homey, but not like this. This had big trees and looked like where I wanted to spend the rest of my years. My problem with this whole proposition, number one, I'm not afraid. I worked for 13 years for the Department of Corrections at Lincoln Correctional Center in the living unit with the guys. I was the only female, most every single shift. Me and 123 guys, and one other guy on the other side, wings away, behind a lot of glass. So if something went wrong, I was on my own. So it isn't fear. It definitely isn't ignorance. Love those two words. I've had a lot of experience with men, not women. So if I was going to be in danger, I've had my fair share of chances. My problem is not the people. Actually, I've sat in your front yard and I've talked to them. I've talked to one woman who's now living there. Quite the nice lady. She's very pleasant. I sat with one of my neighbors and talked to her, and she was a lovely woman. She really is. She's quite friendly, very articulate. She's a nice lady. It isn't her. She's not the problem. The problem is, in the length of time that the Arciagas were renting out their home, we've had tenants that threw things through the front door, kids' toys for kids that were living in that home at the same time as this gentleman. He got drunk, got angry, decided he was going to toss everything through the front door. We called the Arciagas at like 1 in the morning when this was all going on. It took them 3 days to respond. The police were there in about an hour and a half, and the drunk was escorted away. We've had more than one occasion where there was no response from the Arciagas when we had problems with their tenants. I don't see that this situation is going to improve any. And as far as the parking, if we put 6 cars behind that house, they're going to be parking in the yard. In 2013, I own a sailboat. That's my hobby. I brought my sailboat home. I went and parked it in my backyard behind a fence. I needed to do something to the interior of the boat. My driveway is really, really short, much shorter than my boat. So I couldn't put my boat in my driveway to work on it. So I decided to put it in my yard. The police came along and told me I couldn't do that. I couldn't put any vehicle in my yard, they said. So I called the City Planning Commission and I was told, you can't put a vehicle in your yard. You can't put anything motorized or non-motorized in your yard. I had to take that thing out of my yard, take it back out to Branched Oak, and had to get special permission to Branched Oak to drive all the way out to Branched Oak every single evening to work on my boat. So tell me, how can you park 6 vehicles in a lot that's big enough to park 3 at best, and I mean at best, and still somehow manage to get 6 back there? It isn't going to work. I think we need to redo our measurements if we think we can get 6 back there. There's some problems here. People aren't coming out to measure. People aren't coming out to look. We're doing it all on what we see on a plat map. There's some other problems. From 1995 to 1998, I stood here at every single meeting you guys had, asking to side my house, because the siding wasn't staying on the house on the west side of the house. It was old. My house was built in 1905. It was falling off. It was cedar. And I was told no for 4 years running. Finally, at the end of 1995, I was told, yes, you can put it up on the west side of your house. Can someone in this room please tell me how you get siding to stay on one side of a house? I went back to my siding guy and I said, can we put it up on just the west side? The city's given me permission for one side of my house. And he started laughing at me like I was some kind of lunatic. And he said, you can't put it up on one side of a house, lady. It's got to go up on all four sides to stay up. So I came back to one more meeting and I said, you can't do one side of a house unless you nail it up, and then what's it going to look like? They finally said, okay, you can put it up on all four sides of the house, but this is what's going to happen. And your neighbors are going to pay the price. It's going to ruin your tax value of your house. Your neighbors are going to hate you for it. And they gave me it's going to ruin the historical value of the house. Well, in the 4 years that I was standing here arguing for it, another neighbor cited his house without permission. Nothing happened to the historical value of his house. The next year when my taxes came out, my value of my house skyrocketed, the exact opposite of what they said was going to happen. And my house still looks okay, except for it's a little dirty and you do need to scrub it. But this goes in, not just my house, but everybody around us. We're going to have to tell people, this is what's in across the street. We're not going to be able to sell our houses as easily. Even though the things are selling in Lincoln like a hotcake, our houses aren't going to sell. This is going to hurt us. This is going to make our values drop. And this time, I believe it. It's probably going to happen. So you're not just affecting one house so she can sell it for a whole lot more if it's a piece of commercial property. You're going to be hurting everybody around them, including behind them. And so all that house that I bought 31 years ago, because it looked like such a nice family neighborhood, and now we're all trying to fix them up so we can sell them to young families because we all have 3 and 4 bedrooms, it just went down the toilet. So it's not fear, it's not ignorance, it's not wanting to keep that nice lady that's living there right now into some other place where she was going to have a hard time. It's not. I've been a social worker for 45 years. The last thing I want to do is hurt somebody. All I have done for 45 years is try and hold people up. I don't want to hurt her. I actually liked her. She was pretty nice, and she was very, very pleasant. I don't want to charge her $90 a day to live someplace or $1,800 a month, which is nuts in rent. When you don't have a job or can't find one, I'm sorry. That's crazy. That's all I got to say.
Thank you for sharing.
Okay, we have Jane Seebe, Dominique Sheeny, and Mitch South.
Hi, I'm Jane Sebi. I'm with the Woods Park Neighborhood Association. I'm currently treasurer, former president, lived in the neighborhood for over 25 years. Someone raised a question about, do we know of any other properties operating at transitional facilities? Yes, we do. As a matter of fact, there are 2 for-profit organizations, LLCs, in this city currently operating transitional housing. Most of them are coming in under group homes. We suspect some of them have no permits or licenses whatsoever. They're being considered residential property as long as there are 3 or few people. Nobody knows. There's no way in this city to keep track of these things. We have spent roughly 4 months, the neighborhood association, many of the neighbors, myself, combing all the records we can find in the city, all the records we can find in the state, talking to agencies, talking to probation, you name it. They were out there, they're sliding under the radar, and the ones that we're having the biggest problem with are for-profit organizations. I'm an attorney. I am writing a letter to Michael Hevecan, who is the Chief Justice of the Supreme Court of Nebraska, and I'd like to read parts of it to you. I won't read the whole thing because it's long and it's lengthy, and who wants to hear an attorney rattle on? Dear Sir, I noted your State of the Judiciary 2020 report, your reference to a transitional living assistance program to provide short-term housing to recently released prisoners. This program, via LB 605, if you want to look it up, was established in 2017, this is according to the Chief Judge, the details, to reduce prison populations by providing structured, stable housing in Nebraska communities. This program is now being established in Lincoln, including in my neighborhood, cutting a couple of paragraphs. It will come as no surprise to you that the neighbors around these properties are extremely concerned about their presence, the transitional living facilities, for a number of reasons. The properties are being operated by for-profit organizations. They're individual houses located in established owner-occupied neighborhoods, several of which have historic designations. The companies do not provide any notice to the community of their intent to use these properties as extremely short-term, fast turnaround rentals. Contrary to what you heard earlier, the owners do not have a representative on the property, at least Mrs. Asiago doesn't. The other three that we are aware of, and one that we have somebody living next door to, does not know of any supervisor on that property either. Well, in both cases, the owners live several miles away and rely on camera systems to survey both the property and the occupants. As one company representative told my neighbors and me, she expected people living around the property to call the police if any trouble arose. While there are documentation of parole officers visiting occasionally, there are also several reports of friends stopping by at all times, noise complaints, and police showing up to make arrests. I would add that the details include not just the present property under consideration, but the other properties around the city that we know are operated under this program. In Lincoln, at least, the permit for transitional living facilities attaches to the property itself and not to the entity operating the facility. The permit is also permanent, according to George. While we are attempting to get this status changed in Lincoln, for the present, it means that any neighbor who wants to sell his or her home must disclose to potential buyers that a residence of persons transitioning from prison who are considered at high risk to reoffend is just across the street. Home sales in the area will drop and prices will plummet, of course. Given that many homeowners in the established neighborhoods have a significant portion of their assets tied up in their homes, this is an extreme and unreasonable economic burden on them that cannot be justified as anything other than a government taking of private property for a state purpose. The permanence of the permit also means that one company can sell the transitional facility to another company for the same purpose with no new application for a permit required. This is per Lincoln Building and Safety and the planning departments. The new operator can operate as he or she sees fit and admit any newly released prisoner to reside there with no concern for the impact on the neighborhood. Families with children are especially nervous about this program as it seems to have no limitation on which person is assigned to a facility in their neighborhood. One of the for-profit companies in Lincoln recently bought a house 2 blocks away from a large daycare center. It apparently has no obligation to notify the center about its existence, much less whether one of the residents should be of concern. My neighbors and others with transitional housing, my neighborhood and others with transitional housing are equally concerned about the well-being of the residents in these facilities. According to a former resident I personally talked with, the operators of these facilities can evict them at any time for any reason, as happened to her and 2 others while she was there. She ended up living at the city mission. The neighbors who met her were surprised to learn this, as they thought she was very nice and doing her best to get along. Reports have been received from residents describing drug use and overnight visitors in violation of facility rules. We have video of this, by the way, in some of these cases, if you want to see it. Reports have been received from residences that the in-house programming was whatever the operator or her daughters wanted to talk about that day, whether it was relevant to the resident's situation or not. Numerous videos from neighbors' homes, that would be the home ring system that most people have these days, from security cameras show multiple people coming and going at will. Either the facility was housing more than allowed by the permit, or visitors were coming and going for significant portions of times when we were specifically told that non-residents were not allowed on the property. The probation or parole officer who attended our neighborhood meeting about this issue was supervising individuals living at one of the for-profit company's facilities. This officer seemed to know nothing about the facility itself, whether it had a permit, whether the facility met all housing codes. It didn't, as per building and safety. How the residents were adapting in the neighborhood, or if there were any problems with the neighbors. She seemed to know little about the service provider. Our impression was that she had found a place for the individual to live, and that was one less thing she had to deal with. The residents have no recourse for any unreasonable or unlawful actions of the operator against them. Either they cooperate or they are out. One resident reported that she had not eaten all day, but was denied the opportunity to leave the residence and get some food because it was after 9 p.m. While my neighbors and I agree that this program could have great results in reducing recidivism, what we're seeing is ineffective and unsafe for both residents and neighbors. Furthermore, we cannot find anyone who takes overall responsibility for this program at a city, county, or state level, and who will address these problems. At the city and county level, each department only looks at its particular area of responsibility, even when other problems are obvious. There are no references.
Can you wrap it up in about a
Sure.
minute?
Listening to all these groups describes their responsibilities on this program is like the old tale of a group of blind men describing an elephant. Each could only talk about the particular part he was touching, none could reflect upon the whole. I am contacting you, the Chief Justice, because someone needs to see the whole elephant and ensure that it doesn't cause harm to those it serves, as well as the community in which it resides. You, as the head of the judiciary branch of the state of Nebraska, have the authority to identify an appropriate person or committee to look into this matter. Please do so in order that a promising program can be both effective and accountable. Thank you.
Any questions for Jane?
If you would like documentation on the number of residences owned by the for-profit organizations, I can provide that, addresses and names. Thank you.
Okay, and I misspoke. Tom Kiefer is actually next, then followed by Dominique Cheney and Mitch Stumpf.
I have copies of my speech.
You can just leave them in the envelope there.
Good afternoon, good evening. My name is Thomas Kiefer, K-I-E-F-E-R. I live at 426 South 28th Street in the 1908 Ludwig Taylor House, which my wife and I have owned for 33 years. I am here today to voice my very strong opposition to SP 2005 and the Alternative to Imprisonment Facility Permit request. Since this is the first such application, and with similar facilities proliferating in Lincoln, it will set a precedent for future applications. The staff's justification is too weak and the conditions for its approval too inadequate for this important role. The justification for approval is that the proposed use is comparable with a duplex and group home. This comparison is faulty. A duplex provides separate living, cooking, laundry, and sanitary facilities for up to 3 unrelated persons in each unit. In contrast with the 420 South 28th property, there will be up to 6 unrelated persons and up to 2 staff sharing a single kitchen with 1 refrigerator, a single living room, and only 1 full bathroom. Duplexes do not have staff members or probation officers frequently visiting, inspecting, and counseling 6 unrelated adults. Facility residents will be cycling in and out every 1 to 3 months, unlike a duplex's residents, which typically live in a unit on a long-term basis. Finally, unlike a duplex, we and our neighbors will have to have a formal notification in our seller's agreements, notifying the buyer of our homes that an AIF is adjacent to the property. The staff's comparison with a group home is also faulty. Group homes have distance requirements. In contrast, this AIF permit allows the applicant to avoid distance requirements of any sort. 420 South 28th is less than 1/2 mile from at least 1 legal group home, is less than 1 mile away from a domestic shelter, and is near multiple transitional facilities already operating as rentals in our neighborhood. Moreover, if this application is approved, you will be inserting a commercial enterprise, a for-profit correctional facility within 100 feet of 12 residential homes. 6 of these house children, 1 a disabled adult, and 4 house retirees. These are vulnerable persons deserving consideration, especially given incidents of trespassing and loitering which have already occurred. Distance requirements protect a neighborhood's residents as well as facility clients. This is why Omaha, Kansas City, and Denver all impose geographic distance and other requirements on transitional living facilities, or to locate them away from R2 neighborhoods altogether. I sent a supporting document and that discusses this for Denver, Kansas City, and Omaha. Furthermore, group homes require a license from the state of Nebraska. The licensing process functions as professional verification and as an enforcement mechanism. In contrast, this AIF requires no such process because the Department of Corrections has turned any licensure and zoning requirements over to the municipality. Please see supporting document 2. But Lincoln has no regulations on an AIF permit, other than restricting the number of residents to less than 16 and requiring a public hearing with possible conditions placed on it. The staff report, which grants this first ever AIF to someone with no prior experience running a transitional facility, reflects this complete lack of regulations. In fact, with SP 20005, the staff of the Planning Commission has failed to exercise its full regulatory authority. In the staff report, under analysis paragraph 3, it states, quote, "The Planning Commission will act pursuant to their authority to impose such conditions as are appropriate and necessary to ensure compliance with the comprehensive plan and protect the health, safety, and general welfare." There are no such conditions in this report. None. Every condition the report does have concerns the property's appearance, lighting, and parking. The health, safety, and general welfare of both facility residents and the residents of the surrounding neighborhood are not addressed by these or any other conditions. Most concerningly, it appears this permit is irrevocable and permanent as long as the cosmetic conditions are satisfied, no matter what other detrimental effects the facility has on its residents or the surrounding neighborhood. These are very serious, even harmful omissions. And for an application that will function as a precedent, it contradicts sound urban planning and betrays the comprehensive plan's commitment to protect inner city neighborhoods. Given the lucrative potential transitional living facilities provide, this lack of regulation will open the door to the exploitation of core neighborhoods like ours and will create incentives for outside interests to turn much needed single-family middle-income housing into money-making enterprises paid for by corrections. Please see supporting document 2. For these reasons, I respectfully ask you to reject the SP 2005 application and any other AIF permit request until the necessary codified and enforceable regulations are in place. Thank you.
I have what may seem like a strange question.
Mhm.
What's your wife's name?
My wife's name is Maureen Honey.
Okay, I was just looking it up on the assessor's
Mhm.
website, and I noticed that the name didn't match. Thank
Mhm.
you.
Okay, thank you. Any other questions?
No, I don't think so.
Thank you.
Okay, we have Dominique Cheney, Mitch Sump, Dan Sloan, and then Tamara Sloan.
Good afternoon, good evening. Members of the Planning Commission, my name is Dominique Cheyenne, and my wife and I live at 1636 South 23rd Street. We have been Lincolnite for 41 years. I reviewed the staff report for conditional approval associated with SP 20005, and I want to attract your attention to what I believe are some flaws associated with the reasoning. I thank you in advance for considering my comments, especially because you may have already heard some of the argument, but I want to dwell a little bit deeper in them. In the justification for recommendation section, the following statement is made, quote, "The external land use effects are not any more significant than those of a duplex. The existing house will retain its appearance and can be converted back to a single-family residence if the use would discontinue." The first part of the sentence basically states that the physical footprint of this single-family house is similar to that of a duplex. And nobody would disagree with that. However, the second part of the sentence then now assumes that this single-family home is in fact a duplex that could be potentially converted back to a single-family home should the need arise. This is, as you know, a circular agreement. In other words, you start with something that you want to be the expected outcome. It may be a common practice in this day and age, but it's also very misleading, especially in the context of an important decision process. This flawed argument is repeated in point number 8 and number 11 of the report, where statements such as, quote, this number of persons at additional land use comparison would be similar to a duplex, and, quote, the inside will remain the same as per the layout, which would support the idea that this is a duplex that could be converted back to a single-family home. However, the layout that you can see in the permit is clearly that of a single-family home with one kitchen, one bathroom, one dining area, one living area, 3 bedroom, 1 dormer, and 1 laundry area. Let us be extremely clear. A duplex is a residential dwelling that offers separate cooking, washing, living, sleeping facilities for distinct and separate groups. And this is not the case. This is a nice single family home, period. My time is getting short, so I will leave you with a few facts. Now, 1. The landlord of this single-family home is asking you for the permission to derive guaranteed income associated with housing 6 unrelated individuals with past criminal conviction, and using the applicant's word, are, quote, assessed at high risk to reoffend, end quote. Yet, the landlord of this single-family home is willing to leave these tenants totally unsupervised during most of the nighttime hours. The permits application is extremely vague when it comes to inspiring confidence that, in fact, supervision will be in place. Quote, 1 to 2 workers staffed at one time during the day/night hours at most, end quote. 3. The applicant has not demonstrated that the property has enough facilities to support the washing and cooking needs of 6 unrelated adults. Finally, in the light of the current health guidelines associated with COVID-19, it is evident, eminently evident, that this single-family dwelling will not be able to support compliance with basic practices such as social distancing between unrelated people and or short-term quarantines, if ever required. If you approve this special permit as it stands, I'm afraid that you will be supporting an extremely low set of residential standards, as you will open the door to more absentee landlords who will delight at the idea of collecting a guaranteed amount of revenue from the state while having relatively little to invest into the venture. This would not be right. I'm respectfully asking you to deny the permit as it currently stands. It is a smart thing to do, but more importantly, it is the right thing to do. Thank you so much.
Okay, Mitch Stump, Dan Sloan, Tamara Sloan.
I signed in opposition, but I had noted I would not speak.
Okay, thank you.
I'm Dan Sloan. My wife Tamara has opted not to speak in the name of time and all of that other eloquent arguments that you've had. I think they've covered all the points that I have. I live at 405 South 28th Street, across the street and up a couple of houses. I bought my house in about 2000, so I've been there about 20 years. The house I bought is a grand old house. It was a party house. We had holes in the attic walls. I mean, it's the old ballroom on 3rd floor, but I mean, we were legendary. When we bought in, the neighbors just threw a party almost because they were so glad to see all those bartenders move to some other neighborhood. Over the years, we've we have invested considerable time and money into the home. Last year, we were fortunate enough to get the Historic Preservation Award for the remodeling and rehab of the house. It's the historic Daniel Kelly house, and it's a fabulous property. Contrast that with the Arciagas, and I consider Tommy a good person. I wouldn't say we're close friends, but Tommy and Tina, they've got good hearts. They're not bad people, but their path is different than ours. They bought the house not far off of when I did. They lived there for a while, and then they essentially fled to the suburbs, and they've been absentee landlords ever since. You've heard some of the stories of, the problems that we've had over there. Plenty of police calls. I wasn't home that night, but I believe there was a knifing in the front yard. That harkens back to the kind of stuff that we fought in our neighborhood for years and years. Lincoln needs families to live in the inner city. They need affordable housing. That's what we have. The bigger problems that we have are with absentee landlords. A permanent permit for a for-profit transitional housing unit there essentially guarantees this will be an absentee landlord situation forever. I don't think that that's appropriate. I really don't. The house occupies virtually all of the lot. I'm not sure how you could have a security light and not shine it into Tom's bedroom. I don't think that can happen. We see all of the ways these very ingenious females go about circumventing the cameras. I don't want to be the enforcement for this place. I don't want to have to watch them all the time and call anybody. I want to live in my neighborhood. I want my family to be safe, and I don't want someone else to destroy that. We fought too long and too hard for that. That's all I have.
Any questions for Dan?
Okay, thank you.
Thank you.
Okay, I believe the last individual is Randy Smith.
Last, hopefully not least, my name is Randy Smith. I live at 705 South 32nd Street in Woods Park neighborhood. I'm the current president of Woods Park Neighborhood Association. Our board of directors was approached back in January by some of the residents on the 400 block of South 28th Street with their concerns about the facility, which is already open and operating with 3 individuals and has continued to do so. We met, Jane Sevey and I met with about a dozen of the neighbors privately several times to hear their concerns about this facility on their block. As Tommy mentioned, Tina and her family attended the February meeting of the Neighborhood Association to formally make a presentation to discuss the facility. The meeting was also attended by a large number of neighbors. Things did get a little heated, but there was heat on both sides of the issue. At that meeting, the board, as then currently present, voted to oppose granting the special permit for this facility. We, as a neighborhood association, I think the neighbors as well, recognize the need for transitional housing for people to successfully exit the correctional system. But we feel that a residential neighborhood zoned R2 is not an appropriate location for this type of facility. For a little context, a 420 South 28th Street is shown by the red rectangle. It's in a large area of zoned R2 in the Woods Park neighborhood, and it's smack in the middle of the East Lincoln Elm Park Historic District. Looking at the block itself, this is a stable, affordable, middle-income neighborhood. The adjacent and nearby properties are almost all owner-occupied, single-family residences. And as you've heard, many of the residents have owned these properties for decades, invested large amounts of time and money in preserving and upgrading these residences. These are mostly large homes on relatively small lots. So there's very little distance between this facility and the neighbors on either side. We don't feel that the neighborhood opposition is rooted in fear of the facility's residents, as you've heard from other testimony. Concerns are more with the overall impact of the facility's presence in the neighborhood. You've heard that there have been incidents of men lurking around the facility at night, trespassing on adjacent properties. Tina has made progress in upgrading the security for the facility, but it's not clear that that's going to eliminate the situation. Until recently, there was no talk of a 24-hour staff presence. That'd be great if they're going to carry through with that, but as noted previously, there's no condition in the special permit as proposed that would require that. It's overnight when bad things happen, and the neighbors don't want to become the security system for this facility. And as previously stated, the neighbors are concerned that the presence of this facility in the neighborhood will have a large negative impact on their property values. It does seem the state probation department has basically left regulation of these transitional facilities to their host cities. Lincoln's zoning code for this type of facility was set up in 2005. The legislature authorized these types of facilities in 2015. So our zoning regulations have not caught up with the reality of the situation. We're concerned the probation wants to understandably transition these folks out of the prison system and into the community, which is a laudable goal, but they're leaving it up to the cities to determine where appropriate locations for these facilities lie. So we feel it's premature to issue any special permit for an alternative to imprisonment facility in Lincoln until reasonable zoning restrictions are put in place to determine what are appropriate locations for these types of facilities. And we feel that single-family R2 residential zoning is not the appropriate location. Thank you.
Any questions for Randy? Thank you.
Thank you for your patience and what must have been a very long day for you folks.
Any other testimony in opposition? Okay. Staff questions. Go ahead, Dick.
George, is it correct that you can have 3 non-related people living in a house without any permits or anything, correct?
3 unrelated persons, yes, that may or may not be related to a probation situation. And I should have stated in my opening that the comparison to the duplex was kind of geared towards the number of persons. If you have a duplex, you could have up to 3 unrelated persons in each unit, so a total of 6. That's kind of the general basis for the comparison.
Chams.
Sorry. I have several questions. Are you aware of any police reports at the residence right now that have been reported or anything in that manner?
I am not aware of any police reports. I would mention one of the review agencies was the police department, and respective of the special permit, they did not have any concerns.
Okay, perfect. And then it sounds like it's already kind of open and operating. Are we able to put on a condition with 24-hour staff presence, or is that already implied in the application?
I might have to defer to legal counsel. I don't know if we could place that specific level of condition, but
Okay.
I think I would defer to law department on that.
He's coming up.
He's right behind you, George.
Sorry.
Oh, sorry.
Yeah, they're not here for you. Tim C, City Law Department. I think it's important that we keep in mind that we're talking about land use questions here, not internal operations of a facility.
I think there's a temptation to go down a path of, can we put in a number of requirements about how a facility is operated that don't necessarily relate to this as an approved land use. So I would caution you with respect to anything that had to do with something like a 24/7 requirement on staffing or something like that. But all I can do is give advice, and that would be my advice at this time.
Can I piggyback on that for a second while you're up here, Tim?
Yeah.
But with regard to restrictions on domestic shelters and group homes, for example, those are about how far apart they can be from each other.
Right, so group homes are conditional use. They have a spacing requirement. So you have I don't recall the number off the top of my head. I think it's
Right.
somewhere around 1,000 feet between group homes. But that is a land use issue in terms of how close are they to each other, not who's on site all the time managing the operation. So that,
Right.
maybe you weren't trying to get to a distinction there, but
So when we're saying that, I mean, there are some restrictions on, domestic shelters but it's all about location. It's not about programmatic
right,
issues.
So we're a planning commission dealing with land use issues, not a regulatory body that is dictating how a facility is run under our license per se. This is not a use. This isn't a this is a land use permit, not are you a licensed facility as a alternative to imprisonment under the state of Nebraska regulations or something like that, which, by the way, don't exist. I'm not suggesting that they do, but just to draw that distinction, you might say a healthcare facility has land use things that go along with them. They also have to comply with DHHS requirements that go along with that. Those are two different things.
I want to make sure that I'm understanding or interpreting this correctly. So there is a limit, requirement that there's only so many group homes within a certain space. Is
Right.
that?
They have spacing requirements.
Okay, so that's really why. Okay, I think I'm picking up. Okay, sorry, Shams.
Okay, sorry, George. Okay, thank you. On page 2, number 5, can you just maybe make that a little more clear for me? So it says 1 to 2 employees will be staffed at one time during the day, night, with 1 staff person on the premises from 7 to 11. Can you tell me what your perspective is on that?
Yes, so that was the information provided by the applicant. It wasn't that staff or someone from the city was asking them specifically for that staffing level.
Okay. So I'll defer to the applicant then with
Yes.
that question. Thank you.
I'm still confused about, I looked up Hanu House when they came through with their special permit. So theirs is called a residential healthcare facility. They're accomplishing the same thing here pretty much. Why are they coming under a residential healthcare facility and this is coming in as a transitional?
Yes, and I apologize, I'm not familiar with that specific facility. However, I will say that when this was presented to the city, building and safety, law, and planning departments all looked at it, and it best fit the definition for alternative to imprisonment facility. However, as has been mentioned, there are a couple of options potentially. There's having up to 3 unrelated persons. There's potentially a group home. There's potentially a residential health care facility. But this proposal fit under the alternative to imprisonment.
If there was a reason.
Hold on, I think Steve
go
has
ahead.
something to say about that.
Steve Hendrickson with the Planning Department. Just to explain the Hanu House, the definition of a residential health care facility lists examples that aren't meant to be exclusive, but it says examples of this facility include assisted living, nursing care, memory care, convalescent home, hospice home, or a group home with more than 16 people. Hanu House was considered a convalescent home. The people were staying there for a very short period of time to convalesce. They lived somewhere else. This was not their residence. So in the Hanu House and the second one that was also approved were all deemed to be convalescent homes. The operation as described here didn't fit under a convalescent home. This is their residence as of the moment. They're a specific facility. The people on Hanu House were not part of an alternative to imprisonment. So in looking at the definitions, it fit best under alternative to imprisonment. It was not considered a convalescent home. Hanu House, which didn't have really anything necessarily to do with imprisonment and had more to do with mental health, was viewed as a convalescent home.
Although I am under the impression that people do stay overnight at Hanu House.
Oh, absolutely. What I'm saying is that their permanent residence was somewhere else. They might stay there for 3 days, a week, but they did not change their residence. They did not start having their mail necessarily delivered there. They did not end their lease somewhere else. They needed some convalescence. They needed some time away from their home situation, and then they returned back to their home situation afterwards, by and large.
I thought that was the other facility that they have.
They have two facilities with us. I think my memory is that both of them came in as convalescent homes.
Okay, I
And
thought
I was just
that,
trying to explain that
Yeah.
particular question about why is Hanu House different than this one?
so I was under the impression, and I could be wrong, but I was under the impression that Hanu House is serving people that are coming out of prison, directly out of prison, so it would be the same situation as this, where
Right.
they're not coming from a different they don't have a different
Right.
residence, they're coming
Yeah.
and to getting springboard back into society.
Yep. So, again, to explain, when you have a use, sometimes that use has accessory uses. So, again, I don't recall the circumstances. We're not really here to debate that particular use. But if somebody 90% of the time is for convalescence for mental health and occasionally has people who are also there as a post-release, that was viewed as something different. Now, again, if you want to follow up on that particular one, I'm just trying to say.
The problem that I'm having is that to me, this is the same facility. The same things are happening in this facility as in this facility. So I really don't understand why they're getting residential health care and this one is being called something else, because they're doing the exact same thing.
They were, in our view, were not doing the exact same thing. They were doing two different things, and thus, after.
Why I'm saying, like, I think the one place that is run by MHAN is, like you described, like they have a permanent residence and they're, taking a break from that. They don't getting their mail there. I completely agree with the one is like that, but I'm not sure the other one is.
Okay.
So, and that's the one I'm referencing.
Yep. I'm just saying, remember, you need to view this as an alternative to imprisonment.
Sure,
The
but.
applicant is not contesting that they're applying for this particular use.
But for me, I mean, when I'm making my decision, it's hard for me to make a decision and allow one over here that's doing the exact same thing, only we're calling it a residential healthcare facility. Well, this one is not. And so that's why I'm wondering, like, should they have applied for a residential healthcare facility?
Commissioner, I appreciate your questions. I appreciate where you're coming from. With all due respect, I think we need to focus this conversation and this decision on the application that's in front of us. And they've applied for an alternative to imprisonment. If there's another facility out there that has another permit, that may be the case.
Okay, so let me rephrase my question a little bit then.
Mm-hmm.
So how was, to me, this is no different than the previous situation we had today, where, they came in and wanted an ADU, staff suggested a CUP. So where did the applicant, how were they directed to file for this particular designation?
I'm here to tell you that the issue is they've applied for, regardless of how they came to that conclusion, ultimately the applicant turns in an application. They sign the application and say, I'm asking for a special permit for an alternative to imprisonment facility. That is the question before the Planning Commission, and those are to be considered on a case-by-case basis as they come before this board and as the evidence is presented before this board, not comparing them to other facilities that are not before this board at this time and for which there is no evidence in the record today about what those operations are. So I'm just asking us to create the clearest record that we can, that this is a decision based on the evidence that's been presented today on an application for an alternative to imprisonment. And that sounds harsh from my perspective, perhaps. I don't mean to be disrespectful, but I'm trying to keep a record here that is as clear as possible.
May I piggyback on that? Along those lines, though, let's say the legislative history is relevant, and in particular, if we're looking at some sort of comparison to domestic shelters and group homes that do have proximity requirements, whatever the reason for those would be, you know, and why when those were enacted, they decided that was important to have as part of the statute. Why would that same reasoning not apply to this type of facility?
I don't know the answer to that. I know that the city council of this city who approves these ordinances did not put in one of those requirements for this kind of a facility.
Okay. Okay.
Thanks.
Does anyone else have questions?
I think Shan still has some questions. Oh.
I'm going down my list. I think my questions are for the applicant.
Thank you.
Okay. Yep.
I feel like there are some discrepancies in some of the information that you shared with us with what was in, for example, the handbook on staff hours and visitors, and obviously, as we've discussed, that wouldn't necessarily be in the conditions, but I do want to get a sense for you know, where reality is, and it kind of goes with Commissioner Albadre's question as well with regard to the hours.
Sure.
So do you want to clarify that a little bit for us?
So initially when we did the handbook, we had worked on that when I got approved through probation, and that was in November. And then when we decided to do the permit, and I found out about the condition permit, the special permit, that kind of thing in January, and then I went to the Woods Park meeting, that's when I got their feedback, and so I was tailoring what I was doing based on what I heard to be acceptable in the neighborhood.
Okay.
So some of those
So the handbook
references-
just hasn't been necessarily adjusted to
Yes,
reflect what
yes,
you're intending to
yes.
do? Okay, that makes sense.
And so they had concerns of staffing. I did not have to do that, as George stated, for condition. I didn't have to put in so much staff, but I felt it was important. So I said, sure, I'll do that. I started with 8 to 10 women. They didn't like it. I said, I'll stop at 6. And I've done everything I can to appease the neighborhood.
Sure.
I really have. I was just going to piggyback on when you guys were talking about the R2 zone, so I could only do residential, group home, or AIF. I didn't want to do AIF. That was the only alternative I have. The healthcare facility wasn't offered in the R2 zone. I think it's only R4 or R6 where you can do that. So it's where the building's physically located. And so, of course, it is the same thing. We're dual diagnosis. We do mental health. We do substance use. People are coming out of incarceration. It's the same thing. They're staying overnight. I just have to be the one to do the AIF.
One of the things that was mentioned in the handbook, and again, I understand that it may not be updated, but something about licensed by the state of Nebraska was mentioned. What does that mean?
So Mark Luger from the state of Nebraska was supposed to be here, and
we did get his information.
Yeah, well, he called
Yeah.
me at 10:15 to say he got with the legal department at the state, even though he told me that for a whole month he'd be here, and it was too late to get it into the thing by 10 a.m. this morning. But per our conversation, you do not need a MHSU license for the halfway house. You plan on opening according to the regulations attached below. And then there's 2 actual references for that, because when my facility down at Heritage Square, I have to have license. So that's why I called. I mean, I know how to do that. And then he sent me something today. I think he just said, "Good morning, Tina. I'm sending you some state statutes that may be helpful to your defense. I've already sent you regulations 175 NAC. You guys don't have this. It's the Purpose of Act,
We do.
healthcare facility defined." Oh, okay. So he gave me those, and he'd know I don't have to get it licensed.
But the handbook said that? It was just because you thought,
No, this was part, like, when we did, this wasn't in the handbook. So when we did the original permit, I mean, I gave George, it's all separate in that PAT system where I had the licensing information, I had probation for the statutes, I had my handbook, I had my application where I had to get approved through Hannah at the probation, which was a lot of work. I mean, everything was just in separate, in the site plan, the floor plan from the architect, you know, all of that was just all separated out, so it probably didn't look, I don't know.
in my notes, I thought I had written that as I read the handbook.
Right, so the client handbook is
So-
for the people that live there.
Got it.
And what's their expectation. So they're not concerned about, does it need to be licensed through the state? You know, they're not concerned about those, they're just trying to live, right? You know what I mean? It's just
Sure.
how they need to, their code of conduct in that house. That's what's important.
Tina, oh, sorry, are you done, Tracy?
I am,
Okay.
thank you.
Just to kind of start off by saying, I really appreciate what you're doing and being a fierce advocate for women. Leaving the criminal justice system is really important. Could you clarify and I know this is not a land use issue, sorry, but just for the neighbors, can you clarify, are you planning on having someone staffing overnight?
Yes.
Is that, okay.
Right, so like when they had stated that, I am an operation, I can have up to 3 unrelated people, which I got scared because the neighbors, some neighbors came at me and said, I can't even do that. And it wasn't pleasant, so I went high up, I don't know who I had to go to get email confirmation I am in my rights to do that. Like, I had to go far for that. And so, because I think, Jose, somebody had sent me a letter stating that if I was responsible homeowner, I would seize all programming right now, and I can have 3 unrelated. So I have started in January, but I chose to have staff there so people feel comfortable. You know, someone had mentioned the rings were messed with. I have paid somebody, a security person of the rings. They're going to tell me if they're moved or if they're being played around with. They're not being moved. I mean, that's why I have someone paid to do that. Do you want me to keep talking or?
Oh, no, you're good. You answered my question. So.
I'm going to ask a question about that. So I kind of, this is what I'm thinking in my head. This may not be the correct terminology that you use. So when you say you have staff present, you know, all the time, I kind of think of like you have like a house mother there, or
Right.
you
Right.
know, so someone's spending the night there, or, you know, they may not be, that sounds kind of funny when I say spending the night, but someone is working overnight.
Yes.
And they're there for anything that the residents would need,
Yeah.
issues that come up, security issues.
Yes,
If
and-
the neighbors have security issues.
Absolutely. And, you know, it kind of took me apart. Like, you know, we lived there from 2000 to 2006. I remember the knife incident. It wasn't our house. I mean, it was the absentee landlords that live across the street that have lived in California for 20 years. It's not our house. It wasn't our knifing incident. I did rent to a housing authority. I got my house ready for a woman and it didn't work out. There was some issues. The glass did break. Maureen called me. She has my direct phone number. She lives next door to me. She called. We were over there and we got the glass replaced the next day. It wasn't 3 days.
How do you, and this was asked a little bit before, but how do you decide, how do you screen what women you're going to accept into your house?
So there's no sex offenders, number one, which that's really minimal for women anyways. So on my website, it's a referral form that they fill out and I review, and I talk to the navigation officer or whoever it is to see if it's conducive to the house.
Are these perhaps women that you have seen in your other practice?
Some of
so
them.
You would be familiar with?
Sometimes I'll do jelly vows in the prison system and I'll see them again, but most of them are new. So it's probably like 40-60.
Okay. And I'm just going to go back to one thing. So your understanding is that you have to do the AIF because you're zoned R2.
Yeah. And I'm not rezoning in it. It's protocol to put a rezone sign in the yard, which threw all the neighbors, you know, and I understand because it says rezone, but it's just protocol. I'm trying to explain, I'm re-permitting in the zone. I can't change the zone, you know, but I do have the right to permit the house based on how it's zoned. It's R2, and I have those 3 options.
My understanding is you probably could change the zone, but I don't know that it would be
It would be, yeah, I kind of went over that, yeah. I've went down that avenue too. It'd be hard.
Do you know, I think the answer to this is no, but do you have to have sprinklers or anything because you have six people in there?
Right, so as far as the perimeters, you know, about the parking and parking in the grass, no. I mean, like, Gil Peace is an architect, and he is the one that did our site plan and our floor plan, and he did all of the measurements for the stacking if necessary. We don't even need the stacking though, because we have a new double stall garage, and then we would put, there's like multiple homes off the alley that have cement for we're not the only one that's gonna have it. There's like 4 of them that I know of, and we're just gonna put in 2 slabs, so there'll be 4 parking places. If there's 6 women, you need 1 car for every person. You have 2 people on staff, the 6 women, that's 8. You need 3 stalls, not even 2 and 3/4 or whatever.
So 2 of the stalls are in the garage.
Right.
Would you allow, if women had a car, would you allow them to park in the garage?
Of course. And I had to be insured that way. I mean, it's a big process. But also, most women don't have vehicles. They're operating on bikes, which I have. They have right on the bus route. It's not like they all have cars. You know?
Okay. Any other questions for the applicant right now?
Anything you want to add?
Well, I didn't know if I should do rebuttals.
Yeah, that's what this time is for.
Oh, I'm sorry. Can I start that then?
Sure.
So, like I said initially, they had stated that, oh, I'm so sorry. Let me try to find where I'm at. There will be 8 to 10 women at Connecting Links. Like my son said and my daughter said, I took things pretty personal. So, like, as far as the opposition letters, that kind of thing, I reviewed them thoroughly. And so I want to let you guys know that I read over all of them, and I formulated what I would do because of that. So there'll be 8 to 10 women at Connecting Links Transitional Living. If one is worried about overcrowding and health concerns, quite frankly, I'm surprised the health department, fire department would allow. There's no question that this would have a negative impact on our way of life, safety, traffic, and lighting. And I said, I have agreed to max out at 6 women. It's also noted by George from the Planning Commission, the application, and I did the site plans. From the architect shows 4 additional parking plans. In addition to our double stall garage, there'll be a total of 4 parking places in the back of the house, which creates enough for the 6 women, and most don't have their own car. Safety issues, we're minimizing the maximum of 6 to alleviate any safety concerns for the neighbors. Something about not having enough space I had heard. We have like 3,500 square feet. We finished the attic. We have 800 square feet in the attic. We have a lot of room. 6, you could put more in. The applicant has no previous experience with this type of facility, will not have on-site 24/7 supervision. I think we've reviewed that. I do. And, no, I don't have a transitional living experience, but I have 16 years experience working with this population, and I can do this. And I've been doing it for 5 months. The police haven't been called one time to the facility. Would you care for a facility like that in your neighborhood? Would Tina Arciaga want this next to her door? Yeah, I would. I would. There is no direct correlation with this type of permit negatively or adversely affecting property values or the historical value of the home. It's not decreasing the property value. There's no statistical research finding that's significant that correlates this negatively impacting the property values. In fact, I would want this in my neighborhood because these women are going to be functioning as normal neighbors. Everyone claims to support the opportunity for these women until it comes to their neighborhood. It would be helpful if we started supporting these women that have paid their debt to society for their previous mistakes they've made. They have paid their debt. It's the same as living next door to an ex-convict without knowing that they ever committed any crimes. There's 10 registered sex offenders in the Woods Park area. Right now, I looked it up. That I'm trying to approve a permit for a correctional facility. This isn't a correctional facility. They're located at West Van Dorn, West O Street, Highway 2. I'm not a correctional facility. I'm not trying to rezone, I'm re-permitting. Late at night, there'll be horns honking, people coming over causing commotion at night. Will the applicant ensure that there'll be no drugs or alcohol? Originally, I started with 8 to 10 women, maxed out at 6 to appease the traffic, lighting, safety, sense of community. I did not create the sliding pay scale for this endeavor. If it were less, I'd still be thriving forward. Regarding the trespassing issue, we were told to put up side cameras. We agreed to do that. I got with the historical people to see if I could put up a fence, and I had to take pictures. We put up a fence to help out. You have these measures in place. They're working. We have hired LMHPs. I've been open since January. I went to Woods Park, I think, in February. There has been nothing that's happened. There was one incident about the trespassing, or they got the wrong porch, took care of it. Being compared to other facilities that are permitted legally, I read something that some of the facilities, I don't know, like a opposition letter, there's something on 13th Street, and they're trying to hide it. Yeah, there's places out there that are not, they go to the front door and they say, hey, how many people you got living here? Oh, we don't have more than 3 unrelated. They know what to say. I have my master's. I'm not going to play that game. Ethically, I would lose my license if I got in trouble. I'm not going to take that risk. So I just feel like I am doing it the right way, that I shouldn't be punished or reprimanded because of it. This is my right to do this, and it's for a good cause, Let's see. Over the years, let's see here, this is just a cash cow for Tina. If we're indeed a cash cow, I wouldn't have gone through the length to make this a legal and inclusive process for all. I obtained my master's degree to be a therapist. Most therapists and counselors don't make much money. It's a passion. The introduction of an AIF operated by an absentee landlord who has consistently demonstrated not sharing the values, interests, and incentives in families in this neighborhood. They may be referring to the house across the street where that landlord has lived in California for 20 years. That is an absentee landlord. I, however, live here in Lincoln. I will be at this house daily, as I always am, with the staff. I share the same values and interests of the families in this neighborhood. We have put $50,000 in this property, upgrading in 2004. We put double-stall garage, central air, new roof, new gutters, new windows before this even happened in 2019. And so for these concerns, we will reinvest money back to preserve the historical nature of this house. Things disappear, panhandling at any time of the day. To me, that's like the stigma. These women may have committed crimes under the influence of substances. They are sober now. They've paid their debt. It is not, I just had a couple things to say about the fence. I talked about that. I didn't take 3 days to fix that window glass. We didn't have the knifing incident. Every time somebody called, Maureen has my number. She calls me when things happen. And I always responded. If I didn't respond, she didn't call me. The house across the street just sold. It was up for $299. It sold like I don't know what it sold for, but it sold with the 3-zone sign in the yard. So the property value didn't seem to be a problem there. The women don't pay the rent. We're not sliding under the radar. Jane kind of alluded to people, sliding under the radar or this or that or other facilities. That's not me. That's not me. I'm legal. I'm doing it right. I just want to reflect that I am legally permitting the property. I ethically have to do things the right way or I'm going to lose my degree. I do have supervision in the overnight hours. I will have that when I have the 6. I'm going to have a house manager. The Ring cameras are intact. Nobody's moving the cameras around. And I just wanted to end with something that just kind of, somebody wrote this. Granting the permit would sow divisiveness instead of unity, would foster contempt instead of community, and would deintegrate our collective efforts to establish a neighborhood that attracts families, supports responsible home ownership. And to me, I say, this grant will harmonize the community instead of sow divisiveness. It will help build this esteem for these women. The permit will help flourish, integrate, link, strengthen, expand, and provide the solidarity for our community. I just hope that you'll consider this application.
Any further questions for Tina?
Thank you.
Thank you.
Thank you.
I would move that we close the public hearing.
Second.
Jerry?
Okay. I believe Commissioner Scheer left. I did not see that, I guess.
You left around 7:20.
Okay, thank you. Alpadre,
Yes.
Campbell,
Yes.
Edgerton,
Yes.
Joy,
Yes.
Core.
Yes.
Motion carried, 5-0.
I'd entertain a motion.
I would make a motion to deny this special report at this time.
Does anyone want a second just for conversation?
Guys?
I'll second just for conversation. We can go down that road.
My reason for this is I think that Tom and Tina have put together a very good program. My biggest concern is we do not have parameters in place. That once this is granted a special permit, it always will have that special permit. And even though I think they would be very good operators at this point in time, I'm uncomfortable moving this forward until we can get staff to put together either a task force or some a committee to come up with some guidelines for this. And then I would urge them to come back and ask for that special report. But I think there should either be a period of time that there's an automatic review, like a liquor license on the special permit, or there should be some reports that have to be done and turned in, including getting how many police calls have come to that residence, or other things like that that may be valid to be included to determine whether you're going to maintain a special permit. So that's the only reason I am moving to deny, is I just don't think we have the parameters with which to handle these properly. I believe these are very, very much needed facilities, and I just want to make sure that we end up doing it right.
The reason why I wouldn't provide a second for that motion was I'd prefer, if that's the route that we want to take, to table it versus putting a vote in record.
Okay?
That's my opinion.
I don't think
So now what is there a law position on that versus, do we have a quorum?
Yeah.
We do.
Okay, okay, just making sure.
Or you do.
David Carey with the Planning Department. I'll start and I'll have Tim come up as well, but I think I just would like to strongly recommend against the tabling concept, just because you are in a position of needing to act on this based on the regulations that are on the books today. That is when this was applied for. So you can certainly vote it down. I'm not recommending one way or the other. I'm just saying that the tabling idea is not going to work in a legal sense. So I would just recommend that, and I'll have Tim if he wants to add to that at all.
If whatever action we take today, they would have to resubmit a whole new special permit and pay the fees all over again if they were denied and came back through.
If there was a denial, and there was a desire for the operator to try to do something differently, yes, there would be another process to take.
Can we postpone this?
I don't think you're in a position to postpone it in an indefinite manner for the reason of waiting for other regulations to come forward.
Right. But what if we want to defer for another reason?
If you want to defer for another reason, I have no objection to that. If it's I need more information or something like that, that might be grounds. The tabling issue, I think, is problematic because I think the tabling in order to wait for regulations to come along would be an inappropriate thing. The Supreme Court has spoken on that. They will not allow you to table something and allow a set of regulations to come back, to catch up and pass it and then subject an application to a
Right,
new
that
set
makes
of
sense.
regulations. That's not a,
That's
that's
rude.
contrary to people's due process rights to
Right.
do something like that.
Mhm.
So that would be why I would be opposed to it. I would advise you against tabling it. As Dave didn't mention one other thing. The applicant, if this is denied at the Planning Commission, they still have both sides have the opportunity to appeal this to the City Council. And so that tonight is not necessarily well, it's not the last time we're going to hear about this. I'll make that statement with quite a bit of confidence. So, but I think those are the perspectives. Tracy, I think you had a question about deferring it for another issue, another
So if
reason
we
maybe.
deferred it because we wanted to gain information on other items, not changing the rules.
It's probably possible to do it that way. I think you should specify what those items are and then wait to see what what your fellow commissioners would say to that.
So, on the motion that's on the table, from what we've heard, and unfortunately or fortunately, land use is what we're tagged with. And I respect all of the people that took the time to talk about this, no different than all the other activities that we've heard today. It appears, though, to meet the regulations from what we've seen and heard, with conditional approvals and with health and safety and welfare from building permit standards. So I will vote against denial based on that.
I'm very torn, and I certainly empathize with both sides and the information that's been presented. I think that we all have had a lot of different thoughts as we've reviewed this information, both before the hearing and during the conversation. I think it was a particularly apt point that the permit process for this special permit was put into place in 2005, and the transitional housing program was announced in 2015, which would perhaps bring in quite a bit more interest in providing transitional housing in the state of Nebraska. And that special permit process hasn't been revisited since that has come into play. That being said, this is still the first permit that has ever come to our attention. And we are I think that the Arciaga permit has certainly qualified for everything. There are no concerns from my perspective in terms of that they have met their requirements, especially with regard to land use. I am troubled by the lack of licensing requirements generally, and I also don't quite understand why an AIF would be considered differently from restrictions that are in place with regard to locations of domestic shelters and group homes. That being said, I will vote against the current motion.
To piggyback off of what Commissioner Joy and Edgerton stated, I will also be voting in denial of the current motion. I do believe that they have met the requirements, and if we're looking at land use, then they have met that.
I agree that this is a difficult situation. We kind of have two polar opposites here, and so it's kind of hard to figure out what's going on in this situation. I still am uncomfortable with how, with this classification, I guess, for a better word. I don't understand, I guess, for lack of way to say this, I don't understand why this is an AIF and not something different. Like a residential health facility or something like that. And because I am still grappling with that, I am going to abstain from voting for that reason. Jerry?
Okay. This is for the denial of special permit 2005. Alpadre?
No.
Edgerton?
No.
I'm sorry, Campbell.
Yes.
Edgerton?
No.
Okay, Joy
No.
and Core.
Abstain.
Okay, motion failed.
Anyone want to make another motion?
I'll make a motion for approval.
Second, Albadri.
Any further discussion?
No.
Jerry?
Okay, this would be for the conditional approval of special permit 20005. Albadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
Core.
Abstain.
Okay, motion failed due to lack of 5-0 vote, majority vote.
So we get to do it again.
David Carey, the Planning Department. So as has happened in some issues in the past, we as a body need 5 votes one way or another to move this forward. This item did not receive the 5 votes, so the public hearing is closed. So the public hearing will not be continued, but the item will be on the next agenda for another vote, at which time we would expect to have more than just 5 members here. So we will have this item for vote only at the next hearing. So with that,
Okay, so, for anyone wishing to speak on an item not on the agenda, this has been suspended until further notice, and I would call for a motion.
Motion to adjourn.
Second.
Jerry?
Okay, I'm sorry, I missed the motion, or who's moved it?
Joy and Edgerton.
Okay, thank you.
Sorry, I should have said my name.
No,
I
you're fine.
apologize.
Okay, Albadre?
Yes.
Campbell?
Yes.
Edgerton?
Yes.
Joy?
Yes.
And Core.
Yes.
Motion carried 5-0.
We are adjourned.